this morning that you intend to tender. Do we need to circle back to the issue from when we broke yesterday?
So the issue when we broke yesterday dealt with my line of question that had to do with a preliminary hearing for Mr. Sledge, and the relevance of that particular one. At the time that we broke, I believe that he was referencing the hearing shortly after his July arrest. We will move on past that particular one because the hearing and the phone call that has pertinent information that I am attempting to elicit testimony regarding happened in November of 2015, so I can address that because the issue will still be there. So the issue is whether or not testimony regarding what happened at the preliminary hearing, whether it was July or November, is relevant. The reason that the testimony regarding what happened at the November hearing is relevant is that in a conversation that Mr. Sledge had on November 19th, 2015, that was served, and that the court said he could not introduce unless he testified inconsistently. Mr. Sledge said specifically, after talking about getting money for a bond, which is not what we want to get into, at 3 minutes and 18 seconds into the phone call, he says, "Them folks threw Shannon under the bus, man. That and Summer D ain't right either, boy." And the girl said, "You're lying." And Sledge says, "Man, he told on that boy, man." The young person with whom he is speaking says, he said, "2 people wrote a statement on you." She's talking about the detective, I believe. And the girl says, "Woody." And Mr. Sledge says, "Nobody wrote a statement on me. One dude wrote a number." And the girl says, one witness saw you there. He says, he being Mr. Sledge says, it's the number 2 witness, and Woody and Lil D never said nothing about me. They said it about Shannon. That's why they dismissed it. We're not trying to get that part in. The girl says, whoever they came forward October 19th, Sledge says, them folks, he references why it took 9.5 months to come forward, whatever, and the judge, Judge Atkinson, he talks a little about him. We're not getting into that. Mr. Sledge then says the first case got switched, but the body didn't. Basically, he's saying that the judge found no probable cause for him on the murder of Mr. Thomas. The girl references the fact that they've been indicted. They talk about him being able to dismiss it. The young woman asked, what did they say about Shannon and 30 Deep? 30 Deep, meaning Mr. Garlington. Mr. Sledge says, man, 30 Deep brought his name up. Booty brought his name up. I knew YSL D. And I put 2 and 2 together. He references something about Shannon's lawyer. And the girl said, someone from YSL said, Monk, he said that. I was telling OG, he said either D or DK. He then says, I'm looking for the literal quote, but I'm going to summarize it knows that it's Lil D. They didn't call his name, they called him witness number 2. He knows it's Lil D because that witness told them about all of us meeting up at the condo after, not his words, but he's saying after Donna and Thomas's murder. He told them about all of us meeting there. The only person that could have done that was Lil D. On the stand, while Mr. Sledge is talking, he says, well, the court remembers that he referenced going to Mr. Williams' condo and only seeing Mr. Williams and Bielby, and all that was happening was that they were working on the song Da Vinci. And then they left to go to another condo so Mr. Williams could grab some jewelry. And then maybe while he was there, he got a call from Mr. Copeland. Mr. Copeland came over, he can't remember, but he doesn't remember who all was there or what, who all might have been there. But there really wasn't a meeting up there. And on the phone call, the reason that he surmises that it was Quindarius Zachary who told police the information they were able to share at his preliminary hearing is because the details that Quindarius Zachary gave were details that only Quindarius Zachary would have known, because drawing the inference from what he is saying, Quindarius Zachary was there, he was there, the rest of them were there. Nobody else would have known, they were all there, but Quindarius Zachary. So him saying, hearing what he heard at his preliminary hearing is what led him to surmise that it was Quindarius Zachary who had told. And Quindarius Zachary had not told him, Antonio Sledge, anything about what he told the police. He just told the police. And then the police, trying to protect Quindarius Zachary, uses witness number 2. So those links are necessary in order for me to be able to put before the jury the fact that, one, Mr. Sledge and other people that they will later hear about were in fact meeting up. They did meet up at the condo, just like Mr. Sledge said in his factual acknowledgments. And what he is saying on the stand now is wholly different than what he said when he took his plea back in 2022. So it's relevant. I mean, obviously the bar for relevance is low. This is very relevant. It took a few steps to get to why, but that is why I was saying I was laying the foundation for more evidence that was going to come in.
Okay, well, I think that it might be relevant if you can find me like his actual statements where he is saying essentially that had to be Lil D because he told about us meeting up at the condo, as if, he is saying, I know from my own knowledge being there that this could only have been him because he would be the only other person who knows about it. That part might be relevant because it is inconsistent with what he said on the stand about the only people I knew at the condo were maybe Jeffrey and the people who came with me, which was my baby's mother and my baby. But all of getting it to that,
I don't need all of it. When I said what happened at prelim, I did not want, and it was an inartful way to elicit that, and I can be more precise. I asked the court for permission so that the court knows exactly what I'm talking about, to just play that snippet. We have a jail call pulled up, and we have a timestamp as well, that we can play for the court, if the court will allow us to play for the court.
I'll listen.
And as well, Mr. Sledge denied having any knowledge of any members of YSL speaking to the police. That is something else that he talked about yesterday. That was a question I think that I asked him, not as specific as the stuff that I just said, but.
So Tommy will
in this part that the court is gonna hear, he says he put it together because that witness that they did not name was buying guns for people within YSL. Quindarius Zachary, we all know, is the one who was straw purchasing for them. And in fact, he was sentenced federally for straw purchasing. He was the one that purchased the gun. I think one of the guns that the witness had in the video that the jury has already seen. And Mr. Sledge in this jail call says he knew it was Quindarius Zachary because they referenced that that witness was buying guns for YSL. So we're going to start at 3 minutes
Your Honor.
and 12. We're going to start.
Well,
Before you play it, I'll hear what he has to say,
Thank you,
but
Your
finish what you're saying.
We're going to start the one segment, the first segment of this jail call from November 19th, 2015. And we're going to play is 3 minutes and 12 seconds in, and then we're going to stop it and play other questions. And I'll cede the floor to Mr. Sharp before we start that process.
Okay, and do I have a transcript of these calls somewhere? I do, right? Or no?
no.
Okay, all right, yes, sir.
Respectfully, I'm lost. The putting things together from what was said at a prelim, that was said about my client at a prelim, all of that it's preposterous to me that the state would be attempting to get into any of this. And this seems to be becoming very complicated for something that should be very simple. There's no putting it together. There's no, I realize little D told. There's none of that, because I'm going to tell, I'm putting everyone on notice right now. I don't know what Mr. Zachary is going to do, but if there is elicited testimony about my client, stuff about what Mr. Zachary said about my client or to the police or at my client's prelim or at a prelim in general, I am moving for a mistrial. I am of the opinion that the state will have goaded me. I'm putting them on notice. Don't do that. And they're trying to backdoor testimony because they don't know if Mr. Zachary is going to testify or not. Now, if it's just a matter, Mr. Sledge, you said you don't remember who was at the condo. Didn't you say to your girlfriend or whatever she was, wife, fiance, that Mr. Zachary was at the condo on the night of January 10th, 2015? Didn't you tell her that on a jail call? And then if he denies it, then we play the little snippet where he says that one thing, then I guess that makes sense. But I don't know why we're getting into, I figured out he was the witness. This is what he said. This is what he said about me. This is what he said about Shannon. He must have known these details. Why are we doing this?
May I respond, Your Honor?
Yeah.
Two things. One, this notion of goading into a mistrial and don't do something is not anything that I can respond to, because that is wholly wrong. The fact is, every defendant knows that the state has a good faith basis for putting forth the knowledge that Mr. Sledge had regarding what Mr. Zachary said. Mr. Sharp's words to the court seem to suggest that for some reason he believes Mr. Zachary, we won't be able to procure him. He's under subpoena. They know that he is, and we have served him, and we have every intention that he will be here. He's not, he's out of the hospital, I'll put it that way. We have the statement that Mr. Zachary has given to the police. We have served it. They know what he said. Mr. Sharp is well aware what Mr. Zachary said about his client. The reason that what Mr. Sledge tells his girlfriend is relevant, and the reason that there are those steps that have to be taken, is that Mr. Sledge, as I stated earlier, surmises, he realizes who it is because of the facts that Mr. Zachary shared with police, that police then told about under the label of witness number 2 at the preliminary hearing. Mr. Sledge doesn't say Zachary lied. Mr. Sledge was there. Mr. Sledge has actually said he was there. Mr. Sledge is the one that gave the state, and unfortunately, we may have to impeach him on that with other evidence. He's the one that gave us the statement, we met up and Thug gave us money to lay low. All of that aside, I have no words for the whole voting stuff because that's not what we're doing. We would object if Mr. Short even makes
Okay,
one.
let's just get to what it is that he, and I don't know why the part about guns is relevant. If you are telling me that he essentially says, I know that's little D because of what he said about us meeting up that only he could have said. That's the part I'd like to hear. And that's the part that might be admissible as a prior inconsistent statement. So let's hear that part.
Right. Move to the part where he said he knew it was little G.
And I guess the guns part, I mean, I guess he did say he never sold. He doesn't know if Zachary's selling anybody guns. So, you know, I guess that could be a second prior inconsistent statement. Yes.
I don't know. I'm not in Mr. Sledge's mind. I don't know his reasons for it, but that was an inartful question from the state because I don't think the truth is that Mr. Zachary has sold guns to different alleged members of YSL. I think the allegation is that Mr. Zachary was a straw purchaser. I wouldn't call that selling a gun.
Yeah. So, I mean, it may be that if you want to get that in, you need to ask different, more specific questions. But let me hear the part about the meeting up,
Yes.
whatever he says about that.
We're going to start at 1321. Is it playing? We're starting a little bit before.
About the whole situation, I really they said Noah was there. You know,
Vera said he went well, you know what's going on.
Yeah, you know what I'm saying? The whole situation, whoever witness number one is, they thought Noah he say, you remember when we talked on the phone, he's like, boy, you didn't know nothing about it, you was in the blind. They told them folks this. After Lud got killed, all of us met up together and went down over house. Them made that word. That's how you know it's deep.
So when y'all ready to what Shannon said.
But that, cause they sent me back before Shannon, cause Shannon was still up, so they.
So the old boy's house that we believe he is talking about is Jeffrey Williams' house. That is the only house that he has testified that he went to. We have Mr. Zachary saying they met up at Jeffrey Williams' house. We have other people. It's not like we do not have a good faith basis for knowing and realizing that's who they're talking about because Mr. Copeland,
Anyway, that's witness one, not witness two.
my apologies.
Why is my client's name coming up in that conversation? There's no inconsistent statement that would lead to admissibility.
Why is that in the courtroom anyway? Is that somebody, what? Is that somebody who has a Rule 22?
Go back up.
So
The second part, Judge, just to orient the court, there is at 5, we wanted to play the part that the court asked about what he said about the witness, but to orient the court as to the question posed just now, we would need to go to 557 where Mr. Sledge references it being Lil D. So if we could,
Hang on just a minute, because we got to deal with this one first. So I think I mean, it sounds to me like they're saying, you know, here's what happened and we know X, Y, and Z because we were there. And so I guess the reference to Shannon is because he knows Shannon was there and he has said on the stand, I didn't know anybody other than
No.
Jeffrey and, okay, what?
I think, I don't have a transcript, but what I heard that little snippet to say is little D, and of course we have two little Ds. I'm going to assume for the purposes of this statement that he's talking about Mr. Zachary, was saying things at the condo and putting Shannon there, meaning, and he also references Nard, who's Demise McMullen, there being the murder scene.
There being the murder scene?
Yes.
Honest to God, a transcript would really help because it's hard to tell what everybody's saying.
our transcript is of the quality. and
Okay, but you know, y'all can retranscribe little snippets. Somebody who knows what the content is, you know, like what is being talked about. It's not, you know, it's not that hard to do.
We have not a formal transcript. We have what is being talked about in timestamp form that we can give to the court.
Okay, so is it your understanding that they're talking about the murder scene or they're talking about the condo right there, what we just heard?
They were talking about the condo when he said that they met up at old boy's house.
All right, if we don't even
We
know
st-
what's
we-
being said, then
We
I
do
don't
know
know.
what
Mistrial
is
waiting
being
to
said,
happen.
Your Honor. It is
What?
not a
This is a mistrial waiting to happen.
Your Honor, if I may.
Particularly. Go ahead.
Judge, we were playing the clip. We put a portion in about Nard. We're not trying to get in anything about the murder scene or Nard. We are not going to cause a mistrial. We are giving to the court the portions of the call that we wish to play. I'm being specific about the portion because we started the clip a second before where someone was able to pick up Nard and make a whole separate argument about the murder scene does not take away the importance of the portion we're presenting to the court that we need to play, which is that I know it's Lil D because he told the police about us all meeting up at old boy's house after Nut got killed.
But now we gotta pay
So-
for your mistake.
Nobody is trying to put in anything about the murder scene. Nobody is trying to put in anything about
You should have played it at the right
That.
time.
So let me hear the part you actually want to play.
Exactly.
Just the part you want to play.
Oh, Lord.
So, Your Honor,
It's too early for this.
is it at
Y'all
this
know I
time
know-
that we're allowed to play the portion I told you that gave some context to
Yeah,
the,
right here.
we had
My coffee, y'all.
a specific part the court just asked us to play
How my kids
that we played.
school.
There is a part before that we have said
Morning.
I don't
multiple.
want the part before it. I want to hear what it exactly and only what you want to play before the jury, because that's what I need to rule.
Yes, Your Honor.
Nobody can hear it. Okay, they're just trying to figure out where to start. Why do we have food in court again? I didn't change that rule. No food in court. Somebody please retrieve the banana and take it back to the back. Well, you can't have food in court either. We're in court right now. We're not on a recess. We're not at lunch. Put it back in your briefcase. That's fine. I don't care about a covered drink. That's fine. It's food.
This number one is this I know it deep. Cause he say, you remember when we talked on the phone, he's like, well, you ain't know nothing about it. You was in the blind.
Mm-hmm.
They told them folks deep. After Lud got killed, all of them met up together and went down over out. Them made that word. That's how you know it's deep.
That's, and Your Honor, that's the end of that portion.
Okay. If there is an inconsistent statement, this is where we're at, as far as I can tell. Mr. Sledge testified that he couldn't exactly remember who was at the condo. Okay. If there's an inconsistent statement that says D, which is of course complicated because there's two Ds, is at the condo that night, then it seems to me it would be easier and cleaner if we just had him refresh his recollection. But that's how I know he told. That is, why is that coming in?
Right. I'm not sure why that's relevant.
Judge, the reason that is relevant, it's two things I want to respond to. The notion about we don't know which one it is. He makes a distinction in
Let's
the
not worry
call.
about, we don't know which one it is.
Okay, so the reason that it is relevant is because we know, Mr. Sharp knows, everyone knows, that what Quindarius Zachary told the police is specific information that will be
Let's
presented.
get to, how about if you ask Mr. Sledge specifically on the stand, you said the only people you remembered were blah, blah. Didn't you tell whoever this is, your girlfriend, didn't y'all discuss the fact that he was also there or something to that effect? And then if he says no, then you confront him with this prior inconsistent statement, which he needs to listen to first without the jury hearing. And then he can say, oh yeah, actually I did. And if he still says, I don't know, then you can play that little part.
Also, Your Honor, we feel it is important that the jury hear what he says, because he said Lil D told on them folks. He told them folks. Earlier in the call, the portion we've not played, there's a distinction. I know I'll get there. The reason that is important is because he starts out talking about people telling. Yesterday, the court heard him say.
Yes, I don't want to go through all of that again. I can follow the argument, but he does not say told on us.
No, he says.
He
told
says
them folks.
told.
Them folks.
Yeah,
Yeah.
which doesn't mean, Lord have mercy. We heard Kenneth Copeland say, I told 100 different versions of things. Telling somebody something doesn't mean you're telling on them or you're ratting them out or anything. And I know the state want it to be that, but you don't necessarily get that from, if you have something that says XYZ told on us, then yeah.
Your Honor, if Ms. Hilton and I were the only two people in a room where I ate someone's crackers, and Ms. Hilton comes out and she tells my boss, Ms. Love ate those crackers. And then my boss announces to the world, Ms. Love, you are dismissed because you ate so-and-so's crackers. And I say, well, I know it was Ms. Hilton who told, because
yes, that is one version of how something like that could go down. But Ms. Hilton could also walk out and say, Ms. Love ate those crackers, and there weren't even any crackers in there to begin with, in which case she is not telling on you. So it is an argument, but it is not established just because you think that's what he means when he says that.
Your Honor, I understand the court's position, and I would just say that if the argument has been relevance, the very fact that we're here at the place where there is an argument that the court sees on either side makes it, to me, very apparent.
I
that-
said that you can get in the part about what I just, that little snippet you just played, if you confront him with it and he says, yeah, I totally still cannot remember him being there.
And just for the record, Your Honor, the evidence rules do not require that I play it for him before I impeach him with it. So in other words, he does not have to hear it. The rules, I will find it for the court. It's very specific.
Well,
That
if you can recall it to his attention specifically enough without him hearing it, fine, but he has to be confronted with the prior allegedly inconsistent statement and given an opportunity to explain it or deny it or whatever, and then it can come in.
And so telling him what he told her at this time on this call,
But you need to be careful about what you say when you are recalling that to his attention, because we do not need to get into this happened at a preliminary hearing, or you heard it from a police officer who was giving probable cause or anything like that. This is just, he somehow knows that this person has said that, and he's saying, oh yeah, it had to be him because he was there or whatever. Okay.
Your Honor, I want to make sure I stay within what the court is requiring that I do. So, Your Honor, the fact that Mr. Sledge hears a rendition of an account from a witness one that Mr. Sledge recognizes, in his opinion, came from Lil D. Does not the rendition?
What you claim to be trying to get in is that he said something to his girlfriend that makes it clear that he knew that Lil D was there.
When you say you're talking about Mr. Sledge saying something to me. What I'm trying to get in, Your Honor, is the fact that Mr. Sledge, in telling his girlfriend he knows Lil D was the one that told, knows it because he said he told police that we all met up at old boy's house after Nut was killed. That part, we all met up at old boy's house after Nut was killed, is the part that I'm talking about. And earlier in the call, and we don't even have to, I won't even touch the call before whatever break the court has, if it is not resolved, obviously. But earlier, he is talking about defendant Stillwell, and he is talking about at 5 minutes and.
This is the part we haven't gotten to yet.
Because
I'm willing to listen to that also. I'm just trying to resolve this one first.
Your Honor.
Yes, Your Honor.
The state began this whole discussion saying that they want to impeach Mr. Sledge with a prior statement because he said that he didn't recall who was there.
So
That's what this whole thing was about. Now we're talking about he told. And I'm going to go back to the same thing because I don't understand what's confusing about this. He was at the whole part about yesterday where Mr. Sledge said, no one told me what they told the police.
Right.
Mr. Sledge was at a prelim.
I know, which is why I'm saying she
agree.
can't get into that part.
But it's not the prelim itself. It's also clear that he got this information from the officer testifying at a prelim.
Right, which is not inconsistent with him saying, nobody talked to me about what they said to the police. I said that yesterday.
Okay, I got you.
I got you too. I mean, I understand what the issues are.
Well,
All right, so let's listen to the second one.
We're starting at 5 minutes and 58 seconds. There's a portion where if we don't clip it out, he's saying that they threw out his charges. We will not play that. We will not get into any of that. We will not get into what did they say about Shannon and 30D. We're not getting into that.
Go to the part you are.
It's about 3 seconds.
Okay.
You might have to go back. Go ahead. Can we join? Can we be allowed in Zoom? Here we go.
Because I put 2 and 2 together. Because Shannon lawyer,
So get with, when he said somebody from YSL, they said that, he said they saved Moon. He said they had another person they saved Moon. He said that, and I was telling OG, he said either D or DK. I was like, I don't think it's DK.
it's D, man, because they said,
Starting at
Shannon got a paid lawyer.
keep it
So
down.
Shannon lawyer like, yeah. So Shannon lawyer like, how could a person that they saying is buying guns from the YSL make a statement on? See, they were trying to hide these names, but he said that, and that's how I know it.
No.
Okay, we don't have a problem with that.
Okay, so I guess next issue real fast is the portions of the plea presentation that Ms. Love forwarded and Mr. Atkins forwarded this morning.
And there's one more as well.
All right, any issue with the parts that she intends to play? All right, well, she gives a description kind of, I don't know that we, as long as it's just walking through those factual assertions, I don't know that you need, I think you can probably tell from just the description of where she's picking up, what she's talking about, but what's the other portion?
No, not another portion
Oh,
of the video.
What, another
Issue.
thing to raise, okay.
Correct. So State's Exhibit 425Y, when we presented them on our, I think, admin day, I believe that the request was made to remove commentary, and there was a phone number on State's Exhibit 425Y that the court said the court did not find relevance, I think, in the post until it became apparent how it was relevant and so forth. Yesterday, when presented with State's 425Y with just the phone number and none of the context, the witness testified, I don't know what that was, but I'd like the court to see the full exhibit with all of it. So the first portion of this post, to make the record clear, this is a post with Mr. Sledge taking a selfie, literally looking up at the camera, holding his apparently recently born child in his arms. The first post by the real Toonk, which the witness has said was his name, says, "I woke up like this." And then the real Toonk tags AK2 Success and says, "My baby." Then the real Toonk says to AK2 Success, "Thank you, sis." And then Katini says, "Such a good father. Keep up the good work, brother," at YSL Toonk.
Okay.
Then the real, you can publish it, I need the record to reflect it. The real Toonk then says, at Kahenti, "Thanks, sis." And then he thanks someone else.
Okay.
after another person congratulates at YSL Toon, Pizzle Dope says, say slime, what's your math? Then the real Toon says, at Pizzle effing baby, what the move slime? And Pizzle Dope then says, trying to see now, send your number. And then the real Toon tags Pixel effing baby and gives his phone number.
Okay,
So the context is key.
okay.
So
Because because he said, I have no idea what any of my phone
Yes.
numbers were, and you need to establish that this phone number is clearly his phone number because he's the one sending it.
yes,
All right, there shouldn't be an issue with that now now he said he doesn't know his phone number. Anybody have an issue with that whole thing coming in? Or you could just try to refresh his recollection with it first.
That's what I was going to
I'll
suggest,
try.
Your Honor.
I'll try again.
Okay, and
I
then if
know I
that
did. I
still
did.
doesn't work,
And to be clear, we obviously did try to refresh his recollection with the phone number, but we'll see
Right.
if the context
okay.
further
Okay,
refreshes.
that should be fine. All right, have y'all had a chance to look at the portions of the,
They have the original, but I can
Mhm.
pass it over.
okay. Coming back to the factual assertions, plea colloquy.
I have not. I didn't even realize there was an email sent until
Okay,
just
well,
now. So if I could.
how far into, how much longer do you think you have with Mr. Sledge?
I expect it to be through probably within no under 2 hours, probably an hour
Okay,
and change.
so by lunchtime.
Yes.
All right, so maybe you'd be doing all of this before.
I started a
break
new
again,
poll. I
so
guess
we
me
need
and
to
Judge
go ahead
Whitaker
and
have
sort
the
it out
same
now.
question.
Y'all need what, 5 minutes?
And I can
I told y'all 3 hours meant 3 days.
Yeah, we'll recess and let y'all watch it.
Okay, good morning. Happy Friday, everybody. I am back. I got, thank y'all for letting me take the night off. I got so much rest last night. I feel so much better. And you know, we got to go live with Nick tonight at 6 on his YT. I will drop the link for you guys. But I want to say something about this phone number thing. I don't know my phone number from 2015. Let me think. I'm not sure. I've had my phone number for a very long time, but I don't know the year I got my phone number. I think I've had my phone number for about maybe 10 years. So maybe I did have it. I don't know. I do not know. Who knows their phone number from 2014? I mean, and I think that when cell phones started first becoming popular, especially when I was younger, when I was in college, I probably had 6 different phone numbers. I mean, the phone, yeah, before I was a lawyer and had a job and stuff, I had all kind of stuff going on with cell phones, prepaid phones, T-Mobile, the AT&T, on my parents' plan, all kind of stuff, like sharing phones with friend lines. I don't know my phone number, guys. I have one phone that I have right now that I don't know the number to. But anyways, good morning. Good morning to the chat. Yes, exactly. Like, come on now. I was gonna say something, but it's in a. I was gonna say something, but I'm not gonna say it. I'm gonna incriminate myself. Let's go, guys. Like the live. Thank you so much. Thank you for my mods that I got in here today. Thank you to my new members, the pink girls. Thank y'all for joining me today. Come on, guys. We got to get 1,000 people in here. We are at 632. That is amazing. I thank you guys so much. We're going to have a good time. At lunch, we're going to talk about what we were supposed to talk about yesterday, which is the Alford plea. We'll probably have some more stuff to talk about. We've been going back and forth about one sentence call for, I guess, 30 minutes. I was on this is funny to me because I honestly need to do a poll, guys. What do y'all think? What do y'all believe? This is what I'm saying. Is he messing up the plea? So we'll go over the plea again. And I mean, who is Zachary is the next? Oh yes, they sure did. Oh, I do not miss this. Okay, guys, thank you so much. Remember, as we get started, to be respectful of the chat. Respectful, everybody be respectful. Don't forget to use super chats. Guys, let's get some super chats in. I got some great content coming for you guys, and I need y'all to super chat me and help me stay encouraged. Because it's hard to do this and go to court and do work and answer the phone, but I think it's necessary. And I love the fact that shout out to all of my YouTube friends that are covering the case. I love Kat. She's so smart. She's smarter than me. Don't get it twisted. Shout out to Nick. Shout out to Seti. Shout out to Miss Sylvia. Shout out to everybody. And shout out to Cuff Boys. Y'all know I am a Cuff Boy fangirl. And of course, Thugger Daily. Shout out to all of them. I love them so much. And I am so thankful for them. But I appreciate I have one special thing that they don't have, and that is, well, I have two. I actually was a part of this nonsense, and I'm a lawyer. So I appreciate the fact of being able to give you guys a different perspective. So thank y'all, and thank them. Even though I think some of them, well, oh no, Nick is a lawyer, so I only have one thing. Dang. But I love y'all so much. Shout out to Cuff Mama. Fangirl. I'm a fangirl. Thank you. It's Cloud9. Thank you so much. Y'all, let me see. How much time do we have? Let me see. Because I saw something very interesting last night. Thank you. Happy Friday, Miss R. Thank you for joining us today. Thank you, guys. Benjamin, like I said, if you come on here, where's the case? You got to tell me. Where is the case at, Benjamin? Thank you. Thank you, SQL Knowledge. else. I'm trying to show y'all this clip. Let me see. Maybe I can just play it. Can y'all hear that? Her hearing is at noon. I do practice criminal law. How do you think I got involved in this? How do you think I got Mr. Copeland out of jail? Thank you for the super chat too, Miss J. Let me see if I can send this to myself. I can't get it to send to myself. Let's see if I can log on my Instagram on my computer. Y'all, I can't get it to send. I'm so sad. Oh, I got it. Where'd it go?
I shut them down. Because you guys seem to be getting along real well before that. I mean, I saw, how you guys were working together in the summer 2014.
Did it stop playing? Did y'all hear that?
Right. My hand was on the spot. I saw it. We are so together. I was like, I'm just asking again. So everybody been talking about, I'm gonna just be a man and answer myself. Right. It's crazy, man. Niggas know what has something to do with it. We just can't prove. Point blank period. I ain't no rat, I ain't telling no, I'm being real with y'all. I got how much I love nothing, man. You know what I'm saying? Like, that shit real fucked up, bro.
So, why did you suspect Young Thug when you went down to Miami? Because people told you, or did you have some beef with Young Thug at the time that kind of let you?
I ain't had no beef, bro. That shit was deeper than rap, man. I really feel as if that was jealous of the relationship. I shut the word. You know what I'm saying? You can tell us that in a relationship, man.
So did y'all hear that?
You guys seem to be getting.
Like, did y'all hear that? Did y'all understand what he said? I don't know how I feel about that. I don't know how I feel about that. It says, I know Thug has something to do with it, just can't prove it. We was close, but what happened in Nut is effed up. I don't like that. I don't like that. He's talking to the police. He is talking to the police. That was Rich Homie Quan telling the police, we know Thug had to do something to do with it, but we can't prove it. And their beef is deeper than rap, and it's effed up what happened tonight. So, and you guys know that he was on the witness list. He for sure, Rich Homie Quan was on the witness list. I don't like that. It doesn't mean anything. It's just, guys, stop talking to the police. I mean, I don't know. Unless he was I don't know. I say stop talking to the police. Because I know if he was then labeled a rat or a snitch, he'd be upset. I don't, Ari, and you must be joining us late because everybody knows we're talking about Rich Homie Quan. That's it. I'm not saying, as a lawyer, I'm not saying, oh, don't talk to the police if you're a victim or this, because that's not what I'm saying. But if you're in the streets and you don't want to get on the stand and you don't want to be labeled a rat or a snitch, just don't talk to the police. And like you said, don't talk on the jail phone, whoever said that. That's it. That's all I'm saying. Because, or even on social media, guys, you have to be so careful. So careful on Instagram, especially now. It's definitely the police he was talking to. Exactly. Why would you say I ain't no rat? You don't want to be labeled a rat, yet you're sitting talking to the police. That's exactly what I'm saying. Welcome in, everybody. Thank y'all for joining me. Share the live, like the live. Let me go on TikTok. Okay, let's see. This is a pretty long break. Let's see. I'm ready to see what's going on. Yes, they can bring up some of his statements, and it won't be considered hearsay because there are a few exceptions to hearsay. And one of the exceptions is if the witness is unavailable, and unavailability does include death. So it is possible. But with that being said, you leave it up to the jury on how they interpret that. That's a really good question. Thank you, K Bear's mama. Good morning, y'all. We almost got 700 people. Not dying declaration. So dying declaration is something said like if you get shot, if Sunshine shoots me and in the midst of me passing away, I say, Sunshine did it. That's a dying declaration. Good morning, everybody. Come on. Let's get going. Absolutely not. Hey guys, I'm right here. I'm not talking to y'all, but I'm right here. Thank you for the super chat. Thank you. We're going to have a great Friday, guys. Great Friday. Thank you for becoming a member. Thank you. Okay, guys. I am talking and answering questions. We are on a long break. I showed a clip of what is going on. I showed a clip of what we believe to be Rich Homie Quan talking to the police, saying that we know Thug did it, we just can't prove it. We talked about him being a witness and the possibility of his statement still coming in. It looks like we may be starting back. I was just trying to get my people from TikTok over, guys. They always ask me about what's going on. So I told them they need to come over and join on YT. So good morning. Good morning. Let's see how much time we got. We can talk about some hearsay exceptions. Hearsay exceptions. As soon as I start talking, I just don't want to, let's see. Oh, here we go. We'll talk about hearsay on the break.
I'm waiting for all of the attorneys to get back in. We've had
Good morning.
way more than a few seconds.
Good morning. Good morning. Do you guys want to watch this on the break? Let me know if you guys want to watch. I'll do a poll. Hey, y'all, Miss Sylvia. Hi, Miss Sylvia. Y'all, Miss Sylvia's on my TikTok.
This colloquy.
So we have, Your Honor, the state has now sent to counsel for the defendants and to the
Yes.
court, I believe you just, the edited version so that there's no starting, stopping, or muting. It has the portions we referenced that we intended to tender as either a prior inconsistent statement, contradiction. It has what we referenced.
Okay, well, I wasn't able to access it because I don't have the permissions, but I mean, I can tell what
Did you see that?
parts, I think. Is there an objection to that?
So, Your Honor, we have not reviewed the edited version. So because we
All
were,
right, well, I'm gonna assume that what Ms. Love says is in there and out is what's in there and what's out. So let's just take her at
Okay.
her word as an officer of the court.
okay.
And
We, as I understand it, the state's attempting to introduce this as prior inconsistent statements. My response would be twofold. First of all, I don't believe that they're inconsistent with the testimony. Secondly, to the extent they are inconsistent with the testimony, Ms. Love has already read the factual acknowledgements and confronted him with them during her direct, is my recollection.
she actually hasn't. She's gone through, I think, some of number one, but the ones that like 7, 8, 9, and 16, she hasn't read those out.
Okay, well, that, my recollection is, and I'm not
Have you,
saying I'm
Ms.
right.
Love?
No, I intentionally not.
Yeah, she hasn't.
Okay. Is the edited version, has the law and crime
Yes.
been taken out? Okay.
So this is just essentially going to be him swearing to tell the truth, identifying himself, and then it's going to be the factual acknowledgements that he says, no, these aren't true. And then the sentencing understandings or whatever that he says, I didn't understand any of that at the time. And then the bottom, that's where he says, I have read and carefully considered all of this, and I've made any changes I want to, and this is all true.
What it has is, in addition to that, so it has the very beginning where he raises his hand and swears to tell the truth.
Right, I said that.
And then from there, I asked him if he understands the charges. It's basically from there, I'm reading and asking whether he understands his charges, the sentence, and the special conditions of his sentence. And then I asked him whether his attorney has explained to him the maximum and minimum for these charges. I stopped right there so as not to put in the maximum and minimum for the charges. Then I pick up at
Your Honor.
asking,
Yeah.
Well,
I mean, it's essentially what you sent and described in the first email of this morning, right?
yes,
Okay.
yes.
in Your Honor, I just want to be clear, to the extent, and you haven't ruled yet, and to the extent that this is allowed in on cross-examination, the state is keeping out the maximum minimums. Gets a little complicated because we need to, through cross, talk about what he has over his head, his bias, his motivation to work with the state.
Okay, well, I don't think he's working with the state from his testimony, but
Well, he,
sure, you
on
can.
December
yeah.
28th of 2022.
Yep,
And at one point, and the state drafted this document, not us,
yep.
they said the state will be asking for the maximum. So at that point, the maximum, at least for the gun charge, is going to be revealed. I know that sometimes we don't like to say what charges carry that our clients are
Right.
facing, but the state said that they're going to ask for the maximum, and we need to articulate what the maximum is. I just wanted to be
All right.
clear.
That's y'all's choice.
Okay.
Okay. All right, so is there objection to the portions that Ms. Love is proposing to play?
We just have an objection to the extent that we don't feel that they are prior inconsistent
All right.
statements, but we're going to.
All right, well, I'm ruling that they are prior inconsistent statements. So this is in when tendered.
And Your Honor, I do want to make
clear so that there is no confusion for any record later on. The special conditions of his sentence are not portions that were asked about, but they are portions that give context to what he is saying he understands. So when I read the charges, for instance, his current charges, his negotiated sentence, and the special conditions that he shall abide by, all of that, it gives context to the fact that he said he didn't understand it. So I did not ask him, hey, is this a special condition? Is this a special condition? But I included that in there for context for the rest. So I need to be abundantly clear. What I am saying, I am playing is exactly what I have indicated in my email to the court and counsel. And the reasons for it have not changed, but I needed the court to hear that part.
All right, well, I mean, part of what he said yesterday that he didn't understand at the time he signed it was any violation of these provisions or any special condition will result in him being sentenced count 30, and the DA will recommend serve the maximum. So he's thank you for clarifying the record on that. All right. Okay, are we anything else before we get the jury in an hour after I told them to be here?
And good morning, Your Honor. Good morning, everyone.
Morning.
Your Honor, is the court stop the questioning of the interrogation by Detective Gaither of Mr. Sledge that we objected to when we left yesterday? I didn't understand the relevance, and then
I don't expect her to
Okay.
go back into that
Thank you.
because I ruled that to be irrelevant.
I don't have an additional part of that I'm trying to get into at this
Okay.
time. And if before I ventured into that, I would bring it to the court's attention, but I don't foresee it at this point.
Okay. All right, let's get the witness in and then we'll get the jury in.
And Your Honor, I believe that Mr. Wright may have apprised the court. He is in Coweta County.
He did not apprise the court of anything. And
Well, he
in
did-
fact, I told him and he assured me that he would be here
There's
through
a good part.
duration.
There's a good part. There's a good part. He has standing
Oh,
counsel
okay.
that he has. I should have started with
Hello,
that.
you should have.
That he has, I apologize, that he has, and Mr. Sledge has agreed and okayed.
All right. All right. And tell me your name, ma'am. Thank you for being here.
Thank you, Judge.
And I shouldn't say he hasn't apprised the court because he probably apprised one of my staff. I just haven't had anything forwarded to me. So, okay, but as long as Mr. Sledge has somebody here to represent him, that's fine. All right, we'll go ahead and get the jury, please. You can come on up and take a seat. Thank you.
I'll
Good
see y'all.
morning, ladies and gentlemen. Thank you for your patience this morning.
I asked what's going.
We started before y'all again, but we weren't able to get through everything. So that's just, how it happens in trials sometimes, is we have to deal with issues that require y'all to be patient. So thank you for continuing to be patient. And we're ready to continue now with Mr. Sledge's testimony. Ms. Love, go ahead.
Thank you, Your Honor. And good morning, Mr. Sledge.
Good morning.
Mr. Sledge, yesterday I showed you an exhibit, 425Y, to see if it refreshed your recollection. I'm going to show you what I will label as 425 Yankee Alpha and see if this exhibit refreshes your recollection regarding your phone number back in December of 2014 and in 2015. Okay?
Yes.
May I approach?
You may.
And don't read it out loud, but is the photograph depicted in 425 Yankee Alpha the same photograph that was depicted in the exhibit you saw yesterday?
Yes.
And is that you and your child in that photograph?
Yes.
Do you recall how old your child was in that photograph, approximately?
No, I believe just born. I don't.
He was just born?
Yes, I don't exactly know how old he was on that photo.
That's fair. When was that baby born?
Yes.
Okay. And based on what you are reading,
Try that other mic, maybe. Which I know has also got its own problems, but.
do you recall making the posts that you see in the sidelines of this photograph?
I thought, y'all, correct me if I'm wrong,
My name right
but
now.
didn't yesterday,
Well,
am I
that's
wrong? But didn't she
what
say
I'm saying.
one last question yesterday?
Is this a post that was on your Instagram page?
Yes.
Does this post refresh your memory about what your phone number was?
Yeah, it looked like something I wrote.
Does it look like a fair and accurate copy of what you wrote and posted on your Instagram page?
Yes.
Are you able to now tell the jury what your phone number was?
It say 446628935.
404
Yes.
662
8935.
8935. And was
Yes.
that your phone number?
I guess I don't remember the look, but I see it on the photo. It said I gave it to somebody, but for my personal knowledge, I don't remember. But from the photo, it's saying it's my number because I sent it to whoever that was.
Your Honor, given that, and thank you, Mr. Sledge. Given that Mr. Sledge does not recall the state tenders State's Exhibit 425 Yankee Alpha as a past recollection recorded.
All right, it's admitted.
Thank you. Your Honor, permission to.
You may.
And Your Honor, there is also. Thank you, Judge. Could you zoom in? All right. Mr. Sledge, would you read the first post that you made?
It said I woke up like this.
And then what's the next one?
My baby.
And are you responding to someone, tagging someone, saying that?
Yeah, I said, it said, thank you, sis.
All right. And is that at K2 Success that you're telling that it's your baby?
Yeah, it do. It say, thank you, sis.
All right. And what's the next line?
Such a good father. Keep up the good work, bro.
And then who is that person talking?
It said, thank you, sis.
Is that person writing to @YSL_Tunk?
Yes,
And is that Kahenti, Kahenti, that made that post?
yes,
In response, do you then tell @KAHENTI, thanks, sis?
yes,
And then do you tell someone else, thank you?
yes,
Does MDBNELL congratulate @YSL_Tunk?
yes,
After that, does Pizzle.dope ask, say slime, what's your math?
that's a number thing. I don't know. I see the pound sign number for a number
Do
on
you
my
see?
side.
Okay.
If you pay,
Right here, do you see say slime, what's your math?
oh, okay. I see it on now, but it don't show right here.
You don't see say slime, what's your math?
Oh, okay, right there. Okay.
Okay,
I was looking right there.
that's okay. And then, do you respond to @pixel_baby, what's the move, slime?
Yes,
And then does Pixel.dope respond, trying to see now, send your number? They
Yes.
use a hashtag.
yes,
And then do you respond to @pixel_baby 404-662-8935?
yes, but yes, go ahead. Yes, I respond to that.
You're able to say
No,
whatever you need to
go.
explain.
I respond to that.
Okay. And was this post made around the time that your child was born?
Yes.
All right. Now, can you tell us when your child was born?
I just remember December, around December or something.
December, what year?
Thank you for this super
2014,
chat, Katie.
Thank you. Yesterday, we talked about what happened on January the 10th of 2015. Has any part of what you told the jury yesterday changed regarding what you recall happening January 10th,
At Kyrie, what's the
2015, after
T?
you learned about the murder of Donovan Thomas?
You gotta refresh my
I
memory.
mean,
don't
not
remember.
Kyrie. Cherie Moore.
Do you remember what happened after
Cherie
you learned about the
Monet.
murder of Donovan Thomas?
What's the
No, could
T?
you refresh my memory?
So is it your testimony? You do not remember what you told the jury yesterday?
I'm not saying that. I'm just saying I don't remember right now. If you could show me,
Thank
then
you.
I don't remember right now.
Thank you, Tarsha.
Did you testify yesterday that you got a call around 10-something PM, or you got a DM
Yes,
that indicated you and someone else were responsible for the murder of Donovan Thomas?
yes.
Do you now remember what you did after you got that DM?
No, I don't think I said. I remember saying that I went to Mr. Jeffrey's house.
And do you remember what you said or who you said was at Mr. Jeffrey's house?
Yeah, whoever. I don't know if he's the cameraman or he just do the videos. I'm not for sure about that.
All right. And is it still your recollection that only Mr. Bean, you, your child's mother, your child are the people that you recall being at that house on 10th Street?
I told you it was other people there, but I don't know the other people.
Did you also testify that none of the defendants in this courtroom were there?
I said, I don't remember seeing none of them. Now, that's what I said.
And thank you for clarifying. You said that yesterday. Is that still your memory today?
If you have anything to refresh my memory, Ms. Love, you can show me and then.
I appreciate that.
But I don't remember.
Okay, so that's still your memory today.
Yeah, that's my memory today. I don't remember.
And what about when you went to Mr. Williams' second residence? Today, do you have any further memory about who all was at that residence?
No, if you have anything that can refresh my memory.
Thank
can
you
show
so
it to me,
much,
but I
Katie.
don't remember.
And do you not remember any of the defendants in the courtroom here being at that residence?
I don't remember.
Objection asked and answered.
Okay. Do you remember being at Rice Street in November of 2015?
November, yes.
And while you were at Rice Street in November of 2015, do you remember calling and speaking with your child's mother at various times?
I talked to her a lot of times, so you have to refresh my memory.
Would showing you a rough transcript of that call refresh your memory about what was said during, or let me ask you this, do you recall
Thank you for the
talking to
super
your
chat.
child's mother
Guys, let's put in the chat.
on
Who do you think is winning?
November 19th, 2015 at 8:03 p.m.?
I don't remember the dates, Ms. Love. I talk to her most every day, so I don't remember the exact dates.
Would showing you a rough transcript of a call refresh your memory?
Maybe if you show it to me, yeah.
All right. Your Honor, we will label this states 448 Yankee, and it will not be for the purposes of admitting for the jury, just to refresh his recollection. And Your Honor, yes, I was going to ask if the defense could look at it first. Do we have another? You got it? Yes. You want to finish?
What y'all think they about to what y'all think they talking about, guys? What's going on now? Why do they have to keep having what they just trying to get the headphones working. I don't know. She looks mad. That's what I said too. Why won't they switch courtrooms? Like they can do it over a weekend. Yes. And that was here in Houston, guys, at Thurgood Marshall. Positive vibes in the chat. Okay. I saw that too. I'm that queen. It's okay though. Y'all. Thank you so much. I watched it the first time I watched it. I was on here yesterday with you guys. That was my first time watching it with y'all. So I thought it was funny. I posted it on my Instagram.
All right.
Thank you so much for becoming a member. Thank you. Thank you. Thank you.
Call me back.
There's one more.
Oh my gosh, we are never gonna come back. What is going on? And thank you guys for all the memberships and the super chats. Thank you.
Well, I didn't think it was going to take this long.
What is this, an IT issue? What is going on?
Your Honor, Mr. Sledge asked if he could have a moment to read that with his attorney.
All right.
He said he doesn't read as fast as I do.
Okay. Well, if y'all want to get back to the jury room, you can, but I doubt.
He
if it's
doesn't
gonna be
read
that
as fast
much
as I do
time.
is
By the
wild.
time you get back there, I'll be calling you back out again.
Your Honor, may we approach with a member of the defense about a correlated matter?
Sure.
I want to know what kind of smile that is Max just had. That was an interesting smile. That's not a nice. Ooh, look at that face. Ooh.
Tr- Do I start here?
Yeah.
Trying to
Get it out. Get it out. Why can't she get it out?
Go ahead.
trying to be proactive, Your Honor, based on our outside of the jury conference earlier this morning regarding that jail call. We went ahead and clipped the portion that the court determined could be relevant and had that sent over to the court and to counsel in the event that it became necessary to play simply that snippet. We sent that so that if there was any disagreement that that was the portion the court acknowledged may be relevant, counsel could let us know. So we were offering it at this time. I don't know whether the transcript we've provided is going to refresh Mr. Sledge's memory or not. He's having a conversation with his attorney.
Okay.
I was under the impression that we litigated this morning and that the state, and then you asked the state to play it, and the clip they played was talking about what Shannon's paid lawyer said.
Right, I don't think that's this. I think what she has just sent us is that first part we talked about. That is the transcript that he's looking at now.
Okay, I don't know how that could be 28 seconds, but
I mean,
listen.
I don't think it should be 28 seconds either, so I'd like for us to,
Can we play it for the
yeah.
court?
I just did a
The
poll,
whole
guys. Go
situation,
vote.
whoever witness number one is, this I know it's D. How he say, you remember when we talked on the phone, he's like, boy, you ain't know nothing about it, you was in the blind. They told them folks, D. After Lud got killed, all of them met up together and went down old boy house. Them made that word. That's how you know it's D.
Them folks, after Nut got killed, again, we're backdooring the fact that D said something to the police that's problematic. If Mr. Zachary takes a stand, I will deal with it and I will cross-examine him and it won't be a problem anymore. But I don't want there to be any insinuations, any references, any reference to D telling on people until he takes the stand. And so I don't know why we have to get into what Lil D told them folks to get the fact that he was at a condo.
Do you have the transcript or does he have Mr. Sledge have it?
Mr. Sledge has one copy, I have one.
And if Mr. Sledge needs to hear that outside of
Yes.
the presence of the jury,
One Lil
get
D,
context
Lil D
to
from Cleveland, and Lil
understand what he
D,
said
Mr.
previously,
Zachary.
I don't have a problem
They
with
call
that.
him the other Lil
I
D.
just don't want the jury to be hearing Mr. Sledge's phone calls to his girlfriend about what other people told the police.
Thank you so much for joining. Thank you, Cypress. Thank you.
Right.
That's
I think you
Zachary.
could
That's
accomplish the
Zachary.
same thing.
The other Lil
if
D
you
is the one
just
that Woody
cut
said
out the witness
from
one, because,
That's the other
I
Lil.
mean,
The other Lil D is from
what you're asserting that you want to get in is,
Demiki and Garlington is the other
I
Lil.
heard that he said these things and we know it's him because of exactly what he's saying. So we don't need the witness one part for that, so.
So, we will have Mr. Makins take out witness one.
Because, and just start with he
Thank
say.
you. Thank you for the membership. Thank you, guys.
And
I don't have the transcript in front of me. I don't have the call memorized, but I did hear
we can play it again.
he's telling them folk what he told them folks.
Yeah,
The whole point of this is just, was Mr. Zachary at the condo that night or not? And I really don't care what the answer is. What I don't want is a bunch of references to what was said at a prelim and D is telling these folks this and that.
nobody's gonna know who them folks is from this.
Well, them folks is
Them folks could be anybody.
Your
Them
Honor,
folks could be
respectfully,
anybody.
respectfully, Your Honor, them folks in the street is police. That's slang for the police, and I believe the jurors are
Yeah.
going to be able to put that together.
Well, I don't know whether they will or not, but that's what he said.
I understand that's what he said, but I don't believe that just because he said it, it's admissible. Him talking about what Lil D did, respectfully. If Lil D takes a stand, we'll deal with it.
Okay, well, maybe he'll just remember that Zachary was there after all.
And Your Honor, again, we gave that to him to refresh his memory about who all was there. What I started the questioning with today was, do you have any different
I
memories?
understand. I was here. All right, I'm gonna hand this back to you. But if he. If he's presented with it, the transcript, and he claims to still have no memory, then I'm gonna permit this in as a prior inconsistent statement. Yes.
This once, but I'm going to say it again. I would suggest someone just play Mr. Sledge's recording and then see if that refreshes his recollection outside the presence of the jury.
I asked him, did he want to, I asked him, do you want me to play it for you? You want to take the transcript? He said, I just like to read it. I just need more time. That's what just happened back there in the presence of his lawyer and chief investigator. Come on. Anybody want that?
Okay, can I
What?
go talk to the witness and ask if he wants to hear the
I'd
recording?
appreciate it if the witness would be allowed to talk to his own attorneys.
Oh, only the, I guess only the state gets to talk.
Well, y'all are the ones, you are the one, Mr. Shard, in fairness, that asked for a bench conference
You're right.
and suggested that Mr. Sledge be apprised and that his lawyer be apprised as to maybe what should and shouldn't be said from that transcript. And that is why Ms. Love went out and gave them that transcript.
And Your Honor, I was under the impression that this whole thing about the call had been settled. Apparently, I was wrong about that. But if he needs to listen,
I thought
to
it was
the
settled too.
call to refresh his recollection, I don't have a
No, we
problem. I'm
spent
just
Well, you
trying
know
to-
what? If he comes in and he says, yeah, that still doesn't help me, but if I could hear myself say it, then maybe that would, then we'll take it from there.
Okay, thank you.
Do we think maybe he's ready, or is a no, or,
Told him to come back in, but I'll send someone out to see.
or I mean, his co-counsel could do it. She's still here. That way there's no kind of, one side gets to see Mr. Wright more often than the other side. You can go ahead and take that screen share down for now, since we might not get to that. Yes. 5 more minutes. Anybody else need to use the bathroom? Okay, can you do it quickly? Because I don't want it to turn into another 20-minute recess.
We have done absolutely nothing today. Like,
We've had about,
let's
what,
see what-
5 minutes of actual trial time today
Yes.
so far?
yes.
There was no objection to the plea deal, right? There was not an objection to the.
Who
plea
needs
deal, right?
tissue?
No one has voiced one.
That was a lot of tissue.
I mean, other than they don't think it's a prior and consistent statement, and I,
This why I
Well, then
don't. This why I don't get up, y'all. I normally come in around 10:30, and this is why. I can't. Thank you for coming back, Miss J. Thank you. Y'all look at me leaning in like I can hear what's being said. Gone, gone. Mr. Howard was the district attorney, not Fonnie. So that's the difference. And then talk about who said something about he looks the youngest. Let's see.
Get the jury back.
We're ready.
I'll show y'all this later.
Yes, sir. I've instructed him, may I ask his counsel?
You can do it right now while we're waiting on the jury.
I'm gonna come back to this. I'll be right back, guys. 2 seconds. Thank you. Be right back. Be right back.
Mr. Sledge, have you had enough?
Hang on. We're waiting on a juror.
I'm sorry.
That's why we're all
Y'all
still
were waiting
standing.
on me. I'm so sorry.
All right. Even Ms.
My
Love wants to
apologies.
move the pace a little bit now.
I thought they were waiting on me. I'm sorry. I feel a little self-conscious. Mr. Sledge, have you had enough time to speak with your attorney and to review the exhibit label states 448 Yankee that I gave to you to refresh your memory?
Yes,
All right. And is the attorney with whom you reviewed that document the same one that you had on December 28, 2022?
yes,
Were you able to ask questions and gain answers to every question that you had regarding this document?
yes,
All right. Does reviewing State's Exhibit 448 Yankee refresh your memory about a phone call that you had with your girlfriend, with your child's mom on November 19, 2015?
yes,
All right. Your Honor, I'm going to place this here as not admitted for the purposes of the record.
All right.
Mr. Sledge, having read States 448, do you have any more memory about who all was at Mr. Williams' condo or with whom you might have met at the condo after Donovan Thomas was killed?
Could you repeat that, Ms. Love? Repeat it one more time.
Yes, sir. Having refreshed your memory about the phone call that you had with your child's mother,
Yes.
do you have any more memories about who all you met up with after Donovan Thomas was killed?
Yes, I think.
All right. When you say you think, who is it that you think you remember you met up with after Donovan Thomas was killed?
Who I met up with, or who I was at the condo. You losing me right now.
Let's go with the way you first said it, or the last said it. Who all was at the condo?
I still don't remember who I was there with. I'm trying to think. I seen the paper, but I didn't see any name really that was on the docket saying who was all there.
Do you remember whether Quindaria Zachary was there?
I think Quindara Zachary was there when I got there.
Do you remember whether Shannon Stillwell was there?
I still don't remember if Shannon Stillwell was there because I didn't see him personally with my eyes, so I still don't remember if he was there or not.
Do you remember whether Diamante Kendrick was there?
No, I think Mr. Kendrick was not there when I got there.
And when you say you did not see Shannon Stillwell with your eyes, is your testimony today, you know for a fact that you didn't see Shannon Stillwell or that you don't recall?
I don't recall. When I got there, I didn't see Shannon Stillwell there. When I first got there. That's what I'm saying.
At any point, were you, Shannon Stillwell, Diamante Kendrick, Quindaria Zachary, Defendant Williams, in a room at one of his condos the night Donovan Thomas got murdered?
Let it go.
I think we was. I think, yes.
Which one? Which condo?
Not the first one.
The second condo?
Yes.
All right. What were y'all doing?
Nothing. Mr. Williams getting himself together.
At what point did, and let me back up and ask you this. Would you characterize your being there as y'all all meeting up at that house?
I don't think we all arrived at the same time.
That's not what I asked. Would you characterize you all being there as y'all all meeting up at the house?
Yes.
All right. And what purpose did you all meet up at the house for?
They was going to the show and the video shoot with him. From my understanding.
Were you working as head of security for Defendant Williams at that time?
No, I don't think so.
And Kenneth Copeland, was he also one of the persons that met up with you, Shannon Stillwell, Diamante Kendrick, Quindaria Zachary, and Defendant Williams at Defendant Williams' condo?
Yes, he was there.
Okay. He was there and he was one of the ones y'all met up with. Is that what you're saying?
Yeah, he came down to the condo.
All right. Now, what did y'all talk about at the condo when y'all all met up?
I don't basically remember the conversation that we was having, but I knew I don't remember the conversation. I'm gonna say that.
Is it still your testimony that you went to defendant Williams' condo solely because you got a DM accusing you of Donovan Thomas's murder?
Yes, that's one of the reasons. That's the reason, yes.
Was there any other reason?
I don't remember. If you have anything that can refresh my memory, you can show me, but I don't remember no other reason why.
That's the only reason that you remember today? Okay.
Yes,
Given that that is the only reason you can think of that you went to defendant Williams' condo, did you talk about the fact that you were, one, that Donovan Thomas had been murdered, and two, you were one of the ones accused of Donovan Thomas's murder?
Sustained.
Thank you. Did you talk about with the people you met up with the fact that Donovan Thomas had been murdered?
yes.
All right. Now, about what time did you all meet up at defendant Williams' second location, his other condo?
I don't remember the time.
Do you recall whether it was before or after midnight?
No, I don't remember.
Based on what you said yesterday, is it safe to say it was definitely after 10 o'clock p.m.?
Yeah, it was after 10 o'clock, if I'm not mistaken.
All right. Do you remember how long you talked about Donovan Thomas's murder with the people that you met up with?
It couldn't have been too long because I ended up dropping Copeland off, so I don't remember how long it exactly was.
What was the atmosphere in the room while you all talked about Donovan Thomas's murder?
What you mean, atmosphere? Could you explain that to me?
I can. How did you bring up Donovan Thomas? Well, who brought up Donovan Thomas's murder when you all met up?
I already had spoke about it to Mr. Williams.
Right.
So I don't know who started the conversation at the second location.
Do you remember what the conversation was?
I just know the conversation with me and Kenny Copeland was the one responsible for it.
And was there anything said by anybody else that you remember?
Not really. I just remember Mr. Williams telling me that we ain't had nothing to do with it. Go down now.
Who is the we?
Me and Kenny Copeland.
Okay. And do you know how it is that Mr. Williams is able to tell you that you all don't have anything to do with it?
He wasn't directly like trying to tell us what to do. He just was basically saying, don't go to the show and go down there and clear our name.
Okay. Now, to your knowledge, did Kenneth Copeland go to Miami?
I don't know. I think he called me and told me he was in Miami, but I don't personally know, was he in Miami?
And is it your testimony that you didn't go to the show because, well, you wanted to stay and make sure your family was safe?
Yes.
All right. But is it also fair to say that you weren't trying to clear your name? You did not go to the, did you, I'll rephrase. Did you stay back from the show in order to clear your name?
Sustained.
Did you make any efforts to clear your name?
Sustained.
Your Honor, I'm not suggesting the answer. I'm just asking one that's yes or no.
Ask it a different way.
Yes, Your Honor. Did you take Mr. Williams' advice that you say he gave?
Sustained.
What did you do after you were told to not go to the show and clear your name?
I dropped Copeland off and I went on about my business.
We said this yesterday.
Do you make or recall anything else, anyone else in that room said about the murder of Donovan Thomas?
Objection asked and answered.
I'm asking if he recalls anything else. He seemed to remember something.
Go ahead.
Do you recall anything else anyone else in that room said about the murder of Donovan Thomas?
No.
After you dropped Mr. Copeland off, did you ever go back to the condo that night?
We talked about this yesterday, Miss Love. I told you I went to the hotel room.
I understand. Did you leave the hotel at any time and go back to the condo?
No.
Did you see either Defendant Williams? We'll start with him. Did you see Defendant Williams anymore before he left for Miami?
You said that night?
Between the time you said you left his condo and the time that he left for Miami, did you see him at any other time?
No.
Did you see Defendant Stillwell at any time after you left Defendant Williams' condo?
No, Miss Love.
Do you know whether Defendant Stillwell went to Miami?
No, I don't know that neither.
Do you know whether Defendant Kendrick went to Miami?
But I think Mr. Kendrick will going because he's supposed to be in the video or something like that, if I'm not mistaken. He was gonna help perform that night.
Do you know whether he went?
I don't know personally because I didn't see it, so I can't say personally that he went.
Do you know whether Mr. Zachary went to Miami?
No.
Did you speak with Mr. Williams at any time that he was purportedly in Miami?
I think he called and checked on me. I'm not for sure. I don't remember that. I think he called and checked on me, but I don't remember.
Did you speak with Kenneth Copeland at any time that he was in Miami?
Well, he told me him, his daughter, and himself or something went down there, if I'm mistaken.
Is that a yes?
Yes, I guess, yes.
Did you speak with Defendant Stillwell at any time during a point where he was in Miami?
No.
Did you speak with Defendant Kendrick at any time while he was purportedly in Miami?
No.
Now, when you spoke with these gentlemen that you love that are YSL members, did you always talk with them either in person or on a telephone line, or did you have any other ways that you communicated with them?
We never really talked on the phone that much. Me and Mr. Stillwell probably talked on the phone more than anybody.
And do you count FaceTime as talking on the phone?
Yes.
All right. How often would you say that you FaceTimed with Kenneth Copeland?
I can't answer. I don't know.
Did you FaceTime with Kenneth Copeland before he met with you at Defendant Williams' condo?
I don't recall.
Did you FaceTime with Defendant Williams before you went to his condo?
I don't recall. If you have anything to refresh my memory, you can refresh my memory, but I don't recall of talking to Mr. William before I went down to his condo.
What about Defendant Stillwell? Did you FaceTime with him before y'all met up at the condo?
No.
Did you FaceTime with Defendant Kendrick before y'all met up at the condo?
No.
Are you able to give us just a rough estimation of how frequently you spoke with Defendant Williams on FaceTime?
I can't give you that. I don't recall.
Did you, between the time that photograph in 425 Yankee was posted, so around December 2014, and January 10th, 2015, was that the same number that you would have used and FaceTimed with?
I don't know, Ms. Love. I can't answer that question. I don't know. I don't recall that. I don't know.
Okay. are you able to say with any degree of certainty about how often you FaceTime with defendant Stillwell, since you said that's who you talk with the most?
We used to FaceTime a lot, so
And the jury, and I don't know what a lot means for you, so could you please tell them what that means?
I can't give you a number of how much we FaceTime. I can't give you that number.
And thank you. I don't need a specific number. Was it every day?
I say yes, probably yes.
Was it multiple times a day or just once a day?
We talked like big brothers, little brothers, so I don't know how many times a day that me and him talked on the phone, but we talked a lot on the phone every day.
Defendant Williams and you, how often did y'all talk on FaceTime?
Me and Mr. Williams didn't talk on the phone as much as me and Mr. Stillwell did.
All right. Your Honor, at this time, I believe that the instruction that the court has that should precede what will be marked as State's Exhibit 442Y that we have sent would be appropriately read.
All right, so this is going to be about his plea in this case.
Yes.
Okay.
In this case.
All right. So I'm gonna again instruct y'all, and this time everything I'm gonna say is gonna be applicable to this plea in this 2022 case. All right. So you are about to hear, and you actually have heard evidence that this witness, who was a co-defendant in this case, has pled guilty to some of the charges in this indictment. I caution you that the co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider this co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, and they are going to be admissions in this case. This wasn't an Alfred plea. This was a regular guilty plea. You may consider the witness's prior inconsistent statement, that is his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have to the issues on trial.
Thank you, Judge. And we are going to play that. I wanted to ask Mr. Sledge a few more questions. Mr. Sledge, yesterday, you, am I correct that you testified that you know of an Antonio Sumlin?
Yeah, I know of him.
Okay. And did you testify that that's the person that you called Obama?
You never asked me, did I call him Obama? Not.
Okay. Did you call him Obama?
Yes.
All right. And how well would you say you know him? You said you know of him. How well?
Yeah, I used to see him around, but me and him never really hung out together.
To your knowledge, did he ever claim YSL?
Yes, I heard, yes.
Okay. And when is the last time that you talked with Obama?
I don't know, Ms. Love.
Did you talk with him in 2022?
Yes, probably. Yeah, I probably talked to him in 2022.
Do you know how often? Generally speaking, I don't need a
No,
exact number.
when I seen him, I talked to him.
Okay. Did you ever FaceTime with him?
No, I never been on the phone with him.
All right. Was the last time that you saw him in 2022?
Yeah, in person.
Okay. And do you recall if you ever spoke with him around April 2022?
April 2022?
Yes, sir.
No, I don't recall that.
Do you recall speaking with him around the time that this indictment came out?
I don't remember call talk to him when the indictment came out.
Okay. Did you ever share any bills with Obama?
What bills? What kind of bills?
Any bills? I don't even care what kind. Any kind of bills with Antonio Sumlin?
What you mean by bills? Could you be more specific?
Understand what
I'm asking you to be more specific.
money that you owe to somebody else?
No, I don't recall that. I don't recall that.
Did you ever have to pay any rent with Mr. Sumlin in 2022?
Mr. Sumlin never paid any rent with me.
Did you ever have to pay any with him?
No.
Do you know of anyone else within YSL who is referred to as Moncton?
No.
Have you ever had any reason to charge money at a door for a light bill?
Not that I know of. He never gave me no money for no light bill.
That's not what I asked. Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
No, overruled. Go ahead.
Could you repeat it?
Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
I don't recall. I don't remember, Ms. Love, but I know if you came to my house and stayed for weeks and months, eventually I want some money for you staying there.
I imagine so. Have you ever had any I take it back. Have you ever had any reason to charge money at a door along with Mr. Sumlin for a light bill?
You already asked that question, Ms. Love.
I'm gonna object to relevance at this point.
Your Honor, I have a very good faith basis for asking this question.
Okay, well, you're asking him, basically, has he ever charged money at a door for a light bill? Charged anybody money at a door for a light bill, right? Just maybe ask
Yes.
that and then,
Yes. Yes.
because if he has no recollection, then he has no recollection whether he was with himself or somebody else. So
Yes.
if you want to make sure that he understands the entire universe of people, have you ever charged them? Go ahead and ask that. But then if he doesn't recall, let's move on.
Thank you. Have you ever been upset that people were hanging out with you or at you and a spot you may have shared with Mr. Sumlin and not paid bills?
I didn't share with him. He just probably stayed a couple of nights, and when the bill came, I told him to give me money on the bill. That ain't.
Okay. And when you say stayed a couple of nights, where would it have been that he stayed?
He probably stayed in my room because I went home.
Okay. And was that your room on Boulevard or somewhere else?
Somewhere else.
All right. Was it a house that you lived at?
I stayed there when I wanted to.
What street was that house on?
I think it was out Brown Mill. I'm not for sure. I think it was out Brown Mill though. I'm not for sure.
Did you have a nickname for that house?
No, I didn't have a nickname for no house.
To your knowledge, did anyone ever call that house the Web?
I never hung it. I never been there when they called it the Web.
Do you know of a place called the Web?
I heard of it.
Do you know where it is?
It was off Brown Mill somewhere, but I never been to it. I just knew it was off Brown Mill.
Have you ever seen it?
I didn't know exactly what house it was whenever they was calling the Web, but I never been to it at that time, so I don't know.
Who is the they that you're referring to that called it the Web?
the streets. I heard people like at the gas station, I'm about to go to the well. So I don't know. It was,
Were those people YSL?
I guess.
Did you ever hear anybody other than YSL members talk about going to the web?
Yes, I don't heard females say they was going to the well.
All right. Do you know or have any idea how far the web was from the place you said that you were at off Browns Mill Road?
No, I don't know exactly.
Do you know the last time that you talked to Kenneth Copeland?
I can't tell you the last time I talked to Kenny Copeland.
Do you recall whether you talked to him in 2022?
I don't recall.
Do you remember talking to Kenneth Copeland at all while Kenneth Copeland was in prison around that time? That time being 2022.
I don't know if I talked to Kenny Copeland in that time. I'm not for sure, my lord. I don't want to say the wrong thing, so I'm not for sure.
Right today, you don't remember?
Yeah, I don't remember. Right.
Okay.
So.
Do you remember whether you talked to Demekion Garlington?
When?
When was the last time you recall talking to Demekion Garlington?
I'd probably say 2022.
Okay. Did you ever talk to Kenneth Copeland or Demekion Garlington, either of them, about a RICO indictment?
You saying did I ever talk to them about it?
Yes, sir.
I don't remember. So if you have anything, you can refresh my memory.
Do you have any memory of having conversations about a potential RICO indictment before this indictment or its predecessor was ever brought forward?
I don't remember, Ms. Love. I'm being honest with you. I don't remember.
Thank you. I appreciate that. Your Honor, at this time, the state asks permission to publish 442 Yankee. I'm sorry. We tender 442 Yankee as evidence.
All right, that is admitted and you may publish.
Thank you, Judge.
We're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, counsels Love and Hilton. Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing should be the truth, the whole truth, nothing but the truth, so help you God or so affirm?
Yes, I do.
All right, you put your hand down, sir.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Moonton, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes, ma'am.
today?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until the years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentence.
We might need to skip forward 2 seconds. Try that.
The agreement is not captured. I'm going to object to skipping forward. I'll
Let's-
see.
Let's see.
Your Honor,
I'm not saying to skip anything substantially. I'm trying to
Right.
see if they can skip over the part where it's just repeating
skipping,
itself.
yes. We're sharing through a different screen and we're going to go ahead and pick up
On
at
these
6:40
charges.
At 6:40 where we stopped.
It has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3, special conditions of sentence of this plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial meeting stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgements section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgements and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgements contained within this plea agreement. Section 4, defendant's factual acknowledgements. Have you initialed each and all of the defendant's factual acknowledgements contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgements are as follows. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave the defendant and other YSL associates cash money to lay low. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgements and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgements that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgements are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
Change it to E. Then initial right there.
1 And Mr. Sledge, is that your initial above the strike through of the word begin to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgements?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgements, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you sign your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence, State's Exhibit 1AS.
No. Any objection? States 1AS is admitted for purpose of plea.
Mr. Sledge, I'm showing you, and Your Honor, I'll show defense before I present it to him, what was admitted during that session as 1AS. If anyone wants to see it, if not, I'll go ahead and approach the witness. All right. Mr. Sledge, would you please take a look at 1AS and tell me if 1AS, which was admitted for the purposes of your plea, and the document we have been referring to. Yes, thank you. As states 444 Yankee. And I will now add back the first 2 sheets. Would you please look at those 2 documents and tell me if states 444 Yankee is an exact copy of State's Exhibit 1AS that you signed on December 28th, 2022.
Look at the whole thing, or just the.
Yes,
Sorry,
sir.
sir.
Please look at the entire thing.
Yes, I remember this one.
And is State's Exhibit 444 Yankee an exact duplicate of the document labeled State's Exhibit 1AS?
Yes.
All right. Thank you, Your Honor. One moment.
Thank y'all for the super chats.
That's all the state has. Your Honor.
All right, is there a cross-examination of Mr. Sludge?
Finally,
All right, go ahead, Mr. Sharp.
here we go, guys.
Yes.
Mr. Kokomo's in need of the Zoom link.
It's the same it's been all week. Can you look at maybe a prior day's email? Or the state will forward it. Thank you.
And is 12 o'clock still time for Miss Sylvia? Because if so, we got 20 minutes. Then lunch maybe at 12:30.
He's got it. He's in.
Mr. Sledge, good morning.
Good morning.
My name is Max Shard. I represent Shannon Stillwell, okay?
Yes.
All right. I'm going to be asking you some questions about that document that you were just reviewing. Do you have that up there with you?
No, she took it.
Okay. If I ask you specific questions about that document, do you think it might be helpful for you to have it in front of you to refresh your recollection?
Yes.
Okay. Your Honor, may I?
Yeah, I think it's right up with the court reporter.
Okay.
Oh, okay.
I'm not.
Okay.
We'll get there.
Okay.
And just please listen to my questions and then answer truthfully, okay?
Yes.
All right. Mr. Sledge, I'm going to ask you to go back to December 28th of 2022, okay?
Yes.
Now, that is the day that you pled guilty, correct?
Yes.
And that's also the day, as I understand it, that you initialed that document. Is that correct?
Yes.
Initialed the factual acknowledgements within the document, correct?
Yes.
All right. Let me ask you one question before I get there, though. What day were you arrested on this case?
I want to say May 27, 2022.
May 27th, 2022. Well, that works out well for my limited math here. Okay. So May 27th of 2022 to December 28th of 2022. That seems to me 7 months. Is that correct?
Yes, 7 or 8.
Okay. So on December 28th of 2022, when you initialed those documents, you had been locked up for 7 months.
Yes.
Okay. You had previously moved for a bond in this case, correct?
Yes.
You moved for a bond on October 13th, I believe, 2022?
I don't remember the date, but yes, I know.
It was in October?
Yes.
And the state opposed your release on bond, correct?
Yes.
And Judge Glanville denied bond, correct?
Yes.
Okay. So on December 28th, 2022, you had been locked up for 7 months and 1 day, and you did not have a bond.
Objection, asked, answered, and compound.
Sustained.
On December 28th, 2022, you did not have a bond, correct?
Sustained.
Let me ask you, when you were locked up, we're saying locked up, where were you living? Where were you held?
At the Fords County Rice Street.
Okay, that's Fulton County Jail.
Yeah, jail.
Okay, and we're not, generally speaking, is that a nice place to be?
Objection, relevant.
Overruled.
No.
Is that a dangerous place?
Yes.
Is that a filthy place?
Yes.
Okay. On December 28th, 2022, there were some things going on in your life, correct?
Yes.
Okay, you've already shared with us that your mother was ill.
Yes.
Certainly, on that date, you wanted to get home to your ill mother. Isn't that correct?
Yes.
You are also a father, right, Mr. Sledge?
Yes.
You have 8 children, is that correct?
Yes.
Okay. On December 28th, 2022, I don't need to know the age of every child, but what was the age ranges?
23 to the youngest 9.
The youngest was 9.
He 9 now.
Okay, so about 7.
Yeah, about 7 then.
Thank you,
And
Turner.
do your children live in Atlanta?
Yes, all of them.
Okay, do you spend time with your children?
Yes.
Objection, relevant.
Sustained.
Do you attend to your children's daily needs?
Objection, relevant.
Sustained.
Your Honor, may I be heard?
You may.
It goes to his need to get out of jail.
All right, well, get to it.
Okay. Do you attend to your children's daily needs?
Yes.
Do you drive your children to school?
Objection, Your Honor, relevant.
Let's move along a little bit.
Okay.
Oh, they gotta move along.
Did you have a significant
What?
other at the time?
Yes.
Objection, relevant.
Overruled.
Yes.
And I don't even need to say her name. Her initials are DB.
Yes.
Okay. On December 28th, 2022, did you miss DB?
Yes.
Did you miss your children?
Yes.
You indicated that Derek Wright is your attorney,
Yes.
and he's represented you in the past,
Yes.
and you hired him on this case.
Yes.
Okay. When you testified, I want to make sure I'm correct on this, you paid him a certain amount of money, and I don't need to know the amount.
Objection, relevant.
He's testified that he did not, his understanding was he did not pay his attorney. You didn't, the money that you paid your attorney, you knew it wasn't enough for him to go to trial on this long case, correct?
Yes.
That was your understanding.
Yes.
That was his understanding.
Yes.
You did not have an attorney to take this case to trial.
All right, no, now that we all know that that's not true, that anybody who can't afford an attorney is entitled to get an
Well, I'm
attorney
gonna get
without
there.
cost to them.
I'm going to get there. There were people in this case that couldn't afford an attorney, correct?
Objection, Your Honor, speculation, relevant.
People weren't, people still don't have
Hang on,
attorneys.
hang on, don't talk over each other. That is not relevant to the question that you're asking him, nor to this trial going on right now.
Your Honor, may I be heard?
Yes,
If he knows he's going to
you
sit,
may, yes. You know what? Let's break for lunch, because I know that this is gonna take more than 30 minutes for you to do your cross, so let's just break for lunch right now. Huh? Time? Oh, right, well, I've got some, we have to deal with some other matters. Let's say 1:30. Is Let's take up this objection.
So, Your Honor, and I say this not in a pointed fashion. You weren't here in the beginning of this case.
Yeah.
And I know that you're not presiding on the case with the other individuals. The reality is, people were severed off this case because our public defender system did not provide people attorneys. People were sitting in jail for up to 2 years. I'm not even sure everyone has an attorney to this date. These gentlemen that are not sitting here, that are sitting in 901 Rice Street, 2 years later, I don't even know if they have attorneys now, but I do know when we started this trial, people were severed because the public defender's system had not provided attorneys. Mr. Sledge knew that. Mr. Sledge, and this is the reality, and I don't think we should hide it from the jurors. The reality is Mr. Sledge had two options: plead guilty or wait for an appointed attorney to try this case, and he would have been sitting in jail and he'd still be in jail today.
All right, all of those cases are ready to be tried right now. Everybody who's been severed out other than for that reason is ready.
Okay,
And
well,
I
right,
mean,
and they're still in jail.
well, so are all of these defendants,
Well,
but we're not going to get into that, are we?
Well, at this point, I really probably wouldn't mind, but I'm not going to speak for everyone else. But it goes to his mind state. He had two options: either take this plea or end up in the same bucket that Demekion Garlington and Demise McMullen and other people were in, which was be unrepresented, sit in Rice Street until the state gets about. So when we say we know people are appointed attorneys, yes, I know theoretically under the Supreme Court precedents and under our Constitution, appointed indigent individuals are supposed to be appointed attorneys, but in reality, that did not happen here.
That may not have happened immediately, but
It
it just
didn't happen.
happened. And
It didn't happen until very recently.
I mean,
Your Honor.
that does not need to be what is I mean, there are so many collateral issues in this case. So if you want to ask him much more pointedly what his understanding was, but we don't need to go through every co-defendant who may or may not have had.
Oh, I wasn't going to do that.
To be going down
No,
that
I was
road.
just asking if he knew. I was saying he was aware that attorneys were not being appointed to represent the other people he was with, and he didn't want to be in that situation. And Miss Love was objecting, and I never got a chance to get to it.
I mean, for all I know, Ms. Love's now going to want to cross-examine him on his actual financial affairs, which I think would be fair, because I'm not sure,
don't have a
that
problem with
wouldn't
that.
be fodder for redirect at this point.
I mean, I don't really have a problem with her cross-examining him at this financial affairs.
Just give an idea.
Mr. Wright might.
Wow.
Well,
Give an idea.
I mean, why don't you propose a couple of questions that you
That's
think
correct.
will get to the heart of the matter?
Well, I've already established that he didn't hire Mr. Wright to try the case. He was aware
Wow.
that other people that had been arrested that could not afford attorneys were remained unrepresented 7 months later. And he didn't want to be in a situation where he was sitting in 901 Rice Street without an attorney to represent him.
You are not going to be able to ask him about well, I see what you mean. Okay, well, let's not give it the impression that it's indefinite and still going on right now, because we all know that's not accurate.
Well,
That's not accurate. I can pull up all 19 of the co-defendants, I
Well,
guess, and look and
all
see,
represented.
but
and
they're
we-
all represented. They have been for quite a while, right?
Yes, ma'am.
a few
Gone to
months.
several hearings with them and their
They're
attorneys.
at like final plea stage, aren't
Well,
they?
Yes,
at
they're
the-
actually pushing for trial. in the middle of this
Except
trial.
that, yes, which needs to happen, but that's a whole other issue. Okay, so you get about one more question on that and then
I
move
proposed
on.
two.
Okay, what are the two?
That he was aware that on December 28th, 2022, there were people on this case that could not afford attorneys. They had not been appointed attorneys by that date, and he didn't want to be in their situation. I guess that's three. If we're not going to make compound.
May I respond?
You may.
Judge, I would object to Mr. Sharp's assertion, number one, that
In the
he's
meantime, let's
established
get some members.
that
Let's get some super
um,
chats. I'm gonna put
Mr.
some clips from the last
Sledge
hearing.
did not have the ability to
Sharp.
secure
Okay, guys.
Mr. Wright
I
for
can't wait.
trial.
So he said on direct that he didn't. He said, I couldn't afford Mr. Wright for trial, and that's why I pled.
Okay, we'll get into that. Also, I object to the speculation
Okay, we're getting.
regarding, as speculation, his question regarding whether or not anyone else could afford or had an attorney or would be appointed an attorney or might have to wait for an attorney.
I wasn't asking for
It's
speculation.
not-
I said on December 28th, you
What-
knew that other people didn't have attorneys yet. We were all in
Okay.
court. We
I
were all in
mean-
court. We were
Yeah.
all talking about it openly in court.
Yeah.
There were people there that did not have attorneys.
Yeah.
They all sat right there and looked sad, and we all
Okay.
openly
Yes, Ms.
discussed
Love.
it.
Thank you.
I mean, that is
It is
true,
an
right?
improper-
That on December 28th of 2022, there were at least some co-defendants without an attorney yet because there are so many conflicts.
There were
Okay.
still on December 28th.
All right.
We would object that Mr. Sharp's line of questioning is an improper attempt to elicit sympathy from the jury. He has already asked and established that Rice Street is just
Thank you, Y
the
Turner.
worst place in the world.
I know.
And
He's
he
not
wanted
going
to
into
get
that
out.
anymore.
Please.
Also,
I'm like Moody. I'm almost want to get up on the
He's,
feet.
I mean, he may be
Bed.
trying to establish sympathy, but I think what he's legally trying to do is establish motivations for testifying, and that he's allowed to do.
Yes.
motivations
Mo-
for
motivation.
entering
Whatever
court.
he's doing, for whatever this witness is doing.
Okay.
That's a legitimate.
Would the court indulge and ask Mr. Sharp just to repeat so that I can write it down exactly what those questions are that he intends to ask and that the court is about to rule on?
Do you mind repeating those?
I'm going to try to do it as consistently as possible.
Okay.
I was kind of making them up
Off the cuff. I
off the
know.
cuff. You were aware that other people arrested on this case had not hired attorneys on December 28, 2022. On December 28, 2022, you were aware that other people arrested on this case had not hired attorneys.
Okay.
On December 28, 2022, you were aware that some people that had not hired attorneys had not been appointed counsel and remained unrepresented,
Okay.
and you did not want to be
One of those people.
one of those people at Rice Street without an attorney.
Okay. And Ms. Love, if you want to voice what your objection is, if any, to those questions for the record, you may.
I'm getting that last compound one down. Remains unrepresented. And
Had not been appointed counsel and remained underrepresented.
So I have, you were aware that other people arrested on this case had not hired attorneys on December 28, 2022. And the second one is you were aware that some people who had not been appointed attorneys remained unrepresented on December 28, 2022, and you did not want to be one of those people? Did I get it
Well,
right?
that was my phrasing of it.
Oh.
His phrasing
You did not
was
want to be
unrepresented and in Rice Street.
correct.
So, Your Honor, I believe that the second question, in as much as he did not want to be unrepresented and in Rice Street, is fair to establish that point. But I believe that Mr. Sledge's awareness of other people or lack thereof or speculation about whatever their status was, it would amount to speculation, number one. It would
Hang on,
amount to
wasn't
hearsay.
Mr. Sledge a defendant in this
He
case?
was,
up
he
until
was.
the
I don't know
time?
if
So
Ms.
that's not speculation.
I don't know if Ms. Love was here, but we
What-
had court hearings where
Okay.
Unrepresented
I'm gonna
people also
permit,
right
so
there.
is that a relevance objection or?
It is
something else?
there is a relevance objection to it. Yes, there is a relevance objection as well.
I'm gonna permit all of those over objection.
Thank you.
Anything else you think we're gonna need to hash out outside of the presence of the jury?
It also, it suggests impermissibly in my mind that the plea that Mr. Sledge gave was, and I mean, this may be something that we just argue, wasn't given knowingly, voluntarily, and willingly, when Mr. Sledge has already said that he pled guilty knowingly, willingly, and voluntarily.
You've got the video in evidence where he says that and
Right.
acknowledges it, so. All right, so are there any other issues we think are gonna need to be taken up outside the presence of the jury while we're doing this?
Mr. Steele just sent
Cross.
over a Dropbox link and we don't know what's in it yet, so we have to review it and we don't know yet whether
All
there's
right,
something
Ms.
else.
Jill, is that your potential cross? Yeah. Okay. All right.
In your honor,
Yes, sir.
I plan on you, I'm sorry. In your honor, I just handed the state a one proposed exhibit that I'll be using, DS-36. It's actually from Discovery, but I've taken out all the commentary. It's ironically something that they're seeking to admit.
Okay, well, then they should not have an.
Yeah, you would think that would be the case, but it's pictures of Kelvin Watts, Miss Entrevia Smith, and Mr. Sledge. And I'm going to ask him if he knows who those people are.
Any issue with that?
No,
Okay.
Not to this. I haven't seen the rest of what's
Okay,
new in the
I
Dropbox.
know, nobody's seen Mr. Steele's stuff in the context of its use. Obviously, they've seen it in Discovery, but yes, sir.
Yes, Your Honor, I do have a document.
Okay.
I have a document as well that's provided in Discovery.
Okay.
That I intend to use in a short statement.
All right, thank you.
And, see where we are.
Great, thank you. You want to go ahead and do that right now?
Yes, Your Honor.
Okay. Yeah, yeah. Mhm. Yeah.
Older sign for Mr. Sledge exhibits, and there's several missing out. If you take any of them out, please bring them back. There's none of the pictures, there's only 4 wide in here. And it should be 4 wide, well, 410, 3 4 which are photos. None of the photos are up here that were submitted. And also I have not gotten a copy of the video, it's just that on the jump drive. Okay?
The video that we played today, that we edited. Okay, we will provide that to you on a jump drive and via email. Yes, ma'am, we have the photos. We have another copy of them. I don't know why they're on there. I thought they were in there yesterday.
I don't know. I guess maybe the sound is off. We can't add neither because the question is, who who do y'all like better?
I mean, if y'all want to maybe do that offline, I don't know if y'all have any dog in the Rule 22 or not, but. I don't know. Is there a Jason Whitaker here? He was one of the people that, if not, then we won't bother with that part of it. If he can't show up for it, then.
So I guess
Okay.
me.
They're what? Okay.
Well, maybe. Oh,
Well, they can come in here beforehand. Are you Jason Whitaker? All right. Hello. How are you? Come on up to the podium. So I know you have just very recently filed a Rule 22, and I think we were going to have a hearing on Monday, but you maybe didn't get notice, so we had to move it to another day, because obviously you need notice in order to be here for
I
it.
was actually sitting right back there when
Oh.
when your assistant called me. I was sitting there.
Okay, well, anyway, we tried to reach you, and that's why it wasn't earlier, is because we thought that you didn't have notice, so sorry. Maybe, I thought I even asked out loud, but anyway,
It's perfect.
here we are now.
We're here.
And I know that you want to film in some way. Here's the thing, is that we have already got a whole lot of people filming. And I'm gonna have Sylvia Parks in just a minute. I don't know if she's here right now. What I am gonna propose is essentially the same thing that I proposed with regard to Ms. Bumpus, is that you all kind of be pooled media.
Okay.
Because we just already have so much going on.
Not a
So
problem.
that work for you?
Can I express what I was seeking to do?
Sure.
I actually didn't want to. Well, first of all, my name is Jason Whitaker.
Hello.
I'm a member of the community. I'm a Morehouse graduate and actually a former classroom teacher at Cleveland Avenue Elementary School, one of the schools they've been talking about.
Thank you for that.
I do a podcast, and
Okay.
we've been live streaming and discussing this case. And I did not want to actually record anything. I wanted to just be able to, if possible, because I had the Rule 22, be able to use my phone and just update on things that have happened in court. That's it. Nothing more, nothing less. No filming, no picture taking. Just being able to keep up with the community that's watching this. Actually, I stream it from home, so they're watching it out from my house, and they just be able to say, "Hey, this is what happened." Or if the audio goes out, say, "Hey, this is what you might not have heard," or anything of that nature.
We
So
don't
it's
say
not
anything exciting when the audio goes
no,
out.
nothing exciting happens when
No,
the
I
audio
know.
goes out. So that's actually it. Judge
Okay,
Whitaker.
well then you'll sit in the media row?
Yeah, absolutely.
Okay, because they're kind of different rules for the media, phones
I will,
and
I
other
will
people's
follow all the
phones.
rules that are
Okay.
given to me.
That's fine.
Yes,
You
sir.
may do that,
Okay.
yes.
Do I need to give you back this to get it signed, or does the deputy just need to know?
I don't even care no more.
We do it all electronically, so I'll just sit, but my understanding then is that you just want to be able to use your phone to.
And my laptop, just
post
just
essentially, but not to record in any way.
nothing's recorded,
Okay.
nothing's pictured.
All right, we'll get one filed that gives you that permission.
I appreciate it. Thank you so
All
much.
right.
Emily.
I'm about to ask for mine too.
Okay, is it Parks, will that work, or just Miss, okay, come on up.
Here we go, guys. Thank you for the super chat.
All right, so I know that you have been live streaming pretty much this entire trial, and I'm sure probably the pretrial proceedings as well. And it came to both the court's attention and defense counsel's attention recently that you had been on your, what do you call those things that you do? It's not a podcast, or is it, do you still call it that?
It is a podcast,
Okay.
but it's
A video podcast. Okay,
podcast.
anyway, we'll call it a podcast. That you had been, and I know that you say in your letter that you didn't reveal any personal identifying information. And I think that you did not reveal enough to actually identify any of the jurors, but you were referring to where different people sat and their race and gender. And that is personally identifying information. And then you were giving them derogatory names. And you say in the letter that you provided to me this morning that you have always operated with great integrity, that the content you share represents factual reporting, and that you do your reporting with the, and these are all quotes from your letter, the utmost respect and integrity for all involved. Do you believe that any of those three statements that you made to me this morning is actually true about the names you were given those jurors?
I just want to give you the names were movies that I like. And, you know, SpongeBob is my daughter's favorite cartoon.
Do you think that those showed respect and integrity to the jurors?
Well, I didn't think it were bad names at all. Glasses, nose. No, I didn't think it was bad names. Actually,
So,
all the names.
The utmost respect and integrity?
I think it's depend on the individual. Well, to me, I felt it was utmost respect.
Well, I do not feel that. That seems like the kind of thing that a kind of mean person does on the playground in grade school.
You think so?
I do. I don't think that shows the least bit of respect or integrity to the jurors or to the court system. So if you are going to, and let me ask you this, you talked in your letter about being media and freedom of the press. Do you consider yourself to be press and media and journalism?
I consider myself being a content creator. I create content for the community and give information. As far as journalism, I didn't go to school. I've taken some classes and things like that. But I mean, the information I believe is very vital for the community.
I don't disagree. I mean, this is court. It's one of the most important things we do in our country. But you say my role is to deliver news and information. So, I mean, do you, to that extent, consider, and you say you want to represent factual reporting. So do you, to that extent, consider yourself to be media, even if it's non-traditional media?
Yeah, I would think I would, because I've taken courses of like etiquette and things like that. But as far as, and then and the other thing too, with my channel, it's more like some sort of like easygoing, friendly type of thing where people don't feel like it's just.
I'd love for you to keep it friendly.
Okay,
that would be great.
Okay, and I will never use the names anymore if it offend anybody, because that was never my intention to offend anyone.
Okay,
I was just using names that movies that I like, Twister, SpongeBob,
well,
Ghost, you know, things like that.
I mean, I realize that if you're trying to create content that fills, you know, the entirety of every day, that sometimes you probably have to reach out somewhere to whatever pops in your mind at the time. But I would ask that before you do that, that you actually do keep in mind that this is a court proceeding. And I know a whole lot of people seem to be watching this as entertainment, but this is not entertainment for any of the people involved here. This is very serious. And it does a disservice, I think, to everybody when the coverage is flippant in the way that I think that was, okay? And I know you've got every right to do that if you want to. I would just prefer that you not.
I won't.
And I am gonna give you this, it's a code of ethics that the Society of Professional Journalists follows as a guideline.
Okay.
And I mean, you're not required to abide by it. It's not the law. But it might be helpful for you to take a look at it and just, you know, use it as a guideline.
I definitely will.
Okay, so if you can do that for me and try to be respectful and treat this with integrity, then you may come back in and continue to live stream.
Definitely.
All right, I appreciate it.
Thank you,
I'm gonna
Anna.
hand this up to you.
Okay.
All right, I don't know if y'all have had an opportunity now, we can get back to our issues with, or potential issues with some of the exhibits that may be used during the cross?
Yes, Your Honor. And
All
with
right.
the court's permission, may I maintain my seat because I'm looking at.
You may.
So in the Dropbox that we received from Defendant Williams, included are what appear to be, and I'll just take them in turn, exhibit number 15 alpha for Defendant Williams appears to be a video of LeBron James dabbing up someone and wiping his nose and saying slime.
Okay.
We object to that.
On what basis?
Relevance grounds.
I suspect the relevance is gonna, well, I don't want to speak for you, Mr. Steele. What's the relevance?
It just shows that this is not unique to YSL
Okay, well, I
or
mean,
in a gang. Also, Your Honor, it's already in evidence.
it's already in evidence anyway. It's already in evidence.
That's possible. It
It's
probably, it
already
may
in
have
evidence.
gotten, that may have been the
All right.
case. And if
Yeah,
that's the
if
case.
it's not, I
I'm
can
s-
see,
Okay.
I'm gonna overrule the relevance
Okay.
objection to the extent it's not in evidence.
All right.
Any other?
And yes, there are apparently, so I'll name them again, 16 alpha from Defendant Williams is a person unknown to the state, a random person in what a TikTok video. And this person is, they're singing.
Okay.
Apparently they're singing Defendant Williams' song.
Okay.
And they're saying, and he's saying slat, 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 slat. They're lip syncing to it. It's a young female wearing a skull cap, lip syncing to Defendant Williams' song.
Which number is this?
Okay, in the beginning, there's no skull cap. She's
Oh,
just got
okay,
her
then she
hair
puts
straight
one
down.
on.
And then later on, there's a young lady in a skull
Okay.
cap. We object on two grounds, relevance and in as much as it is Defendant Williams' statements, his statements, we would object as self-quotations.
I don't understand
You
the
know,
self.
there is no
Right.
objection
Or-
that is, evidentiary objection that is
Let me-
self-quotation.
Self-serving hearsay. It's hearsay, Your Honor, and there's no exception for it. So I'll leave it at that.
It's non-hearsay. I'm not using it for the truth. I'm just
Mhm.
showing what exactly now Mr. Sledge said that slime is just used, slat is just used. He said it's used by people all over the world. He said people can say YSL, they're YSL, there's no initiation. I don't know though, Your Honor, if he
All right.
has seen these before, so
The
I'm just,
what? You don't know what?
I don't know if I could lay a foundation. I don't know if he's seen these before, so I would show it to him beforehand.
So, I mean, if this is an exhibit that's showing somebody lip syncing to one of your client's videos where he uses whatever this terminology is, that doesn't establish anything other than he put these things in a song and people sing his songs. That doesn't establish that she or anybody else would have used that terminology otherwise. So I'm going to exclude that. That does not show what you allege it to show.
I think that goes to potentially weight, but I understand the court's ruling.
Additionally, Your Honor, 16 Bravo from Defendant Williams is a video that I think it's safe to say has not been tendered previously. And it is, as it's loading, it's a young man whom we don't know the identity of, who is, I think, either singing or lip syncing. He's lip syncing Defendant song.
All right, let me say that anybody who is just some random person lip syncing or singing a song that Mr. Williams put out does not establish anything other than once he puts out these songs, people like the lyrics and sing the lyrics, and that doesn't establish anything other than that. That it is now in common parlance in the music business is probably not even an issue.
So I think that that is the case for 16 alpha, 16 beta, 16 Charlie, 16 delta, 17 alpha, 17 beta, 17 Charlie, 17 delta.
No, that's wrong. So it
So
would
we're
be
still
under
going through them.
16 A through F would be
Okay.
consistent with this honorable court's
All right.
ruling. I will not attempt to introduce it.
All right.
17 A through E, some of them have already been admitted. Other ones are similar. It's just people who are using the nose wipe, if you know what I'm talking about, the finger across the nose.
Okay.
And that's what those are.
And those are already in or no?
No, not all of them,
All
but
right.
some of
And
them.
do we know when these came into existence?
Yes. Mr. Trontavious Stevens and Jeffrey Williams exhibit, or JW exhibit number 17A
Uh-huh.
is already in evidence, and it's already marked 7 through E.
Judge, can we confirm that? Because I
Thank
don't
you,
have
Turner.
that same memory of 17 alpha. in
Sure,
this.
and I guess
and-
at some point, we really do need to sit down and sort out the evidence that came before me, but yes.
All right, so we do not have that same memory, and to the extent that it is not, if it is not, we would object on relevance grounds. It is an unknown person.
All right, do you know when it came into existence roughly?
We have the exact date. It's also 15. I think I said 17.
You did.
15A.
15A is LeBron James, right?
Already in, and Mr. Kumo is getting the date, if that's okay.
So you already talked about 15, if it's,
So 15A is not LeBron James lip syncing, is it?
it's LeBron
January
James.
2nd, 22nd, 2024 was admitted into evidence.
Yes, so-
January 22.
Is he
2000.
also lip syncing one of Mr. Williams' songs?
Mr. LeBron James is coming into a locker room.
Uh-huh.
He has teammates. He's a basketball player.
Yep.
I know you know that. but,
I know, you're setting up for the record.
um,
He's one of the most famous people in the
yes.
world. Yes.
is greeting his teammates.
Okay.
And as he's greeting, he's doing different type of greetings. And one of them is the wiping of the nose.
Okay.
That's what it is.
Okay.
Other people in there, and I have to look to get the exact numbers, but is a baseball player on the Padres. Last name is Musgrove, Musgrove. He throws a pitch on the diamond. He strikes out the batter. It's the New York Mets, and he wipes his nose. Another one is Stephon Diggs. He's a football player on the Buffalo Bills. At that time, he's now on the Texans in Texas. And their quarterback, whose name I can't remember, Josh Allen, they both greet. It's the same type of thing. They greet in the huddle, and Josh Allen's going around other people. They wipe the nose.
And these are all in 15A?
No.
They should be 17A, then 17B, then 17C. I separated them all.
Okay.
So Your Honor, what we'd like to.
17D and 17E, and they just go consecutive. And the next one is CD Lamb. He's a football player on the Dallas
Okay,
Cowboys.
well, we're
It's the
probably
same.
getting cumulative at this point, but so are these all from like the 2023, 2024 era?
I'd say so. 20, maybe a little earlier, but yes.
Judge, so our objection is that, one, as we look at starting at 17A, these videos that Mr. Steele or Defendant Williams is seeking to have admitted are nothing more than people imitating a hand motion or lip syncing words that Defendant Williams appears to have made popular through his music and his songs. Defendant Williams has SLAT tattooed on his index finger as he wipes his nose, and is photographed in pictures and publications with that index finger, nose wipe, and word SLAT. The fact that his music that he has circulated, that people have taken to it and emulated it, has absolutely no bearing whatsoever on whether or not either defendant in this case, and specifically defendant Williams, committed any crime alleged in this indictment. It has no relevance whatsoever. It is a circular argument to bring about something that someone else is doing now because defendant Williams did it. I don't believe anyone, and I can't speak for everybody who's going to get up there, but I don't believe that anyone is going to be able to say, unless they bring in the people who actually put these videos up, when these videos were created, when they were done. There's no foundation, I think, that can be laid, and I don't think that any of them are relevant to any matter in this case.
Okay, well, I mean, the reason I asked about when they came into being is because the fact that something that a performer of the fame and magnitude of Mr. Williams has brought into more common parlance, if you will, within society, doesn't really establish anything more than that. Why don't you pick 2 or 3 and let's just go with that, and that will, I think, establish your argument that this is just something that doesn't mean gangs at all. It just means, this is what's cool in common culture right now. They'll let you do that. That will not prevent the state from arguing maybe what it is now, but that's not what it originated as. It's not what it means to the people in YSL. Y'all can argue that in front of the jury. But we certainly don't need, 15 or 20 of these. So pick like 3, okay?
Also,
all right.
I believe
That 222 Alpha XX from defendant Williams is a compilation that we've not yet, these are flyers of defendant Williams that we object to.
Okay.
Based on relevance, they are self-serving, they are hearsay. So we object to 222 Alpha through XX. We have not yet looked at all of them because we didn't realize it has so many exhibits contained in the one. So I'm still sorting through them. They appear to be defendant Williams flyers.
All right, and what would be the relevance of those?
So this, I couldn't get these. The state gave this to us in discovery. This is from Mr. Williams' Twitter account, and he advertises.
No, this is
This is 220 Alpha through XX?
Yes.
Okay.
So he advertises his shows.
Yeah.
And what I did was listening to Mr. Sledge, he may know about these shows.
Okay,
So-
in which case?
So then the state is saying that Mr. Williams is on Cleveland Avenue and Mr. Williams' notoriety has to be increased because of a drive-by shooting. And I'm saying the opposite. Mr. Williams is extremely busy. He is always in a studio. There's been testimony like that. There'll be more. And he's constantly performing around the time of the 2014 going into 15, which is the relevant time period for Mr. Sledge's testimony.
And is that what all of these are from?
Yes. So that's why I put them together. Now, it is extremely relevant because what the state is trying to show that Mr. Williams somehow is so interested in this gang that is on Cleveland Avenue and selling drugs from a convenience store. And I want to show the truth of what he's actually doing and how busy he is. So that's why these are here. They're not anything to do with hearsay. And this gentleman may not have personal knowledge of these events and shows because he was going with Mr. Williams as he testified to. And that's what I was going to do.
Are you going to hand them to him
Yes.
as like an exhibit that's a composite of a bunch of flyers?
I already did. I gave it, well, I didn't hand it to him. I gave it to the Honorable Mr. Wright, who I assume, because I know Mr. Wright has gone through it with his client. And then I have a hard copy and I have the thumb drive, by the way. For
And they go from, it looks like they start in September before September of 2014 and go through June of 2015. All right, you don't intend to display each one of these separately, do you? Because that's
I would try to get them into evidence and then use them at the appropriate time.
like a few, like a smattering,
That's what I think.
not 57 of them or however many there are. Okay.
Well, I was
I
going.
know. I mean, the jury will have a whatever inch thick
Yes.
composite exhibit to look at.
But I will only, yes, I'm not going to go through
In
every one
terms
of them.
of court time. Okay.
I will be.
All right. I'm going to overrule that.
So, Your Honor,
Yes.
the response that Mr. Steele gave regarding it showing that Mr. Williams has a show or he's busy at shows and he can't be on the corner selling drugs. One, these are flyers that he created. These are not photographs of Mr. Williams at the show. It doesn't even say
Yeah,
that
the
he went
point
to the
is,
show.
He should. Okay. Well, I mean, then I guess maybe you can make that argument, but he's got all of these things lined up on his schedule.
And then as to Defendant Williams' exhibit, and of course that would be, I guess, as the court says, subject to a proper foundation being laid, assuming he can even talk about these, but Exhibit 255 Bravo, Your Honor.
All right.
Is
so we're going to a different exhibit now?
Yes.
Okay.
It is. And would the court give us a number? Like, I know the court said a smattering, but is there a number? All of these flyers?
No, if you feel like he's getting beyond what's reasonable and that it's getting to be a waste of time, then you can make that objection and I will rule on it.
Yes, Your Honor.
Okay, let's look at 255. What's our issue with that?
So, Your Honor, 255 Bravo appears to be a collection of tweets from people that we do not know and have no knowledge of the identity of, saying and lie to their sister, baby, mama, and granny, and get on the stand and tell the God's honest truth. I just don't get it. These appear to be tweets from 2023,
yeah,
which are after Defendant Williams put his.
They look to me like they're from 2013.
I'm looking. I don't see. Okay, so. Okay, so as my team is telling me, as we look through them, some.
It's way more than one page. Okay.
So 2013 to 2024.
All right, we don't need the ones past when Mr. Sledge himself used the term.
And so, Your Honor, we have never
And how did-
disputed that anybody else said that Mr. Sledge, in his testimony, he said it's a saying that people say. I didn't argue with that because he said a lot of people say you lie to your mom, you lie to your sister. My question was, do they say you need to get killed?
Yeah.
So this is irrelevant, showing that somebody else says you lie to your mom, you lie to your sister.
Okay, but no, it goes beyond that though, because all of these also include, but tell the God on.
And tell the God's honest truth, right?
So that, yes, you can use some of those to show that, because you did ask him about all of that part, and it will be clear that none of these say, but then you need to be killed. So, all right.
So
we don't need
all of
anything
them,
past that though.
is he going to be putting in 12 pages of this?
I don't know how many pages there are that are before 2015, but I think you can probably establish that point with a couple of pages worth. All right. What
And-
else?
So the court is, as the court ruled earlier, at the point that state believes is cumulative, make
he's
that
gonna-
objection then.
When I say a couple of pages, I mean one or two or three. Because they're like 7 or 8 on each page, so that'll make the point.
And that's all prior to
I
2015.
just expect this, I know we haven't defined a smattering, but I've defined a couple now. So I expect Mr. Steele to abide by that. And then what else? Yes, all before whenever he used it. When did he use it?
2015,
Okay. So
January
yes.
2015.
Mr. Steele has,
Huh?
when did he use it?
July 2015, Mr. Sledge.
That's what Mr. Sledge used.
Yeah, that's what I'm asking.
Okay.
So what you use to demonstrate that it's in common parlance needs to all be before that. What else?
55 Bravo is this, wait, that's the one we just.
That's what we just were looking at, I think.
So 255 Alpha is the same
Okay.
thing apparently?
That's the one with all of the flyers for, yeah, we've done that one.
So no, 255 Alpha literally is another 32 pages of tweets.
Oh, 255. Okay, I'm sorry.
Is a PDF, a 32-page PDF
We don't need that, right?
of
The same thing.
the same
All right,
thing.
Mr. Steele, we don't need 255 Alpha and Bravo, right? Okay.
A couple of pages through there.
With 2 or 3 pages showing that. Okay. All right, what's next?
Is the same ruling in effect with respect to, and I think the court said it's smattering, I don't remember which one that applied to, with the wiping of the nose?
The
How many-
smattering was the flyers showing his
Okay.
shows.
Okay, so
He's
we-
gonna pick 2 or 3 from his exhibit A, I don't, or wherever they are, 15, whomever it is, I don't know whether you want to use famous people or non-famous people, but the ruling about singing the songs, those are just out. But people using the same kind of hand gestures, pick 3. I don't care what they are. Okay, so what else?
So Mr. Williams, for instance, on exhibit 34, if it's not already in, it's defendant Williams himself sitting there wiping his nose. And I think that might already be in. So I'm not sure if that's one that is being offered now, but for the ones that are not already in evidence, is the court's ruling that 2 or 3 other people that are not him who are wiping their nose are what will be allowed?
Wiping their nose, or if it's some other hand sign, just 2 or 3 things, 2 or 3 of these to demonstrate, whoever the other people in the world do this to.
And Your Honor,
I don't know that it's going to establish anything because this is 10 years after we have heard that YSL, which might be or might not be a gang, was created, but.
so Your Honor, and we would ask as well, because I've seen, I'm not saying anyone in particular, but we would ask that reference to what is contained in the picture, for instance, do you recognize LeBron James wiping his nose? Not be made until it is established whether the witness on the stand, who is supposed to be the witness through whom it is entered, can establish whether they've seen it, know what
Yeah,
it
it's
is.
not, do you recognize LeBron James wiping his nose? It's, are you familiar with this? Have you seen this before in your life?
And given that Mr. Steele has already given Mr. Wright the exhibits, the answer will be, yeah, I've seen it.
Well, the fact that I think Mr. Steele probably knows how to handle a witness well enough to lay the foundation properly.
I'm just asking based on
If
what
you
has
want to
happened
then
so
get up
far.
and ask, never mind, I'm not even going to suggest that. Okay, so Are we clear on that? He can ask before today. What else?
Think that the videos of people lip syncing, the wiping of the nose, and the tweets about lying to your mama and telling the truth in court are the only 3 categories.
Okay.
And so since there are so many, I think we've covered
All right.
that. We'll look at it
All right.
closer
And
at
then we've
lunch.
got the proposed exhibit from Mr. Huey. Is there an issue with that? I haven't looked at that yet, but
So we don't object to the whole thing coming in, but I believe Mr. Matthews has indicated he wants to take the the writing off. But if
I don't know what the writing says. And who are these people in this exhibit?
Yes, Your Honor, that would be Chanel Drinks.
Okay.
This
When they
would-
need to come
okay,
in
we go.
here. Yes, and
1 second, Your Honor.
talking to your mic. Okay, well, all right.
to be
Hang on,
fair
let's
to
not, let's let them finish whatever and then get back on the same page all at the same time. decision. So we can all eat lunch too. And so that your clients can eat lunch. Well, then we're gonna need to come back early. So that's fine, but let's come, I'm gonna give us a half an hour and we'll be back at 1:15, okay? So that we don't keep the jury waiting any longer than we already have today. Can't you get to there to do that?
Okay, guys, I'm about to play this video from it just goes to the point that Max was making. So hold on. This is a clip from the final plea hearing of the other defendant.
Copy of that email as well. Ms.
Yes,
Hilton?
yes, Your Honor. It looks like, are you here?
I am, Your Honor. My name is Attorney Kareem Cashman. I've been the
Would you get on a microphone for us, sir? And would you come on, man? You know, I'm trying to do the best we can. Yeah. All right, that's fine. We will see what's what. All right. All right. Yes, sir.
Good morning, Judge. As I was saying, my name is Attorney Kareem Cashman. I'm the newly appointed attorney for Mr. Cobb.
This is Mr. Cobb.
This is Mr. Fleetwood.
Well, that's half the issue.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
Your Honor, it appears that Mr. Luemba is the attorney on position number 5 and number 8, who would have been Justin Cobb. And so it appears that Ms. Cobb, okay, sorry.
Okay, well, we haven't got to him yet, so you can have your seat, okay? All right. Your attorney that's assigned to you, now whether or not y'all have had any in-depth discussions or all of those kinds of things, I hear what you're saying and you're indicating that you don't even know who they are. And I appreciate what you're saying, all right? He isn't here today, so we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the, whatever the name of that organization is, that I never can get these initial kinds of things straight, but when a request is made for an attorney to be appointed to represent the defendant, it takes forever for them to get somebody and put them in place, which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare to handle a particular cases. This case has been going on so long, certain defendants may have had one attorney, then somebody left the PD's office, or somebody left the Georgia, whatever they call them, Council of Defense Lawyers or whatever it is. And then somebody else has to be appointed and then come up to speed and all of those kinds of things. Well, that's what we're dealing with. So.
Okay. So guys, I just want to tell you who is just joining us. This is the YSL trial. See someone say this is not the YSL trial. This speaks to, I mean, it says it right here. Young Thug trial. This speaks to Attorney Sharp's point. This hearing was on June 28th of this year. So it definitely goes to his point that this could have been a motivating factor for Antonio Sledge to take a plea. He knew he couldn't hire an attorney right through trial. He watched the other people, other co-defendants that were severed sit without attorneys. This was June 28th. So just 2 months ago, and this case has been going on since 2022. So I think that Max is absolutely correct in his line of questioning. And then you got a lawyer that gets up and says the wrong person's name. He doesn't even know who he's there to represent. And I'm not blaming him. I'm just saying I actually accept appointments from the Georgia Public Defender Council. I take court-appointed cases. That's all I do. All I do is court-appointed cases. I don't take a lot of criminal cases. But when I do, most of them are court-appointed through the agency that Judge Dempsey is talking about. And I've been appointed to 2 people on one case before. There are situations where that has happened and I have to say, hey, I represent this person. You know, they find another attorney. But at the end of the day, this was just a little over 2 months ago. So everybody didn't have a lawyer. And I'm just going to play this one more time if you guys don't mind.
Would you get on the microphone for us, sir? And would you come on, man? You know, I'm trying to do the best we can. Yeah. All right, that's fine.
I'm going to answer this, okay?
We will see what's what. All right. All right. Yes, sir.
Good morning, Judge. As I was saying, my name is Attorney Kareem Cashlin. I'm the newly appointed attorney for Mr. Cobb.
This is Mr. Fleetwood.
Well, that's half the issue.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
It appears that Mr. Luemba is the attorney on position number 5 and number 8, who would have been Justin Cobb. And so it appears that Ms. Cobb, okay, sorry.
Okay, well, we haven't got to him yet, so you can have your seat, okay? All right. Your attorney is assigned to you. Now, whether or not y'all have had any in-depth discussions or all of those kinds of things, I hear what you're saying, and you're indicating that you don't even know who they are. And I appreciate what you're saying. All right. He isn't here today. So we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the whatever the name of that organization is that I never can get these initial kinds of things straight. But when a request is made for an attorney to be appointed to represent a defendant, it takes forever for them to get somebody and put them in place, which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare to handle a particular cases. This case has been going on so long that certain defendants may have had one attorney, then somebody left the PD's office, or somebody left the Georgia, whatever they call them, Council of Defense Lawyers, or whatever it is, and then somebody else has to be appointed and then come up to speed and all of those kinds of things. Well, that's what we're dealing with. So what we do is the best we can do. So if somebody hadn't had a chance to adequately prepare, or they aren't properly representing their client, then we do what we need to do to make sure that that doesn't affect the ultimate result of the case. So he's not here today because he has a legitimate emergency. Now, whether or not he's talked with you, met with you, or prepared with you previously, I can't deal with that, and I have no reason to doubt what you're saying. But as far as what we can do today.
And then the fact that they're saying that he may not have even ever met with him, he may not have, I mean, I'm not going to lie to you guys. Back to this question. I have a serious question, Kayla. Do you fight hard for your people even though you're court appointed? My whole thing is, I'm going to be honest with you. I treat everybody the same. Your reputation precedes you. So I have a lot of clients who, for lack of better words, they don't like my style, because one thing about it is I'm not going to run back and forth to the jail if I don't have anything to tell you. But it's like one of those things where I might not show up when you want me to, but when I show up, I show up. I have a lot of clients who, in the beginning, we start off, we may be on rocky terms, but by the end or by the resolution of their case, they're satisfied. I can count on my hands how many times someone has not been satisfied with the result or the disposition in their case. And so I fight hard for everyone, because I never know if this public defender appointment can lead to $1 million trucking accident, because they're going to remember how I treated them. And not just to say it's about that, but that is a big part of growing your business, maintaining your reputation, maintaining your business is 100% based on how you treat people. Okay. 1 second. And yes, I've been to trial. Right now, while we are on break, let me get some members, some super chats, and I'll be right back. Private attorneys can take court-appointed cases. Oftentimes, there are conflicts within the public defender's office, where if the public defender's office has represented a victim or a co-defendant previously, they cannot represent another co-defendant. So they have to have outside counsel or court-appointed attorneys come in, because as you guys know, that we all have a constitutional right to have an attorney, and if you cannot afford one, to have an attorney appointed to you. So that is how that goes. Thank you. I just blocked someone and banned them. Hi, everybody. And I'll say this also about public defenders. I think that public defenders sometimes, well, a lot of times are better lawyers than they get credit for. Public defenders often are assigned to the same judge every day. So they get to go to court, they get to be familiar with the judge, they get to be familiar with everyone in the courtroom, and they get to practice law a lot more than most private attorneys, because most public defenders have hundreds of cases. So there are a lot of times when I have even asked a public defender, like I say, there are certain public defenders that when I'm on a court appointed case with the co-defendants, I will adopt all of their motions because I know they're great. Okay, hold on, guys. Let's see if I can pull this up for you guys. December. Let's see. Can't find it, guys. Let me see if I can. This is a good question. Ooh. This is a situational question. This is how I feel as a criminal defense attorney. I feel like there is, okay, so now I'm on the stand like Sledge says. So the difference to me between, I guess this is what I say. I say if you are involved in a crime and you know what's going on and there are proceeds that you gain, or whether or not there are proceeds, but you know what's going on. You drive somebody, you walk with somebody. I don't think it's appropriate for you to tell. However, I feel like if I'm driving my friend somewhere and they're my friend and they don't tell me, they just say, take me to the bank, but they don't tell me they're robbing a bank, I think you have a right to tell. And I think that is way different. Now, if you are involved, you have any knowledge, have any level of participation, I don't advise that you cooperate with the state. But if you have no knowledge and you just doing your thing, moving differently, and you're facing 15 years, 20 years, baby, you might want to have a conversation. So that's my stance on it. Also, I feel like there's a difference when I have a case right now and the state is asking for proffer, and all of the co-defendants have told on my client. They have all told some version of a story on my client because they were all together, but the 3 co-defendants know each other. And they told, so I think once you get in this realm of he said, she said, I mean, sometimes you do have to work with the state. I mean, I think now I'm at the point where my client's best interest is what I have to protect. And generally speaking, I don't allow my clients to give proffers, or not say allow, advise. However, there is, like someone said, it's circumstantial. Thank you so much, Casey. Thank you. Would you have allowed your client to sign the plea deal giving to Sledge? So this case is very different. And one thing that I can say about this case, I can't speak exactly to what evidence, what discovery there is in this case. So I don't know what evidence they had against Mr. Sledge. So I don't know what he was up against. I know how much time he was facing. However, in this case, based off of how this is going, I would never advise anybody to take a plea on this case. Right at that point. Now, where we are right now and what's going on, if everybody took a plea, that would be different. But I can't say at that stage in the game, I would have advised my client to take a plea. But at the end of the day, who wants to sit in jail? Who wants to sit in jail? I mean, but that's when you have to make a decision. And that's what I tell my clients all the time. Life is about choices. Life is about decisions. And specifically in this case, I feel like you don't get to benefit for 10 years from someone, and then when it comes down to the wire, this is what you do. That's my personal opinion. These guys have benefited from a situation for years, and now this is what, I mean, I know it doesn't feel good to anyone. It doesn't feel good to the young man sitting in the courtroom. I know it doesn't feel good to him, but everybody made a decision. Everybody, and when you made that decision to get out of jail, and I honestly feel like if you benefited for 10 plus years off a situation, why you can't sit down for 2? That's how I feel, but I'm different. And now you want to, not, I don't know. I'm looking at it from like a legal perspective, but from my client's perspective, and I told everybody, and I tell everybody, you don't get to throw rocks and hide your hands. You chose to, hey, we went over the plea deal yesterday. But it's a tough decision to make, because then you have to pick, hey, do I pick my kids or do I pick my friends? Do I pick blood brothers or do I pick the children I created? And if someone needs a PI attorney, I see someone needs a PI attorney in Cali. I got somebody for you, Miss J, whoever that is. Let's see. Yeah, I think these are all good things for appeal. All these will be addressed on appeal. All this can be addressed on appeal. That's all I can say. I mean, there's nothing that can be done right now. It all can be addressed on appeal.
The end of this trial, Mr. Williams will be withdrawing. So if there's going to be a the adjustment to the contract, new contract, whatever you would like, the terms of payment will be $5,000 a month through the duration of the trial. Now, if this trial ends in a mistrial and you're going to schedule another one, the end of this trial, Mr. Williams will be withdrawing. So if there's going to be a whole other one, new attorney, that's on them. But for the duration of this trial will be $5,000 a month. Did I get that right?
Yes, Your Honor. We still, would want her to formally go through the process of withdrawing as.
I'm doing a poll, guys. I really want to know. Okay, let's go.
As an attorney would, we are just telling her that, typically our expectation of any private attorney is that they stay with the case throughout the duration of the case, regardless of if there's a mistrial, that they would stay on. We understand in her particular circumstances, we're not going to object or have any issue with her withdrawing once this trial is completed, if that's what she wants to do, and her client's okay with that.
Yeah, of course, there's some other variables that need to be addressed, so we can cross that bridge when if we get to it.
And there was one other thing that Ms. Glazer and I were discussing, that we're giving you what we agree upon today.
Okay.
One thing I'm still discussing, is, as in the statute, GPDC can come to the county and ask for additional money. That for perhaps some of the parts of the trial where it would be extremely beneficial for Mr. Williams to have another attorney with her, if the GPDC at that point would be willing to ask the county to step in. And it would be up to you all. You said, no, yes, no, that's up to you guys, but they would ask for that. And we've not been able to agree upon whether they would be willing to make that we will request portion of the agreement.
Yeah, I mean, we can certainly look at that. That's, of course, through Superior Court Administration, and it's not in the realm of a reality for an ask, because as you all pointed out, Mr. Williams is the only attorney on representing Mr. Ryan, and that poses some challenges in and of itself. And this case has gone on a while. It's not a marathon. It's not a sprint, it's a marathon. So yeah, so you do need to kind of, I could see some situations where it would be helpful for her to have some support. Okay. So if that's something you all wish to explore, we certainly, from the Superior Court side of the administration, we'll certainly see what we can do to facilitate that.
Yes, Your Honor.
And I will tell you, Your Honor, that we were just saying we're not committing to anything as far as that wasn't something that we had resolved necessarily. We are going to have a separate conversation with Mr. Williams after court as far as what support we can potentially provide outside of what we're agreeing to today.
Yeah, okay, that's fine.
Yeah, that's just an additional thing we are discussing. We have put on the record what is agreed upon.
So what you've agreed upon, just to make sure I understand, is that you will reform the contract to reflect your understanding that it's $55,000.
We're actually going to pay an additional. We're going to have it be worth $5,000 a month regardless. It will actually be, I think it's $60,000 instead cap, just so that there's no disruption of payment. We want to make sure that she continues to be paid. So we are going to reform the contract to make it clear what the original intention was, but to make sure she is paid that $5,000 every month.
And then there's a renewal, and you include the renewal provision that
it will be through the duration of the trial.
Yes.
Okay, all right. So that you'll make it clear.
Yes.
As to the understanding of both parties.
And when that contract is agreed and reached, we will provide it to the court and ask that it be made an exhibit. Part of the court's exhibits.
All right.
All right, and I think that this basically just goes back to what Attorney Sharp is saying. So let's say, even whether you feel $5,000 is enough or not enough, What person do you know that can pay all of their bills and still pay an attorney $5,000 a month? And we've been on trial 19 months. How? And a lot of you guys are saying 5,000 is not a lot, but what if she was making 15,000 a month or 10,000 a month or 6,000 a month and she has to come here every day? She can't have any new cases. Who knows how many hours she's working on her other cases after she leaves the courtroom? And also, guys, remember, her client is currently serving a life sentence. So, I mean, what do you guys want her to say? And speaking of that, let me go. Let me see. I'm going to show y'all this. For those of y'all who have not seen this, a lot of you guys who follow the case probably have seen this. But speaking of Rod, let's see. This right here is a picture of Lil Rod. And do you guys see 11 years old on 2015? I mean, so he was 11 when Nut was killed. 11. It's crazy. We aren't back yet. We should be back soon. I think we got 7 minutes, guys. So I'm gonna take 5 minutes and regroup. See you guys in 5 minutes. Looks like we may be back.
Have y'all had an opportunity to determine for the defense what that exhibit's gonna look like?
Your Honor, that exhibit is going to be introduced at a later stage.
Okay. All right, anything else before we get the jury in? Okay. So we good then to go ahead and get the jury back if they're ready? Okay. So we're good then? Can we get Mr. Sledge back in? All right.
395, thank you.
Yeah.
Mr. Sledge, can I just see that for 1 second?
Which? Which are we talking about?
One AS.
I've been trying to. Your Honor, I was under the impression that this plea agreement, Mr. Sledge's plea agreement, had been admitted in evidence. But I think I was just basing on the fact that it had a exhibit sticker, which now
That says what, A1A? No, it's neither that or
Correct.
444Y is in evidence. That has an exhibit sticker because that's the exhibit sticker from
Previously.
the actual plea
okay.
proceedings.
Okay, all right.
And it has the AS because it was for Antonio.
Right,
Sledge.
it hadn't been tendered,
Okay.
neither of those, neither it nor the 444Y has been tendered for admission here. Was it 444Y?
444Y, right?
That's
It
what
not
she was
tendered.
using before, and she had him compare the two. Right. But it's not in either.
Okay.
It's a copy.
What is the video?
The video is 442Y.
Thank you.
And that's the one that's just the portions.
Right, and that's
Yeah.
been admitted.
Yes. We're ready.
I'm catching up.
It's a lot of numbers.
Thank you. You're talking about the numbers, John? Okay.
We'll figure it out later.
Okay, thank you.
All right, go ahead, Mr. Sharp.
Thank you, Your Honor. May it please the court. Good afternoon, Mr. Sledge.
Good afternoon, Mr. Sharp.
All right. We had just, last thing I asked you was about your representation. Do you recall?
Yes,
Okay, and that you had not hired Mr. Wright for trial.
no,
On December 28th, 2022, okay, you were aware that, well, let me back up. Typically, have you ever had appointed counsel?
Objection relevant.
Just trying to educate on how it usually works. I'll move on. Okay.
Okay.
On December 28th, 2022, you were aware of co-defendants on this case who had been arrested.
Yes,
And there were some of those individuals who could not afford attorneys, correct?
right,
And you were aware that some of those individuals were in Rice Street,
yes,
or they were in Rice Street,
yes,
and those individuals that could not afford attorneys had not been appointed attorneys as of December 28th, 2022, correct?
yes,
Okay. And isn't it true that you did not want to be in their position?
yes,
Meaning you did not want to be in Rice Street without an attorney?
yes,
Okay. You believed, for the purposes of having representation, it was in your best interest to resolve your case via plea on December 28, 2022.
yes.
Do you know what coercion means?
No,
Okay. What about pressure?
yes, I know what pressure means.
Okay. Being in, and this is your truth, I'm not asking for a legal definition, okay?
Yes,
Okay. Being in Rice Street for 7 months prior to your plea, did that put pressure on you to accept this deal?
yes, a lot.
Okay. Being separated from your sick mother and your children.
Your Honor, I object. This line of questioning is already been so asking you.
Your Honor, he testified for 3 days already. I've been going for 10 minutes.
Yeah, but you did already ask him that.
Well, I'm just trying to conclude this line of questioning, then I'll move on.
Okay.
I haven't asked him about pressure yet.
No.
He wanted to go home, and now I'm asking about
Okay.
pressure. Being separated from your sick mother and your children, did that create pressure to plead guilty on December 28, 2015?
Yes,
Excuse me, December 28, 2022.
yes,
And the fact that you did not have a lawyer for trial, did that create pressure on you?
Yes. Fact,
Asked and answered, relative of non.
how about facts not in evidence too?
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty?
Object, that is true fact, not in evidence. And it also calls for speculation.
Overruled.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty on December 28, 2022?
yes,
All right, I want to talk to you about the plea offer. And when you need to, you can refer to it, but I want you to listen to my questions, and if you can answer without, that's fine.
yes,
Okay. At some point in late December 2022, you became aware that the state was making a plea offer in your case.
yes,
Okay. And the state's plea offer was an offer for probation.
yes,
Okay. And probation, I know we know what it is, but for the jury, probation is you don't have to be in custody, right? You're released.
yes,
Okay. And you have to check in with a probation officer.
yes,
In your mind, that's preferable to prison.
yes,
That's preferable to sitting in Rice Street jail, correct?
yes,
Okay. Probation would get you back to your family,
yes,
get you back to your ill mother,
yes,
and that would solve your issues as far as hiring an attorney to try the case.
Yes.
You were interested in a plea for probation.
Yes.
Now, as it turned out, there were factual acknowledgements that you would have to initial to receive that offer of probation, correct?
Yes.
Okay, when you first learned about probation, did you realize that there would be factual acknowledgements that you had to initial?
No.
Okay, but at some point, your attorney told you to get this probation, you're going to have to agree to factual acknowledgements.
Yes.
Let's talk about the factual acknowledgements. Do you remember the first time you saw the factual acknowledgements on that plea form? Was it December 28th?
Yes, I want to say yes.
Okay. Could it have been earlier? To the best of your recollection.
Yes, I think if I'm not mistaken, yes.
Okay. Did you ever write a statement with your truth about what happened in 2015 and give it to Ms. Love or any other prosecutor in this case?
Objection vague as to your truth and what had happened in 2015, vague overall.
Did you say 2015?
I did. About what this case is about. Did you ever write a statement?
Oh, about, not in 2015.
No, about 2015.
Overruled.
No.
Okay. Did you ever sit down with Miss Love before this plea?
No.
Okay. Did you write the factual acknowledgements?
No.
Okay. On that sheet of paper in front of you, I believe it has, do you know what letterhead is?
I think it's the stamp, something like that.
Okay, on the top of the paper.
Yes.
Is there letterhead that indicates whose office that paper is from?
It's a Fannie Wilson. That what you're talking about, right?
Yes.
Yes.
Okay, from the Fulton County District Attorney's Office?
Yes.
Okay. Do you know who wrote the factual acknowledgements?
No.
Okay. Who presented the factual acknowledgements to you? Was it Miss Love?
Yes.
Okay. Did you know Miss Love back in 2015?
No.
Was she hanging out with you in 2015?
No.
Okay. I'm not trying to embarrass you. You're a smart man, okay?
Right.
But you did indicate that you didn't know what the word notoriety means.
Yes.
And you've also just said you didn't know what the word coercion means.
Yes.
Okay. Could you look on that in that document with the factual acknowledgements? Should be page 3. I'm going to ask you to look at factual acknowledgement 1. On the last line, does it have the word notoriety?
Yes.
Okay. I'm going to look at factual acknowledgement 5 on the last line. Does it say notoriety?
It's on 5.
Yes.
Yes.
I'm going to ask you to look at number 16. On the third line down, on 16, does that say notoriety?
Give me 1 second. You said on what line?
The third one down on number 16. That's page 5.
Yeah, I'm on page 5.
Okay.
Yes.
All right. Could you go to page 6 and look at the last word on page 6? Does it say coercion?
Yes.
And those are words to this day, I guess before this trial maybe, that you never knew the meaning of.
Still don't know the meaning of them.
Okay. Do you write sentences using words that you don't know the meaning of?
Objection, Your Honor. Relevance.
Sustained.
Now, in preparation of your plea, whether it was on December 28th or before that, you did speak to your attorney, Mr. Wright,
Yes.
about the acknowledgements,
Yes.
correct?
Yes.
And you brought certain acknowledgements that are on that sheet to the attention of Mr. Wright and told him you don't agree with those.
Yes.
Okay. And were you present for discussions that Mr. Wright had with Ms. Love or the state?
No.
Okay. But to your understanding, some of the acknowledgements that you did not agree with, the state refused to change, correct?
Yes.
Okay. And you wanted to go home.
Yes.
Did you let a disagreement with those acknowledgements stop you from getting home to your sick mother?
Objection, speculation, and.
I said, did you let?
Objection as to the form of the question, whether did he let that? Objection.
Can you rephrase your question?
Those disagreements with the acknowledgements, did you let those disagreements get in the way of you getting home to your sick mother?
No.
Objection, Your Honor.
I mean, you basically asked the same thing, the same way. You just moved the phrasing around. I don't really know. Can you rephrase it again?
Okay. Can I break it up?
You
Okay.
can try.
You disagreed with some of the factual acknowledgements that Ms. Love presented to you, correct?
Yes.
Okay. And you brought that to your attorney's attention.
Yes.
And you were told that the state was not going to change those factual acknowledgements.
Yes.
Okay. On December 28th, 2022, did you let your disagreement with the factual acknowledgements stop you from entering that plea?
No.
Why not?
Because I wanted to go home to my sick mother.
You have, during direct testimony, when Ms. Love was asking you questions, you've stated that you disagree with several of the factual acknowledgements in this plea agreement that you
Yes.
signed, correct?
Yes.
You watched the video of your plea earlier today, correct?
Yes.
Okay. Those acknowledgements on that video, who was reading those acknowledgements? Was it you or Miss Love?
Miss Love.
Okay. When you were saying yes, ma'am, do you remember that? To
Yes.
pretty much every question, is that fair?
Yes.
Weren't there times during that plea, during that video, where you were saying yes, ma'am, before Miss Love even asked a question?
Yes.
Why were you saying yes, ma'am, if you disagreed with the factual acknowledgements?
I was just trying to get home to my sick mother.
Okay. Did your attorney tell you, or you testified that your attorney told you that you could explain those disagreements later, correct?
If I was called into the stand, yes,
Okay. And you were advised not to let those disagreements get in the way of going home, correct?
Objection, Your Honor. Objection as to attorney-client privilege, objection as to hearsay, objection as to an improper line of questioning, to an improper topic.
Okay, sustained on facts not in evidence.
Okay. When you came to testify in front of this jury, you were under the impression that you would be able to explain what you disagreed with, correct?
yes,
Do you know the saying, you're between a rock and a hard place?
yes, I heard of them.
Okay. Do you consider yourself in between a rock and a hard place right now?
Yeah, yes,
Okay. The rock is that you know some of these things in this plea agreement aren't true, correct?
yes,
The hard place is you don't want to go back to prison, do you?
yes.
Yes, you do not want to go
I
back.
don't want to go back to prison.
Okay. And the problem is your plea agreement, correct?
Yes,
Let's talk about this plea agreement. In this indictment, you were charged with 2 counts, correct?
yes,
Count 1, RICO,
yes,
or conspiracy to commit RICO, I should say.
yes,
And count 30 was a gun charge, correct?
yes,
Specifically, possession of a firearm by a convicted felon.
yes,
For count 1, let's talk about that, what the plea agreement was, okay?
yes,
The agreement, if you initialed the factual acknowledgements and entered a plea, the agreement was that the state was going to recommend 15 years of probation.
yes,
And that meant that you would get out of jail immediately.
yes,
I'm going to ask you to look at Part 5 of the plea agreement, number 2, under defendant's sentencing acknowledgements.
What page is that, Mr. Shaw?
That is page 5.
Okay. And what number?
It's number 2 under section 5.
Yes, I'm looking at it.
Your agreement states that defendant, that's you, right?
Yes,
Okay. Defendant understands fully that if he violates any provision or any special condition of the plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections. And in parentheses, it says prison. Is that accurate?
yes,
Okay, so let's break that down a little bit. You're aware that a condition of your plea is to testify consistently with the factual acknowledgements you signed
yes,
that you say are not true.
yes,
And according to this agreement, if you fail to testify consistently with those acknowledgements, the state can move to revoke your probation, correct?
yes.
Do you know what revoking probation is?
Yeah, I think take it back, send you the, however, take the probation back, Revoke it and send you to prison.
Okay, so if you have 15 years remaining on probation,
Yes,
the state can bring a motion and ask the judge to send you to prison for those 15 years instead of being on probation, correct?
yes.
Okay. Let's talk about the agreement for count 30, possession of a firearm by a convicted felon. Okay. Your lawyer told you that count,
Sustained.
you were aware that that count carries a mandatory 15 years in prison,
Yes,
and that 15-year sentence needs to be consecutive to any other sentence that you have.
yes,
So it'd have to be 15 on top of the 15.
yes.
On page 1, under negotiated sentence, it says, where it says count 30,
You said page 1?
yes, page 1, sir.
Okay. Yes,
It says for count 30, that was the possession of firearm by a convicted felon, correct?
yes,
Okay. It says sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant, that's you, right,
yes,
has complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees the defendant shall be allowed to withdraw his plea on count 30, and the state shall agree to no pros count 30. That's what it says, right?
yes,
Okay, so let's talk about what your understanding of what this means. On December 28, 2022, you pled guilty to possession of a firearm by a convicted felon.
yes,
Okay. And under normal circumstances, that would be 15 years in prison consecutive.
yes,
Okay. But the state in this agreement allowed sentencing was withheld, correct?
yes,
So you weren't, even though you pled guilty to count 30, you were not given a sentence.
yes,
You were not given 15 years to serve in prison.
yes,
And sentencing was withheld until after this trial.
yes,
Okay. And your understanding is if you testify in accordance with this plea agreement, the state will dismiss that case.
yes,
Even though you've already pled guilty to it, the state will go back, let you withdraw your guilty plea, and dismiss the case.
yes,
You've been in trouble before, right?
yes.
Okay, you ever have an agreement, a situation like this in any of your other cases?
Sustained.
I'm going to ask you to look at part 5, number 4. Okay, and that's under defendant's sentencing acknowledgements. You with me?
Yes, I'm with you.
It's on page 6, right?
Yeah, 6, 7, yeah, I'm with you.
Okay. Number 4 says, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in his plea agreement, such failure or refusal nullifies. Do you know what nullifies means?
No.
Okay. It says nullifies though, right?
Yes, it say that, but I don't know what it means.
Nullifies any promise made by the district attorney to no pros count 30 of this indictment. Right?
Yes,
And to your understanding, regardless of whether you know what nullifies means, if you don't testify consistently with the factual acknowledgements that the state wrote,
yes,
they will take back their promise to dismiss count 30, and you'll be sentenced.
Yes,
And you have to get 15 years in prison,
yes,
consecutive to the probation that would be revoked.
yes.
Can you look at number 3 under section 5? So I'm on page 5 now, going into page 6.
I'm with you.
Says defendant understands fully that any violation or of any provision or any special condition of the plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law.
Yes,
All that on that video talking about he has to testify truthfully. In your mind, who gets to determine whether you testified truthfully or not?
Objection, relevant, and objection improper and vague. Who gets to determine?
He was about to answer. He knows what I'm asking.
It's a binary question whether it's true or not. But determining whether something is true is irrelevant.
It's
Rephrase your question.
who gets to revoke your who moves to revoke your probation if they're not happy with what you say here today?
Objection. Objection, Your Honor.
Unfair characterization. What is your objection?
One, yes, that.
I said who moves?
Relevance is not a fair characterization, and the terms of the agreement that Mr. Sledge entered into have already been put before the jury, and the characterization that is being made at this point is improper and not relevant.
Sustained on the improper part. You want to, if you want to try to rephrase it.
Have you, in your life, have you ever seen a defense attorney try to revoke someone's probation?
Sustained.
Can you go to section 5, number 5?
I'm with you.
Okay, and that's on page 7.
Yes, 6, 7. Right.
Excuse me, you're right, 6. Thank you. Says defendant understands fully that defendant's violation of the provision of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to no pros count 30 of this indictment and may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections / prison. So it says, right?
Yes.
Okay. We talked about 15 plus 15, that equals 30, right?
Right.
But in number 5, it's saying you're going to serve as much as 35 years.
Yes.
And even though that's an extra 5 years, you initialed it.
Yes.
Why did you initial it?
Because I wanted to get home to my mother.
Okay.
And I ain't understand whatever the words you've been using. I don't understand the words there.
That I'm using or that are in this document?
In the document, right.
I just want some clarity.
Yes.
You testified that you have a 9th grade education. You attended Southside High School, now Maynard Jackson High School, right?
Yes.
Okay. In the video, you said 10th grade. Is it 9th or 10th or you?
I was actually trying to say I completed the 9th, but I was in the 10th grade.
Okay. You ever receive any legal training?
No.
I'm going to ask you some questions, and I'm not asking what the acknowledgements say at this point, okay?
Yes.
Well, let me take that back for a second, okay?
Yes.
Just to make sure we're on the same page.
Yes.
Okay. Let's talk about the acknowledgement. Now, number 3 on the factual acknowledgement, it says on page 3. You with me?
Yeah, I'm with you.
All right. Now, you testified that this acknowledgement is in fact false, correct?
Yes.
Okay. I'm going to read the acknowledgement with you, and then we're going to talk about the truth, okay?
Yes.
All right. The acknowledgement says, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, wherein defendant brandished a weapon used to drive in a drive-by shooting, and wherein, on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, parentheses, girlfriend.
Yes.
Okay, that's what it says?
Yes.
And so you see where it says, and to support, in the first line, I'm just going to reiterate, and to support and express loyalty to YSL. It says that in there, right?
Yes.
And it says, on behalf of YSL.
Yes.
Okay. Let's talk about that. May I approach, Your Honor?
You may.
Mr. Sledge, I'm showing you a document marked DS-36.
Yes.
Okay. Do you see that there's 3 pictures in that document?
Yes.
Okay. Can you identify the 3 people in those pictures?
Me, Antonio Sledge, and Trevius Smith, and what is his name, Watson or Kevin Watson, whatever.
Kelvin Watts?
Yes.
Is that also Shell Kel?
Shell Kel, yes.
You also call him Kel?
Yes.
Okay. Your Honor, at this point, I would ask to admit DS-36 into evidence.
Submitted.
Permission to publish, Your Honor.
May.
Mr. Kokomo, would you please publish DS-36? Okay. Now, Mr. Sledge,
Yes.
we talked about how you're with a lady with the initials DB now, correct?
Yes.
Okay. Before DB, back in 2015, was there a young lady that you were involved with?
Yes.
Okay. And what was that young lady's name?
And Trevius Smith.
Okay. And what did you call her?
Treva.
Treva?
Yeah, Treva.
Treva. Okay. Do you see Treva in DS-36?
She at the top of the photo.
Okay. And do you see yourself in DS-36?
Right there to the left.
Okay. And who's the other gentleman in the bottom right on DS-36?
That's Kel.
Okay. Kelvin Watts?
Yes.
Okay. Do you recall when you started, how would you describe in respectful terms your relationship with Miss Entrevia Smith?
How did I, at the time?
Yes.
It was great.
You cared about her.
Right.
Would you call her your girlfriend?
Yes.
Okay. When did you start dating, we'll say, Miss Smith?
I've been knowing her since probably like, I've been dating her since probably like 2009, but as the relationship, probably like 2013.
Okay, so by 2015, you'd been in a relationship with her for at least 2 years, maybe longer.
Yes.
And you've known her for 8 years at that point.
Yes.
9 years.
Yes.
At some point, did she start dating another man?
From my understanding, yes.
Okay, and who is that other man?
Kevin Watt.
Okay. And do you know, was she dating, and I'm not trying to embarrass you, was she dating you first or Kelvin Watts first?
Me.
Okay. Do you know from your vantage point when she started dating Kelvin Watts?
I don't know at the time when she started dating.
Okay. And when you found out that she was dating Kelvin Watts, did you immediately break up with her and say, no, I don't have anything to do with you? Or did you keep having a relationship with her?
We kept conversating.
Okay. Did the fact that you and Mr. Watts were simultaneously dating Miss Smith, did that create problems between you and Mr. Watts?
Yes.
Okay. Did that lead to an internet back and forth between you and Mr. Watts?
Yes.
At some point in 2015, did you hear that Mr. Watts was looking for you?
Yes.
And was all that revolving around your rivalry over Antrevia Smith?
Yes.
You remember when the state played a video of you and Mr. Zachary with guns?
Yes.
Okay. You said it was childish, right?
Yes.
And at this point, Your Honor, I would ask for the state to publish what's 441Y. It's either 441Y or 395Y. 441 Yankee, thank you. Could you publish that?
Little strip this ass nigga. When little strip this ass.
Okay, thank you.
Little strip this ass nigga. We ain't really going back and forth no nigga. We don't go. You little bitch ass nigga. I know who we hate. I'm everywhere. Yeah, fuck you nigga, Cam. Whoever else, nigga. Well, nigga. Nigga. Whoa. They said they ain't really going back.
Okay, thank you. All right. Back in 2015, were you a little bit emotional about the situation?
Yes.
Okay. And in that video, that was posted on the internet, correct?
Yes.
Did you post it on the internet?
I think me or Zachary posted one of us posted.
Okay. You intended for Mr. Watts to see the video.
Yes.
And in the video, you said you heard that Mr. Watts was looking for you, right?
Yes.
Okay. And you're in that video with guns.
Yes.
And you're in that video with Mr. Zachary.
Yes.
And that's Quindarius Zachary, right?
Yes.
Little D from Cleveland.
Yes.
Okay. And that is someone that you have known since he was little, right?
Yes.
You grew up together in the Capitol Homes neighborhood in Atlanta.
Yes.
Apartments.
Yes.
How far did you grow up from him?
How far did I grow up?
That was a horrible question. You guys were both living in the same apartment complex, right?
Yes.
Now you're older than him.
Yes.
And he was a little boy at that time, right?
Yes.
Okay, would you see him every day?
No, I wouldn't see him every day.
How often would you see him?
When I used to walk past his door to get to the basketball court, he'll be on the porch.
Okay, are you particularly close with him? Or were you back in
At that time?
Yes.
No.
In 2015, you weren't.
Oh, 2015, we were very close.
Okay. And in that video, did you ever hear anyone say YSL?
No.
Did you ever hear anyone say gang?
No.
Did you hear anyone say on behalf of?
No.
Okay. Did anyone tell you to make that video?
No.
That was your decision.
Yes.
And you made that video because you were mad at Kelvin Watts because he was running his mouth.
Yes.
Because y'all were dating the same woman.
Yes.
Okay. So let's go back to Factual Acknowledgement 3, which deals with this video. Says, again, it says, while associated with YSL and to support and express loyalty to YSL, did anything about making that video and talking junk to Kelvin Watts, did any of that video have to do anything with supporting and expressing loyalty to YSL?
No.
Okay. And then later on in Factual Acknowledgement 3, it says, and wherein on behalf of YSL, was there anything about that video that was done on behalf of YSL?
No.
Thank you. Okay. Let's talk about Factual Acknowledgement 5. Says, okay, let me back up. Factual Acknowledgement 4, let's look at that, and that's on page 3. You with me?
Yes.
All right. Says, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant, that's you, right?
Yes.
And fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video, referenced in part 3 of this section, targeting family members of a rival gang. Okay?
Yes.
All right. And then on number 5 of the Factual Acknowledgements, it says, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4, okay? Above, on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. See where it says that?
Yes.
Okay, and I'm just reading that. I'm not saying it's true.
You okay?
Okay. Okay, let's talk about that case. And that was 15 SC 138994.
Yes.
You were charged in that case, correct?
Yes.
Mr. Demekion Garlington was charged in that case, correct?
Yes.
And Mr. Quindarius Zachary was charged in that case, correct?
Yes.
No one else was charged in that case.
No.
And that night, April 28th, 2015, I believe you testified you were at the Club Crucial.
Yes.
And Demekion Garlington was at Club Crucial.
Yes.
And you didn't go together, right?
No.
But you both happened to be there.
Yes.
And you're friends with Demekion Garlington, or you were at that time?
Yes.
Okay. And at some point, well, let me ask you one other thing. There were some young ladies at the club that you knew as well, correct?
Yes.
Alexis Bryant was at the club, right?
Yes.
And a young lady named Summer Good was at the club.
Yes.
And Summer Good is the girlfriend of Quindarius Zachary.
Yes.
Okay. Quindarius Zachary was not at the club.
No.
Okay. But his girlfriend was.
Yes.
Okay. And you indicated that Demekion Garlington was jumped by certain individuals.
Yes.
Okay. You don't Did you observe the fight?
Not from the beginning, no.
Okay. On that date, did you know, while you were at the club, did you know who was jumping Demekion Garlington?
No.
Okay. Was this a major fight?
It was
Let me ask a better question, because
Okay.
that was vague.
Okay.
Was this the type of fight where people were punching and kicking Demekion Garlington?
Yes.
Okay, and there are a lot of people at Club Crucial, right?
Yes.
A lot of other people you knew.
Yes.
Okay. Demekion, you said you left the club without Demekion Garlington.
Yes.
Okay. But then you received a call from Demekion Garlington.
Yes.
And the reality is Demekion didn't have a car.
Yes.
Okay. You had a car.
Yes.
Right. So Demekion asked you to pick him up.
Yeah, he asked me to come back and pick him up. Yes.
Okay. Demekion was upset, correct?
Yes.
Was Demekion drinking that night?
I can't tell you if he was drinking that night. He probably wasn't even in the club that long. So I don't know if he was drinking.
You know if he was using drugs, popping pills, anything like that night?
Probably before he got there, but I didn't see him popping the pills.
Okay, were you drinking that night?
Yeah, I was drunk.
You said you were drunk?
Yeah, I was drunk. Yeah, drunk. Yeah.
Okay. So Demekion is upset after getting jumped in the club, and he calls you to come pick him up. And you're drunk, and you think he might have been popping pills and don't know what else, right?
Yes.
Okay. Demekion had been publicly humiliated, right?
Yes.
When you guys were driving from the club, Summer Good and Alexis Bryant were following y'all's car, correct?
Yes.
They were leaving the club at the same time.
Yes.
And again, that Summer Good being Quindaria Zachary's girlfriend.
Yes.
Okay. And to your understanding, Summer Good was scared.
Yes.
Because people were following her car.
Objection, Judge, calls for speculation.
Sustained.
Okay, well, it was your car and Summer's car. Was there another car following behind y'all?
Yes.
Okay. And Quindarius Zachary, who wasn't in the club, was called about the situation, correct? Well, you went to pick up,
Sustained.
okay, you went to pick up Quindarius Zachary, right?
Yes.
Okay. And the purpose of you picking up Quindarius Zachary was to take him to the house where Summer Good was.
Yes.
To protect her.
Yes.
Your Honor, objection.
It's going to be, she knows the discovery. It's going to be completely obvious.
Well, I mean, it's happened at this point. Let's kind of get to whatever it is that you're trying to get to here.
Summer Good was at a house, at Alexis Bryant's house on Landrum Drive, correct?
Yes.
And you and Demekion Garlington, this is after the fight, picked up Quindarius Zachary and drove to that house on Landrum Drive.
Yes.
Where Summer Good was.
Yes.
Okay. And when you all arrived at that house, you saw someone shooting at that house.
Yes.
Shooting at the house that Summer Good and Alexis Bryant were in.
Yes.
You were driving the car, right?
Yes.
Not the car that was shooting. You saw a car shooting and you're driving in a car pulling up.
Yes.
You chased those people off that were shooting at the house, correct?
Yes.
Okay. at some point, and I think your testimony is that you don't know who they were, but one of the other individuals in the car, your car, determined who was shooting at the house that Summer Good was in, correct?
Yes,
And it was determined that you were to drive them to the house where those people stayed at.
could you repeat that? Cause I didn't understand.
I asked in a bad way. You're in the car, and it was determined, someone, not you, but someone felt they knew who was shooting at the house with Summer and Alexis, right?
Yes,
Okay. And then you ended up driving to a house.
I don't think I went to another house after that, Mr. Shaw. I'm not for sure.
Well, let me back up. In your testimony, you said your testimony was you drove Quindarius Zachary and Demekion Garlington to a house, right?
Yeah,
And they had guns.
Yes,
And they got out and did whatever they did to that house.
yes,
Okay. That wasn't the house that Summer Good and Alexis Bryant were in on Landrum.
no,
Okay, so after you saw that house, the first house where Alexis Bryant and Summer Good were being shot at, you drove to another house where Demekion and Quindarius did whatever they did. Right?
yes,
Okay. And you pled guilty to that.
yes.
You don't know who jumped Demekion Garlington.
No,
Okay. You drove to the first house on Landrum where Summer Good was because Quindarius Zachary wanted to protect his girlfriend.
yes,
And once you saw people shooting at the house, Demekion Garlington and Quindarius Zachary wanted revenge, right?
yes,
Quindarius Zachary wanted to go back at the people that were shooting at his girlfriend.
yes,
And Demekion Garlington wanted to go back at the people who he felt jumped him in the club.
yes,
Okay? That was personal revenge, correct?
yes,
In retrospect, you're 43 years old.
yes,
Okay? You know Quindarius Zachary since he was this big.
yes,
You know Demekion Garlington, I believe you knew him since he was a baby too, right?
yes,
Okay, in retrospect, you were the older person in the situation, correct?
yes,
You should have known better than to drive them anywhere, right?
yes,
Okay, but you did.
yes,
Okay, but the bottom line, and you pled guilty,
yes,
and you served your sentence.
yes,
The bottom line is Jeffrey Williams didn't instruct you to go drive to any houses at night.
no, Jeff wouldn't know nothing about it.
Okay.
Objection as to speculation about what someone else knew.
Sustained.
Ask that portion be stricken from the record.
Okay, you don't know what Jeffrey Williams knew on any given night, but he didn't order you to go to any house.
No, no,
Okay. And no one was out the window shooting guns, yelling, YSL, YSL.
Objection, compound question.
Overruled.
no,
The reality, Mr. Sledge, is what happened on April 28, 2015 was done on behalf of Demekion Garlington, who got jumped in the club.
yes,
Was done on behalf of Quindarius Zachary, whose girlfriend was getting shot at.
yes,
It was not done on behalf of YSL.
no,
It was not done to increase the notoriety, reputation, or fear of YSL, was it?
No.
Okay. The state asked you about, I'm on page 5, Mr. Sledge. Number 14 and 15. Okay. And I'm gonna read those in a second, but I just want to ask you some questions. Okay. We already established it. Did you grow up, Mr. Sledge?
Yes.
We'll get to that in a second.
Okay.
I want you to listen to my question. Okay.
Yes.
Thank you. You grew up. We've established that you lived in Capitol Homes. Did you grow up in Capitol Homes?
Yes.
Okay. In Capitol Homes, does that still exist, or has it been torn down by now?
They tore down, but they call something else now. Capitol Gateway or something like
Capitol
that.
Gateway.
Yes.
Okay. Could you help me understand what area of town, what street is Capitol Homes on?
Memorial Drive.
Okay, it's on Memorial Drive, maybe 5 minutes from this courthouse, right?
Yes.
Okay. They made it nicer now,
Yes.
but back then it was rough neighborhood, right?
Yes.
Okay. And then, how long did you live at Capitol Homes? To what age?
I don't remember exact how old I was, but whatever year they got tore down.
Were you a teenager or?
Yeah, I was a teenager.
Like,
I probably was grown.
so if you were a teenager, we're talking about 18, 19, not 13.
Yeah,
Okay.
yeah.
All right. And then you ended up living off of Boulevard, correct?
Yes.
Okay, did you go straight from Capitol Homes
To Boulevard.
to Boulevard? And when we say Boulevard, we're talking like the Bedford Pines?
Yeah, Bedford Pine Apartments.
Okay, those are right by the intersection of Boulevard and like North Avenue, right?
Yes.
Okay, great. East side of Atlanta.
Yes.
Okay, both these places, Capitol Homes and Boulevard, are, well, you tell me, how long do you think it would take to drive to Cleveland Avenue?
I can't give you an exact how long, but if my mind regular, probably about 15. Probably 15 minutes from Capitol Home, probably about 19 from Boulevard, 20 somewhere in there.
Okay. Bottom line, it's not the same neighborhood.
No.
Miles apart.
Miles apart.
Okay. Have you ever lived off of Cleveland Avenue?
Stay off of Cleveland Avenue.
Or on Cleveland Avenue, or stayed off of Cleveland Avenue?
Yes.
When was that?
I want to say it was probably like 2008, 2009, somewhere in that era.
Okay. And for how long? I'm not asking for exact address. You live off of in the Boulevard area now, right?
Yes.
Okay. So how long did you stay on Cleveland Avenue?
Not long. Well, my kids stayed over there, but I actually moved to Boulevard.
Okay.
But my kids and their mother still stayed over there, so I used to go over there.
Okay, so you used to go over there.
Yes.
And I'm asking you, okay, correct me if I'm wrong, did you ever formally live over there?
No.
Okay. Now, I hate to ask you this, but you've been a drug dealer before in your life, right?
Yes.
Okay, you have a history of, your criminal record reflects that, correct?
Yes.
Okay, you've been arrested for selling drugs downtown Atlanta.
Yes.
Okay, you've sold drugs in the past. We're talking about the past. Off of Boulevard.
Yes.
Okay, you've sold drugs around many areas of Atlanta, correct?
Yes.
Okay. You talked about hanging out in these gas stations. And you said, your testimony, as I recall it, was that sometimes you would hang out in the gas station with your own personal bag.
Yes,
And if people wanted a little bit off of your personal bag, you would sell it to them.
yes,
Okay. And you would hang out with Christian McMiller and Darius Ford.
yes,
Okay. Personal bag, we're talking about bag of marijuana?
yes,
Okay. And we're talking about if someone, for me, for instance, asked you, hey, can I buy some of that marijuana off of you? We're talking about $5, $10 type stuff, right?
yeah.
Okay. Petty.
Petty, yeah, some petty.
Okay. Do a lot of people sell drugs out of gas stations in your experience? Has foot traffic, right?
Objection, relevance as to whether or not a lot of people.
Sustained.
Have you sold drugs in gas stations before?
Yes,
Okay, you sold drugs in gas stations downtown, right?
yes,
It's relevant, Your Honor.
Overruled.
yes,
You sold drugs at gas stations off of Boulevard before, right?
yes,
Okay. And your testimony is that you would occasionally hang out at some gas stations on Cleveland Avenue with your personal bag of marijuana,
yes,
with your friends Big and Mac Mac.
yes.
Okay. Would you be there 24/7?
No,
Okay. How many times would you say total that you hung out at these gas stations? Is it more than a dozen?
yes,
More than 2 dozen?
yes, probably more, yeah. I pull up and just kick it and then leave.
Okay, when you say you would pull up and kick it and then leave, is it fair to say that you were not part of some complex drug distribution network in these gas stations?
No,
Okay, so when you would just kick it and leave, we're talking about you staying around for how many minutes?
sometime an hour less.
Okay. All right. And you say you thought, I want to get this right. You thought maybe more than a couple dozen, more than 25
Yeah,
times total.
Yeah.
Sometimes stay for like an hour.
yes,
You'd also hang out at the park,
yes,
hang out at other stores.
yes,
That's where the mother of at least one of your children lived.
yes,
Okay, that area, not the gas station.
yes, that area.
All right. And from your observation, and I know you don't want to speak on the dead, so I'm going to keep it brief. Your two friends would sell drugs at those gas stations.
Yes,
They'd sell drugs other places too, right?
yes.
Tell me about the time that you and Christian McMiller and Darius Ford pulled out AK-47s and chased everyone out of the parking lot to protect drug turf.
Never.
Okay. You just observed two people selling weed at a gas station before.
Yes,
Okay, let's go back to your factual acknowledgments that you signed on December 28, 2022. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL Associates sell drugs and do not allow other gangs to operate. Okay, now, it is true that in your mind, Darius Ford and Christian McMiller were YSL associates in your mind.
yes,
And they would sell drugs at these two gas stations, 151 Cleveland Avenue and 221 Cleveland Avenue, and a bunch of other places, correct?
yes,
Okay, but you haven't seen anyone do anything that would lead you to believe that They did not allow other gangs to operate in those gas stations, did you?
No,
No violence,
no,
no attacks.
no.
The factual acknowledgement that the video about Shell Kel had
Yes,
something to do with YSL, that was incorrect.
yes,
The factual acknowledgement that the shootings on April 28th, 2015 were done on behalf of YSL, that was incorrect.
yes,
The factual acknowledgements that YSL or YSL Associates do not allow other gangs to operate at these two gas stations, those were incorrect.
yes,
These money that you would make selling little $5, $10 bags, whatever, of marijuana, would you run to Jeffrey Williams and give him those $5 bills, $10 bills?
never,
Okay, would you run to Shannon Stillwell and give him the $5 and $10 bills?
never.
Mr. Sledge. I'm going to ask you to go to page 6 or 7 again. Okay, let me ask you, before you sign these documents on December 28th, you moved for bond on this case, correct?
Yes,
You moved for bond on October 13th, 2022, correct?
yes,
And the state opposed your bond, right?
yes,
They said that you were a danger to the community.
yes,
They said you were a threat,
yes,
and you were denied bond.
yes,
That kept you away from your family.
yes,
On the bottom of page 6, it says, the last sentence. I freely, knowingly, and voluntarily entered into this agreement without force, threat, or coercion. And we already said you didn't know what coercion meant.
yes,
Let's just say pressure.
yes,
That's not true, is it? You were pressured.
yes, I was pressured.
In fact, you were pressured into signing a document that claims that you're entering the agreement without pressure.
Yes,
We talked about that bond hearing before December 28th, where the state called you dangerous, too dangerous to release.
Objection, Your Honor, one fact's not in evidence, two improper.
He was
and
there.
three irrelevant.
He was there. Did they call you? It's not for the truth of the matter asserted, it's for the state's stance.
Objection, relevance. The state
It's
stands
very relevant.
regarding a bond matter for this witness has no relevance or bearing on the guilt or innocence of either of the defendants here.
No, it doesn't, but I don't think that's what he's offering it for.
I'm
I'll
not.
permit it.
They told you, they said to the judge that you were too dangerous to let go, right?
yes,
Okay. When you initialed these acknowledgements that they wrote, they gave you probation, right?
yes,
And then something came up.
And Your
Because
Honor, I'm sorry, I know that the objection needs to be at the same time, but as I thought about it, that was hearsay as well. What the state told him about his dangerousness or whatever being too dangerous.
I'm not saying
to
it's
let go.
dangerous.
Literally, the question was, did the state say that you were too dangerous to let go? That's hearsay. There is no, that's hearsay.
It's not for the truth of the matter asserted.
Overruled.
Again, they said, not saying you're dangerous. They said you were too dangerous to
Objection,
let go.
already asked and answered.
Well, I'm trying to recap because I keep getting interrupted.
Well, she's entitled to interrupt you if she thinks she's got a legitimate evidentiary objection.
Okay. After you initialed these documents next to the statements that they wrote, they gave you probation on count 1, right?
Yes.
Objection, asked and answered.
Okay, sustained.
And something came up in court because you pled guilty to count 30, but weren't being sentenced. You had to be given a bond on that in order to be released.
Yes.
And all of a sudden, on December 28th, after you initialed these statements, the state recommended a signature bond. Isn't that correct?
Yes.
A signature bond means you get released and you don't even have to pay any bond at all, right?
Yes.
Have you ever been able to figure out what made you so dangerous before December 28th?
Sustained.
I have no further questions. Thank you.
All right. Charity, I'll need a break before we move on to the next cross. Okay, let's take a 10-minute or so break. All right, we'll recess.
Okay, guys, so what do you think about Max's cross? I think that he had some really good points. I really like the point about the gas station, where a part of the plea agreement says that the gas station on Cleveland Ave, that YSL was controlling it. And he used a very good illustration of, well, I mean, like, how are they controlling it? Are they beating people up? Are they pulling out guns? So, like, how are they keeping other people from committing crimes there? That was a really, really good point to me. What do you guys think? What were some of your favorite parts? Let me know. We can talk about them. A plus, he talks about, he got right into it about how he would do anything to, Mr. Sledge would do anything to get out of jail, to take a plea. He brought up some good points about in the plea video, you were saying yes before she even, that's how eager you were to get out. This is a good point. He got a signature bond as a known gang member. And we know that he probably has a pretty good amount of criminal history because He said Mr. Wright, Attorney Wright, has been his attorney for 15 years. For 15 years. Let's see. This was a good highlight too. Really good point. Really good point. Sorry, now my phone is going crazy, guys. Sorry. This is funny. This is truly funny. I definitely need one. I need to go ahead and order it now. Order me some Hennessy now. I need Hennessy to be a sponsor. Everybody thinks Matt. Yes, and he definitely showed that the beef with Sledge and the alleged rival gang was really a personal beef, not a gang beef. Hold on, guys. I gotta take this call. Thank you for the super chat, guys. I had to wipe my nose. I'm having allergies. Like, I think me and my dog are having some kind of allergies. I hope I do not get a Rico. Because unlike Antonio Sledge, my nose was itching. I do not like Remy Martin. This is a good point. It's a good point. The state has taken advantage of these men, limited educational comprehension, and when someone like Sharp takes time to break it down to them, they realize they've been screwed. Hold on, guys. I gotta let my dogs out. Sorry about that, guys. Had to let the dogs out. So how long do you guys think that Cross is going to take? I saw someone put, and I put it up here, that redirect is going to take another week, but how long do you think Cross is going to take? You know, they don't get a lot of time. They get time management. And I wonder if it's because these are the state's witnesses. And hopefully when we get to the defense's witnesses, she'll do the same thing and she'll give them as much time, the defense as much time as they need with their witness, and then limit the state on Cross. We have to hope for the best. I don't know if they're going to send him back to jail. You guys keep saying, are they going to send him back to jail? I mean, who knows? They did put Mr. Copeland in jail, but you know, two different situations. One is a violation of a plea agreement. One is a violation of forced immunity. Wonder how long we are going to be on break for. And, you know, we'll go through the plea transcript again, but like when we went through it yesterday, and then even watching the video, you see that there are multiple times where Mr. Sledge is asked an answer and says he understands, and he understands the consequences of entering the guilty plea and what it required. Now, did he actually understand? Does not appear to be so. Does not appear to be so. Move. Sorry. This is a really good question. Kayla, when you have clients with limited education, what steps do you take to make sure they are really understanding the plea? Do you suggest to them getting their GED? Please drop your email again. Okay. So a lot of times when defendants do not have GEDs in taking a plea, most of the time, a requirement in the plea is for them to get their GED. But that doesn't help them right in the moment. What I really haven't had a client, I had Mr. Copeland, but I haven't had a client. A lot of my clients don't have GEDs, but I haven't had a client who says that they don't understand what's going on. I try to make sure I go over everything, but I can't say that, I would never be in Mr. Wright's situation. There are times, like I said yesterday, that this plea may have been in Sledge's best interest. Now, on a personal level, I don't know what the discovery was or what the evidence is against each person. But on a personal level, anybody in this case, I would not have taken a plea. I would not have. But Mr. Sledge is alleging that some of these questions were never, and some of these paragraphs were never even read to him. And that what else did he say, guys? He said some of them. Oh, and that he had proposed some of the subsections be changed, but the state did not agree to that. So, I don't know, but a lot of times in a non-negotiated plea, your back is against the wall, like Max said, between a rock and a hard place. Okay, we should be coming back soon. It's supposed to be Zachary, the little D from Cleveland. That is who's supposed to be next, I believe. We talked about this earlier. How much time we have? So this is how they can get in some of the statements. And actually, I'll make this big for you guys. As used in this code section, the term unavailable as a witness includes situations in which the declarant, and here we're going to say, is unable to be present or to testify at the hearing because of death or then existing physical or mental illness or infirmity. So it won't, some things will be able to come in. And the following shall not be excluded by the hearsay rule if the declarant is unavailable. So we already have the unavailability because of the death. And okay. Sorry guys, we're back.
All right, we ready for the witness and
Little
the jury?
D is not Woody's right hand man. That's Garland.
Yes.
This little D is Zachary, who we keep talking about today. One little D is Demikian Garlington, and one little D is Zachary, who's supposed to be the next witness up.
All right, can somebody get the jury for us? Thank you.
Okay.
Thank you. Is there other cross-examination of Mr. Sledge? All right, come on.
Good afternoon, sir.
Good afternoon.
I'd like to ask you, if you don't mind, to lock in on June 9th, Sunday, 2024, if you can. Do you remember being located at a Starbucks in Fayetteville, Georgia?
Yes.
And the gentleman who is seated in the first row here, the nice-looking young man in the who's now smiling, can you tell, ladies and gentlemen, Jerry, who that person is to you?
My attorney.
Okay, and he has a great reputation.
Yes.
And he's been with you, you said approximately 15 years. And when I say with you, representing you, and he knows you and your family personally.
Yes.
He has become a lawyer for you, but also a friend to you. Is that fair to say?
Yes.
And his name is the Honorable Derek Wright. Is that right?
Yes.
All right. And he was kind enough to put us on a Zoom call at my request. Do you remember that?
Yes.
And that was shortly after, in fact, it was later on Sunday, June 9th, 2024. Is that fair to say?
Yes.
And during that call, I identified myself as Mr. Jeffrey Williams' lawyer. Is that fair to say?
Yes.
All right. And you told me, as well as your lawyer, that you met earlier that day with Prosecutor Love.
Yes.
An investigator who's a female with dark hair. Do you remember that?
Yes.
Do you remember her name as you sit here today?
I don't know her name, but I see her in the courtroom.
And is she the very, very kind young lady, third row back, smiling as well?
Yes.
Okay. And she identified herself as a coworker to District Attorney Love. Is that right?
Yes.
And you freely went there to meet on your own time in Fayette County, right?
Yes.
And you did that to be courteous. Is that fair to say?
Yes.
And you did that because it's also, you knew you were going to testify and you wanted to tell the district attorney's office any information that they wanted to hear, right?
Yes.
And you also want to learn from them what it's like to testify. Is that all fair to say?
Yes.
And you said earlier on your, it's called a direct examination. It doesn't matter what it's called. When you were being questioned by Ms. Love, you said that she had a cell phone with her. You remember that?
Yes.
Either a laptop, an iPad, or some sort of device.
Yes.
And was she taking notes? Do you remember?
I think she wrote some on her notepad. I don't know what she wrote, but I know she wrote some on her notepad.
And I want to go over with you a couple things that you tell the jurors, whether it's true. And then my second question is going to be whether you told District Attorney Love that, okay?
Yes.
When I say that, I'm talking about Wednesday, June 9th, Sunday, June 9th, 2024 at Starbucks, okay?
Yes.
Do you remember telling with your lawyer there and the investigator at District Attorney's Office and District Attorney Love that shortly before, days before, the God forbid death of Donovan Thomas,
Yes.
you and a gentleman named Brian Williams, known as Birdman, do you know who I'm talking about?
Yes.
And others, including Jeffrey,
Yes.
were all together?
Yes.
And you were outside in the parking lot of TIG Studios?
If I'm mistaken, I want to say it was TI Studio, not TIG.
That's fine.
Yes.
And you were having a good time?
Yes.
When you told District Attorney Love that you were with Donovan Thomas and Jeffrey, did you make it known that there was no animosity? That's a bad word. Let me change it. Let me ask a different question, okay? Did you make it known that everyone was having a good time?
Yes.
Did you see any type of argument or spat or anger from Jeffrey towards Mr. Thomas?
No,
Did you see any anger or spat or argument from Mr. Thomas towards Jeffrey?
no,
In fact, you observed they were friendly, right?
yes,
You knew they were good friends, right?
yes,
You knew that Jeffrey really cared for Donovan Thomas. Is that fair to say?
yes.
Objection, Your Honor, as to this witness's ability to know, that would be speculation.
You can ask something foundational.
Okay. Did you observe, from your observations, did you observe that Jeffrey liked Donovan Thomas?
Yeah,
Objection, Your Honor, that's still possible.
It's sustained.
Did you observe from your observations the demeanor is a bad word too. Did you observe that there was friendship between the two of them?
Objection, Your Honor, that's still speculation.
Rephrase, please, sustained.
Let me ask you this. When you told that to District Attorney Love, was your lawyer right there at the same Starbucks?
yes,
Was he there at the same table?
yes,
Do you remember sitting outside the Starbucks?
yes,
Okay. Did you see District Attorney Love make any notes when you told her that?
no,
I noticed she didn't ask you about that. Do you remember her asking? Maybe I missed it. Did she ask you about that when her 3 days of questioning you?
no,
Let me ask you this. When you were at that Starbucks on that Sunday, June 9th, 2024 in the afternoon hours, do you remember telling District Attorney Love that on the evening after Donovan Thomas was, God forbid, shot, so it's January 10th, 2015. That's the date I'm locking on, okay?
yes,
You remember telling her that you were at Jeffrey's home
yes,
and Kenneth Copeland was there,
yes,
among other people,
yes,
and Jeffrey was there.
yes,
And at some time, Kenneth Copeland was receiving calls or received a call from the police saying that he was the suspect in this murder or the shooting of Donovan Thomas. Is that fair to say?
yes,
And that Jeffrey or Mr. Copeland was asking, what do I do? Do you remember that?
yes,
And Jeffrey said to Mr. Copeland, if you had nothing to do with the killing, you should go and talk to the police.
yes,
And you told District Attorney Love that, right?
yes,
In front of the Honorable Derek Wright, your lawyer,
yes,
in front of, or I don't know if she's paying attention. I'm not saying she was, but the investigator was around.
she was there.
And do you remember District Attorney Love telling you that she would prefer if you don't state to the jury that Jeffrey told you to take Mr. Copeland to the police department if he was not involved in the murder?
Yes,
Did you ask why?
no, I never asked why.
Now, you also said, and it's the truth, and if
Yes.
it's not, you correct it, that you were very close with Donovan Thomas.
Yes,
In fact, your relative, I think cousin, but tell the jurors if I'm wrong, dated Donovan Thomas's relative.
yes,
And Donovan Thomas is close with your mother.
yes,
And you told District Attorney Love that.
yes,
Now, you were asked by District Attorney Love whether you remember anything else anyone said regarding the murder of Donovan Thomas on the night of January 10th, 2015, going into January 11th, 2015. Do you remember that question by any chance?
no, not actually. I don't remember that question.
Okay. Do you remember Jeffrey being distraught, that's a bad word, being upset or sad at the shooting of Mr. Thomas?
Yes.
Do you remember?
Your Honor, I object. That calls for speculation. about
Rephrase.
Mr. Williams.
Do you remember ever seeing Jeffrey put out a post, rest in peace, about Mr. Donovan Thomas's death?
Objection, I'm saying to stop an improper question about putting facts not in evidence. Mr. Steele knew that is putting facts not in evidence. And I would ask not only that the court strike the question, but admonish Mr. Steele to not put facts improperly not in evidence before this jury.
Okay, can you ask some foundational questions, please?
Sure.
And Your Honor, any post made by defendant Williams.
So you're not talking about that evening, are you?
Yes, ma'am. I'm talking about the morning hours of January 11th, 2015.
All
The
right,
gentleman.
we might need to take this up outside the presence of the jury.
Well, I'll come back to it then.
All right.
Let me ask you some questions. In front of you, is State's Exhibit number 444Y there by any chance? It is it's entitled, it's on the letterhead of the Office of the Fulton County District Attorney. It's dated December 27, 2022. Do you see that document?
Yes.
And it should be 7 pages long?
Yes.
Okay. If you can turn to page 3 of 7, I want to ask you some questions about this document. And this is the same document that you've been asked about by Ms. Love, by the Honorable Attorney Sharp, right?
Yes.
Okay. Now, at the time of entering this guilty plea, December 28th, right before New Year's of 2022, right after Christmas, right?
Yes.
All right. I want to go through the factual acknowledgements. And I'm specifically focusing on Jeffrey, okay?
Yes.
Number 1, it's on page 3 of 7. Do you remember acknowledging and signing, and the jurors heard and watched your guilty plea before Judge Glanville?
Yes.
You saw that too, okay. Number 1, Young Slime Life, AKA YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase notoriety, street credibility, and reputation of YSL. You see that?
Yes.
And that's, of course, your initial.
Yes.
The A and the S. Okay. Tell the ladies and gentlemen jury about Jeffrey. Focus on Jeffrey. What did Jeffrey benefit
Objection,
from
calls for
any
speculation.
type?
Objection.
Let me hear the question. All right, don't answer the question yet, okay?
I got you.
What's the question?
From your personal knowledge, when you sign this, tell the jury what Jeffrey benefited
That's outside
From-
of the witness's knowledge.
from his personal observation. It's his acknowledgement that the state introduced.
What, that actually did not introduce these parts.
They read this.
They did. Rephrase your question.
Okay. When you sign that, do you have any evidence to share with this jury
No.
that Jeffrey,
No. Rephrase your question.
did Jeffrey, when you signed that, were you talking about Jeffrey Williams?
No.
Okay. Number 1, I'm still on number 1, I just read, okay? When you were sworn before Judge Glanville, sworn means you take an oath to tell the truth, okay? Remember
Yes.
that?
Yes.
You were asked questions, right?
Yes.
Did Prosecutor Love ever ask you, tell us what Jeffrey Williams did?
No.
At that point in time, you wanted to go home, right?
Yes.
You would have answered all questions.
Objection,
Right.
1 calls for speculation.
Sustain.
Number 2, on page 3 of 7.
Yes.
States 444Y. It reads that you have been a member or, it says and/or associate of YSL since 2012, right?
Yes,
Now, you told the jury that anyone can join YSL. Is that true?
yes,
I mean, if I just today said, I want to get a tattoo of YSL on my face, is that a problem?
no,
Objection made, whether or not it's a problem.
Is there any type that you know about, like beat-in or initiation to say I'm with YSL?
no,
Do you know personally from your travels, from going to shows and concerts and tours, are people from all over America and throughout the world having tattoos of YSL,
I seen a couple of fans, yes,
wearing shirts YSL,
yes,
hats,
yes,
tattoos of Jeffrey on their person?
yes,
On issue 3 of that same document, it should read, while associated with YSL and to support and express loyalty to YSL, you, co-defendant Mr. Garlington and Mr. Zachary appeared in a video, and then there's a parenthesis that says the video, with another person, AS, wherein you brandished a weapon used in a drive-by shooting, and wherein on behalf of YSL, you threatened to harm a person named Kel, a rival gang member who had begun a relationship with your ex-paramour or girlfriend. You see that?
yes,
Were you asked any questions about what Jeffrey knew about that?
no,
He knew nothing to your knowledge, right?
Objection, Your Honor, speculation.
Sustained.
On your personal knowledge,
Objection, it was still called for speculation.
on your personal
Mhm.
knowledge, did you ever speak with the prosecution? Did they ever want to know, what did Jeffrey Williams know about that?
Objection 1, that calls for speculation. 2, I can approach, Your Honor, because that.
Okay, I mean, it doesn't, that one does not call for speculation, but if you have some other issue, then.
I don't need
y'all
to
go
approach,
ahead.
Your Honor. I'm going to continue.
Approach, Your Honor, because I have an objection that I need to put on the record.
Okay.
I would rather not stop, because that's all Ms. Love does. I'd rather continue. I'll waive that.
Well, we're gonna approach. All right, go ahead, Mr. Wait, sorry, we need to get Mr. Sledge back in. Yes, ma'am.
I ask that the
We can strike that. All right, go ahead, Mr. Steele.
Mr. Sledge, on number 3 that we were just talking about,
Yes,
on the same document,
yes,
during your time before Judge Glanville entering the plea and Ms. Love was asking you questions, you
yes,
saw the video, audio of that as well.
yes,
Did Ms. Love ever ask you anything about Jeffrey at that point?
no,
And you were under oath at that point,
yes,
and you were going to answer questions if asked, right?
yes,
I'd like to go to number 4, same page.
yes,
On or about April 28th, 2015, as reflected in Fulton County indictment number, and I'm not going to read it, but it ends in 8994. You see what I did?
yes,
I just skipped the first bunch of numbers and letters. You and fellow YSL associates, Mr. Garlington and Mr. Zachary, committed a drive-by shooting using a firearm, the firearm that you wielded in the video referenced in part 3 of this section, targeting family members of a rival gang. You see that?
yes,
Okay, and you initialed that, obviously.
yes,
And again, did Miss Love ask you any questions on December 28, 2022, under oath in front of a court reporter on video, audio about Jeffrey?
no,
Number 5, same page, same document. You and your fellow YSL associates committed the drive-by shooting referenced in section 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, okay?
yes,
Were you asked anything on December 28, 2022 about Jeffrey?
no,
You would have answered questions asked, right?
yes,
By this time, April 28, 2015, if you personally know, did Jeffrey launch a tour across the United States of America with Travis Scott?
I think it was around that time, if I'm not mistaken, I'm not for sure.
You went on part of that tour?
Did I go on board? Yes,
On part of the tour?
yes,
And you told the jurors what it's called. Do you remember what you called it?
the rodeo tour.
With the court's permission and your permission, I'd like to approach you with a document, okay?
Yes,
Your Honor, may I approach?
You may.
Ms. Winfrey, may I approach and get that document?
I would like to know what document it is.
I'm sure he'll show you.
Your Honor, this has already been shown to the state, has been previously marked, partially admitted as on 1/8/24, so it'll be January 8th, 2024. It's Mr. Williams, exhibit number 19.
All right, I'm not sure what you mean by partially admitted.
Parts of it were admitted.
Okay, are you
Not-
going to admit
yes.
for the admission of the rest of it?
Yes, I'm going to see if Mr. Sledge can identify it.
Right.
Thank you.
You may.
Approach you?
yes,
I'm going to show you an item, and I added that earlier, so that's just called an exhibit sticker.
yeah,
But if you can look at that, you can open it up. Just tell me if you recognize it and if it is accurate. If you don't recognize it, that's fine, and we will, we're going to put it aside, okay?
yeah, I remember this.
And what is that? document, which I believe is number 19 of Jeffrey Williams.
This is the,
Put it
booklet.
down until it's admitted.
Okay, I'm sorry.
No, that's
This,
okay.
this the booklet of the tour on what days and what areas that we was in.
Okay. And is it look to your memory to be accurate? Meaning, has it been changed in any way? Has it been altered, or does it look similar to the way that you saw it when you went on that tour?
It looked the same.
Your Honor, I move for the admission of Mr. Williams. It's number 19.
Your Honor, pursuant to 218801. I object on the grounds of hearsay.
For what purpose is this being offered?
The purpose of showing the cities and the states for the certain tour.
And the dates?
That's what it is.
And
That's all it
that
is.
part, Your Honor, that
Uh-huh.
he's describing is already in just that portion.
It's there. That's the official tour guide to that tour.
Your Honor, can I object to the testifying, but there is a portion we can show the court.
Okay, well, I may need to see it myself then, because I don't know what
Okay,
might
approach?
be problematic, yes.
Yes.
Can you hand it to me?
Do I need to?
I think Mr. Steele should probably come up also.
Do I need to step out?
Yes.
Attorney Steele, Brian, he's hilarious. He says, I'd rather not. And it's true. We can't get through anything because this is what she does all day long. These meetings just always have to explain something.
May I approach, Your Honor?
You may. So the portion for the ruling is that it was already in, is in.
Sledge, may I approach you?
Yes.
I'm turning to the third page, full page of turning to the sixth page, if you were counting both sides of Mr. Williams' number 19. Do you see any dates of that rodeo tour?
Yes.
And can you tell the ladies and gentlemen jury, just read it to them, if you don't mind, the date and the city of the tour?
I'll wait from the top to the bottom.
Entirety of the tour dates?
Sure.
Do you want to just post that page?
I don't have it on,
Okay.
Your Honor,
Yes.
also, this witnesses basis for knowledge of the specific dates, we would object unless there is a foundation laid for that.
Okay, well, he said he went on parts of this tour and was familiar with the tour.
Mr.
So
Slade,
overruled.
do you feel comfortable doing that? And if not, just,
Yes, I can read you the dates and
actually, Your Honor, may I approach?
You may.
May I approach you, sir?
yes,
Would you mind if I read along with you?
yes,
Okay, you just tell me if you can put it down. I don't have very good eyes.
me neither.
All right, I'm going to start here, okay?
Yes,
Saturday, February 28, 2015,
yes,
Santa Ana, California.
yes.
March
15,
Sunday, March 1, 2015. You see that?
yes,
Santa Ana, California show day.
yes,
Monday, March 2nd, Tucson, Arizona show day.
yes.
Yes.
I don't know if there's a question, and I would object to Mr. Smith.
Could we maybe give a summary of it?
Okay. Then the next one is the next day. It's a travel day, right?
Yes,
And then it's March 4th, 2015, Denver, Colorado show.
yes,
And then I'm skipping. March 6th, 2015, Milwaukee, Wisconsin show.
yes,
It's the same thing and it's the same objection. Testifying is not a question. He's just stating.
So
This is in evidence.
he's confirming the dates. I mean, Mr. Steele is not testifying, so that's overruled.
Saturday, March 7th, 2015, Chicago, Illinois
yes,
show day, and Rochester, New York as well.
yes,
Sunday, March 8th, 2015, Chicago, Illinois, a show day.
yes,
Monday, March 9th, 2015, Detroit, Michigan, a show day.
yes,
Tuesday, March 10th, 2015, Toronto, Ontario, Canada, a show day.
yes,
Wednesday, March 11th, 2015, Buffalo, New York, a show.
yes,
Thursday, March 12th, 2015, New York, a show
yes.
or a concert.
What month are you going to get to before the list is over with? I mean, can we just say there were show dates pretty much constantly between X date and Y date?
Sure. It goes up to, is it fair to say, consistently through April 3, 2015. Is that true?
Yes,
And the cities that we left off at include Philadelphia, Pennsylvania,
yes,
Washington, D.C.,
yes,
Norfolk, Virginia,
yes,
Charlotte, North Carolina,
yes,
the great city of Atlanta, great state of Georgia,
yes,
New Orleans, Louisiana,
yes,
Austin, Texas,
yes,
San Marcos, Texas,
yes,
Houston, Texas,
yes,
Dallas, Texas,
yes,
Phoenix, Arizona,
yes,
San Diego, California,
yes,
Los Angeles, California,
yes,
San Francisco, California,
yes,
Seattle, Washington,
yes,
Portland, Oregon,
yes,
Boise, Idaho,
yes,
travel home.
yes.
Okay. Now, and if you need to see it, just let us know. Madam Court Reporter. Knowing Jeffrey Williamson since about 2009 when you were released from prison,
Yes,
and seeing him on tour throughout our country, how much time did he spend committing crimes on
Objection.
Cleveland Avenue?
Objection. Wholly improper and speculation and speaking as to
a legal conclusion committing crimes that this witness should not.
Sustained.
Did District Attorney Love, you was having you, or you agreed, sign that on April 28, 2015, it's number 5, that this drive-by shooting on April 28, 2015 was done on behalf of YSL to increase the notoriety, reputation, and fear of YSL. How many questions did she ever ask you at that time you were entering the plea, sworn under oath, about Jeffrey Williams?
The number of questions that were not asked about a specific defendant. It's irrelevant how many times he's asked. The jury has seen what happened and what he asked.
Sustained.
By April of 2015, how wildly popular from your personal observation was Jeffrey Williams?
Objection, relevance.
Overruled.
Very popular.
When you went to all of these cities throughout America with Jeffrey, how many fans would come?
Objection, speculation, and relevance.
I mean, if he can estimate it, overruled on relevance.
20s to 30,000, a lot of people. Okay.
Were these concerts held in arenas?
Yes.
Number 6, it's on page 3, it goes into page 4, okay? Same document.
Page 6.
Going into, it's number 6. It's on the
Oh,
bottom of page 3,
okay, yeah.
same document. It's
Yes.
going to go into the next page, okay?
Yes.
You admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, and it goes on to the next page, for your participation in the drive-by shooting. And it says reference in 3, 4, and 5 above, meaning the April 28, 2015, right?
Yes.
Okay. Number 7, it says that you were told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia to discuss the murder, right?
Yes.
Did anyone ever ask you any evidence that Jeffrey was at the McDonald's?
Objection, improper question as to evidence. Did anyone ever ask?
Sustained.
Did Miss Love on December 28th of 2022 ask you, was Jeffrey at the McDonald's?
Objection, again, one relevance. The jury has heard and seen what was asked, and it's not relevant, and an improper question.
Oh, that's overruled.
So
Okay, so the entirety of the plea transcript is not actually in there. I don't know, what number are we on right now? 6? 7?
Yes.
So,
7 is in there.
okay, but we don't have the entirety of it. Overruled.
Did District Attorney Love ask you on December 28th of 2002, was Jeffrey at the McDonald's?
No.
You have any evidence that Jeffrey was at this McDonald's?
Objection as to that question.
Sustained.
Do you know personally, or what you were told is reference in number 7, was Jeffrey at this McDonald's?
No.
Number 8, you personally know that one or more YSL associates committed the murder of Donovan Thomas on behalf of Jeffrey. That's what you signed, right?
Yes.
Okay. Do you have any personal knowledge that Jeffrey Williams committed the murder of Donovan Thomas Jr.
No.
in any fashion?
No.
You know what a party to a crime is? You know what that means?
Overruled.
Yes.
Was Jeffrey,
Overruled.
do you have any information?
I mean, I'm sorry, sustained, sorry. You may not ask that question. Mr. Steele's like, yes. Sorry, my bad.
He said overruled.
Sorry.
All right, number 9. You see where I am, number 9?
Yes.
January 10th, 2015. After the murder of Donovan Thomas Jr., you and other YSL associates gathered at the home of Jeffrey Williams, AKA Young Thug, who gave you and other YSL associates cash money to lay low. You see that?
Yes.
You already told the jury, you made it clear that Jeffrey did give you $300. True?
Yes.
Because you feared for the safety of yourself and your family, right?
Yes.
Did anybody fire weapons, bullets into your home where you were living on June 10th, 2015, or the 11th, or the 12th, or the 13th?
No.
And then even after you you received these, I think you called it anonymous statements that you and Mr. Copeland killed Donovan Thomas. You used some word. It was from an account in social media.
Yes.
What was your word?
The DM.
Yeah. Was it from what'd you say?
A fake page.
Fake page. Okay. When you got that though, you made it clear that that bothered you because you didn't want anything to happen to your significant other or your child or anybody, right?
Yes.
Including yourself.
Yes.
And you didn't have money at that time because you lost money gambling. Is that true?
Yes.
And you asked Jeffrey and he gave you money for a hotel, right?
Yes.
And the expression lay low, I know you said it was to get your family members out of harm's way. I think that's what you said.
Yes.
But lay low could mean the same, doesn't it?
Yes.
It wasn't any type of lay low from the police or anything, right?
No.
It was be safe.
Yes.
Do you have any information, personal knowledge to share with the jury that Jeffrey gave any money to anyone as a reward for killing Donovan Thomas?
Objection, Your Honor, that would call for speculation and hearsay as to the reward part.
Overruled. And I actually mean overruled.
No.
I'm going to go to number 10, if you don't mind. Same document, page 4. That you have personal knowledge that on January 10, 2015, after the murder of Donovan Thomas, YSL Associates traveled to Miami, Florida, with co-defendant and YSL founder Jeffrey Williams, AKA Young Thug. I want to talk to you about that, okay?
Yes.
Now, you made it clear that you knew that Jeffrey Williams was already going to Miami, Florida for a video music shoot. Is that, when I say shoot, filming it, is that true?
Yes.
And you knew that this was already set up before January 10th, 2015, right?
Yes.
And you knew other people were allowed to go if they wanted to.
Yes.
That Jeffrey was generous. He would take people outside of that.
Objection, Your Honor.
Shout out to Y Turner. Thank you so much for everything today.
Sustained, rephrase.
Jeffrey Williams gave people the opportunity to leave Cleveland Avenue area and see other parts of America. Is that true?
As to relevancy, whether or not Mr. Williams gave anybody else an opportunity to do something.
Sustained.
Mr. Williams gave you opportunity to go, right?
Yes.
And others.
Yes.
Objection, Your Honor.
Was there anything that on the 28th day of December 2022 that you were asked as to why this was somehow criminal, that Jeffrey had this meeting, this work in Miami, Florida?
Objection, Your Honor.
Sustained.
Were you asked? Were you asked any questions by District Attorney Love, Judge Glanville, or anyone, whether that going down to Miami, Florida, was not pre-planned?
No.
Number 11 says that you did not murdered Donovan Thomas Jr. and you're not a party to that crime. That's true, right?
Yes,
Number 12, that you did not murder Mr. Drinks and not party to a crime. True?
yes,
Okay. Number 13, on the bottom of that page, it says, you cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of murder, and you will make no attempt at trial, prior to trial or after trial, to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. You see that?
yes,
Now, you've read this indictment, you've had it because you were charged in this case. Is that true?
yes,
Are you familiar still with this indictment?
yes.
Okay. Well, if you need it, with the court's permission, I have a copy if you need to see it. But you're not charged with the murder of Donovan Thomas in this indictment, are you?
No, not in this indictment.
Okay. And you're not, and Jeffrey's not charged with the murder of Donovan Thomas in this indictment, right?
No,
You're not charged with the murder of Mr. Drinks in this indictment, are you?
no,
And Jeffrey's not charged with the murder of Mr. Drinks.
no.
If you go to page 5, it's the top of page number 14. The gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. You see that?
Yes,
And then I'm just grouping it together because they look similar to me. So if they're not, you just correct me. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate, right?
yes,
Were you ever asked any questions about Jeffrey selling drugs at either of these items?
I object on the grounds that Mr. Steele has no good faith basis for asking that question, given the fact that he does have the entirety of what was asked, and he does know the entirety of what was asked. And so therefore, one, it's not relevant, but two, he doesn't even have a good faith basis for asking. So if we want to get in the entirety of what was asked, I would ask that the court just simply, if he wants that in, to have him tender it, but not to ask questions that he knows he doesn't have a good faith basis to ask.
I don't know what that means. It was not asked. And I'm asking the gentleman whether he was ever asked that. On the record, off the record, it's not there.
Okay. I don't know if you meant on the record or off the record, but I'm going to permit it. Go ahead.
That have anything to do with Jeffrey?
no,
Were you asked anything from
no,
District Attorney Love when she had you under oath in a courtroom with your lawyer before Judge Glanville?
no,
Number 15. You have personal knowledge that you and other members of YSL have either participated in, directly committed, or at least one of the following crimes in order to increase notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug and sales. Were you ever asked anything about Jeffrey on December 28th, 2022, when you entered this plea?
no,
Now, you have been prosecuted before this case. By prosecuted, I mean you've been arrested, charged, and brought before a judge, right?
yes,
Okay. Have you ever, in your experience, have you ever been told that your plea agreement is conditioned on what you say at a trial?
no,
Have you ever been told by a prosecutor that she'd prefer you not say things in front of a jury?
Your Honor, I object on the basis of relevance and
Relevance in what? I'm sorry, did you say something else?
Yes, the question was, have you ever been told by the prosecutor something, so I object on the basis of relevance. I'll stop at relevance.
Mr. Steele, would you like to address that?
Sure. Goes to the motivation, interest, and bias of the district attorney in this case.
Well, that's not an issue.
It always is an issue. Telling a
The
witness not
bias
to
of
do
this
something.
witness, maybe. Is that what you mean to say?
It's a party opponent.
No, sir, that's not how that works. So if that's your only justification for it, then granted. I mean, sustained.
Okay, I want to talk with you about some items. When you met Jeffrey, he was approximately 17 years of age. Is that fair to say?
Yes,
And it's about 2009.
yes,
And the way you remember 2009 is because you were in prison and then was released in about 2009. Is that true?
yes,
And then you went over and found a place to live on Cleveland Avenue.
yes,
So you met people who were in that area. Is that fair to say?
yes,
And Jeffrey was at times in that area, right?
yes,
Did you observe Jeffrey working hard?
Objection made.
Okay.
Sustained.
Did you observe Jeffrey practicing his craft, art, music?
yes,
Did you see him in the studio? You ever see him in the studio?
yes,
And is it fair to say that when you first saw him, to however long you've known him, he is a workaholic, meaning he works all the time?
Objection, Your Honor. They, speculation, workaholic, whole characterization, so objection on the basis of relevance, they.
I think on relevance, sustained.
You've seen him in studios in the morning time,
yes,
afternoons,
yes,
nights,
yes,
evenings.
yes,
You mentioned on direct examination that Jeffrey idolized Lil Wayne. You remember saying that?
yes,
And that there was this, these are my words, so you correct me. There's almost this belief, this feeling that Jeffrey had that he had to make it out.
As to defendant Williams' feelings.
Sustained.
You said on direct examination, meaning when you were questioned by Ms. Love, that you believed that Jeffrey was going to be
Objection.
a
Objection, Your Honor.
popular.
Objection as to one, relevance of the witness's belief about something he may have speculated about regarding defendant Williams.
All right, I don't know because I haven't heard the question. Could you tell me what the question is?
Sure. And it came out on direct that there was a belief by Mr. Sledge that Jeffrey was going to be a successful musical artist.
Okay, and
Way back when.
What's your question gonna be?
That I'm going to follow that up. That was his drive. That was Jeffrey's mission, his drive.
Objection, that would be speculation as to defendant Williams' intent and.
No, he's asking about this witness's belief about that, but that's irrelevant.
All right. Now, have you ever observed anyone or have you observed Jeffrey when you first met him? When you got out of prison, I think May 2009, is that right?
yes, that's correct.
He played in a lot of first local clubs, is that right?
Yes,
And when I say local clubs, in the area of Atlanta.
yes,
And then you saw it go a bigger location, is that true?
yes,
And then multiple states?
Objection, Your Honor, relevance.
This is his
Ooh.
career.
Go ahead.
yes,
And people, including you supported Jeffrey's musical career, didn't you?
Objection as to that compound question, because it calls for speculation as to people supporting, within the employees, and it's not
It's
relevant.
personal observation.
Okay. Sustained on other people and sustained on relevance.
Would you observe, meaning did you personally observe the local community in Cleveland Avenue come out to Jeffrey's shows?
Sustained.
Would you see people, including yourself, put up signs that Jeffrey's performing?
Sustained. Move on to another topic.
All the people that you were asked about, remember being asked about Trontavious Stevens
Yes,
and Mr. Murphy?
yes,
Mr. Murphy and Mr. Copeland
yes,
and whoever you were asked about, okay?
yes,
All those people were in poverty at the same time you and Jeffrey were, right?
Objection calls for speculation, and it is irrelevant and is compound as it relates to at the same time you and Jeffrey, and it assumes facts that are not in evidence.
Sustained.
Were you in poverty in 2009 when you met Jeffrey?
Overruled.
could you repeat the question, Mr. Steele?
Yes, sir. Were you poor? Were you struggling financially in 2009 when you got out of prison?
Yes,
All those other people that you're asked about on direct, were they struggling to your observation
yes,
financially? Jeffrey gave you a job, right?
yes,
And by that job, you called yourself, and I'm not saying that was not your title,
I object as to
but
the vagueness of the line of questioning regarding who gave him a job. That means what?
Overruled.
you were called head of security, right?
yes,
And by that, what that meant was that you would assist others in
We've
locating.
established what it meant.
I'm sorry?
We've established on direct what it meant, what his duties were.
You would assist in any capacity needed to put on these shows.
yes,
And you got paid by direct deposit, it's called. Is that what you, and if you don't know that term,
yes,
you got a bank
yeah,
deposit.
transfer, yeah,
Okay. And to your knowledge, Jeffrey offered other people jobs too from your area. To
Not
his
if
knowledge.
he says to your knowledge. That makes it not speculation. Overruled. Overruled.
could you repeat it, Mr. Steele?
Yes, sir. To your knowledge, Jeffrey would give other job opportunities to other people too, right?
Yeah, yes,
So instead of giving money, you knew Jeffrey had money by 2014, right?
yes,
He was flying on planes, right?
yes,
He had cars, right?
yes,
He had places to live.
yes,
He had multiple places to live.
yes,
He had jewelry.
I mean, I think you've made your point, so just move on to the next question.
But instead of giving just cash to people, he gave people opportunity to earn that money, right?
yes. Oh,
Okay. Now, do you have any evidence to tell this jury that Jeffrey ever told you or anyone else to harm another person?
no,
To your knowledge, and I am not including drug use, and I am not including gambling, but to your knowledge, did Jeffrey ever encourage?
You know what?
Encourage.
Apparently we need to take a restroom break, so let's break for a few minutes.
Thank you, Y Turner, again. Thank you so much.
Let's try to keep this one to 10 minutes or so.
Okay, guys, it's getting pretty intense. We should probably only have about 40 more minutes left in the day. So I would anticipate that cross would end today. Monday, we do redirect and recross and on to the next witness.
All right, y'all, we just took a fairly long recess an hour ago. I'm going to remind y'all to please, whether you have to right then or not, use the restroom during recesses so that we don't then have to take another bathroom break less than an hour later. Okay, I'm going to just start making y'all hold it if you can't do that, because we take plenty of breaks without interrupting the middle of somebody's testimony. Okay, so keep that in mind for the future, please. Go ahead and go if you need to.
Guys, the next witness is supposed to be Lil D from Cleveland. The Cleveland Lil D. Zachary. So, I don't know, guys. I mean, each witness is like making me feel more and more and more like this case should be over. Thank you guys for staying on with me all day. Thank you so much. I got some information too. I've been on my phone. I got some information, and I am so sad that I don't know if I can tell you guys. But I have some information on someone who was subpoenaed today for this case. And I am absolutely shocked. But when it comes out, I'm going to say, guys, remember when I told y'all? I cannot get caught up in what they have. They're not going to mess with me. So I just have to let things unfold. But just know you heard it here first. I'm going to come back and tell y'all when it comes out who I am talking about. And it's not as big of a deal as you guys think, but I can't wait to give my commentary on how I feel about it. This is funny. So you guys think I'm just here on my phone. I'm listening. I don't miss anything. That's how I am sometimes in court. I'm on my phone. I'm doing a million things, but I'm listening and I'm paying attention and I am ready. Okay, let me ask you guys a question. This is completely off YSL topic. So I'm in the process of starting a podcast and I'm trying to get some good guests for you guys. Tell me some people who you want to hear from. Now don't go like, I probably can't get like Drake or anything like that, but guys, give me some ideas. Who are some people that you want to hear from? I am going to spend this whole weekend doing recaps. I'm going to try to start from the beginning of the trial and then go to the end, do some motion reviews, and get a lot of content put out there. That's how I'm going to spend my weekend. Also, My podcast will be completely separate from YSL and from me being a lawyer. I just want to do some culture stuff. Like, who do y'all want to hear from? Let me know, because this will be completely separate from my legal perspective. But I think that I'm a pretty cool person and I could do some pretty good interviews. Y'all want to see Woody? That is so funny. Boosie, Charleston White. Yeah, I'm staying in the courtroom for sure. Y'all want to see Charleston White? DeBrad. I don't know about Charleston. He's not my cup of tea. Celebrity or YouTuber what? Thank you for the super chat. Celebrity or YouTuber what? You want to hear from lawyers. Okay. See what lawyers we got cooking. Okay. Hold on, guys. Okay, guys, so sorry about that. Y'all, these are some very interesting people. No, I'm gonna take my podcast serious. Like, not to say that some people aren't serious, but there are some people who are not. I don't want to do things for like, I want to do yes, I want to hear from these two. But I want to do like real get into it interviews. It's not a celebrity or YouTuber. Who is this, Y Turner? Thank you. This is how I feel. I don't know him, but that's not the type. I don't want like clickbait. I want like, let's get into it. I like this. Everybody doesn't have to be a celebrity to be on the podcast. People from all walks of life have things to offer. So, not just celebrities. This is a definite no at all. Absolutely would be great. But I mean, I want more of a culture vibe. I love Ashley. I've been dying to do a live with her or an interview with her, but I want my podcast to be more of a like culture vibe, you know? Of course people want to get paid for their time. I didn't say I want I mean, why are we talking about that? I just said who do you want to see? Thank you. Okay, looks like we are starting back. Some of you guys have some funny things. I'm going back on mute, guys.
Mr. Sledge, when you were permitted to go on the Travis Scott rodeo tour
Yes,
for the dates that the jurors heard,
yes.
Objection, Your Honor, that assumes facts that are not in evidence. There was not testimony from the witness that he went on that tour on those dates that he heard, that he talked about. Matter of fact, Mr. Simpson said he didn't go on all of them.
Okay, on generally some of the dates, could you rephrase it?
sure. Do you remember on direct examination when questioned by Prosecutor Love, you explained that you went on the rodeo tour with Jeffrey Williams and others?
Yes,
And do you remember telling the jury that you actually were sent home before the tour ended? Do you remember that?
yes,
And you said for doing stupid stuff. Do you remember that?
yes.
And that stupid stuff was committed a crime, right?
Well, I didn't commit a crime, but
Okay.
it was to that occasion.
And Jeffrey said you and others are going home. True?
Speaking of words, it would be hearsay from the defendant that the witness is not, there's no rule that, there's no exception that would allow that hearsay.
Oh my God.
Sustained.
Why were you sent home?
Objection, ask and answer.
Who sent you home?
Jeffrey.
I'd like to show you, with the court's permission, I'd like to approach and show you what I've marked as Jeffrey William Exhibit number 220A. And it's consecutive, meaning it goes in 220B.
Yeah.
But it goes up to JW Exhibit 220XX.
Yes.
Your Honor, may I approach?
You may.
Yeah, these are the, ones that court, I think, can move a smattering.
No, he's gonna, no, that's, yeah,
May I approach?
you may.
May I approach?
Yes.
Do you mind if I just move this? I'm going to give this to the court reporter, okay?
Yes.
So it says JW, Jeffrey Williams, EXH is exhibit, and then you'll see the numbers followed by a letter. Do me a favor, flip through these. If you've seen these before with your lawyer, and you recognize them, just tell us that as well. If you don't recognize some, put it to one side. If you recognize others, put it to a separate pile, okay?
Your Honor, and the question was if you've seen them before with your lawyer. That wasn't, I thought, the question that the court required.
If you've seen him before today,
If I seen them before today,
yeah, you may have seen them today. So if the only time you ever saw them was today, then put it aside as something you've never seen. What he means is if you saw it before today, is that right, Mr. Steele?
Yeah, yesterday, Your Honor.
If you said before yesterday, that's when he gave it to him. He said-
Okay,
Yes, sir.
before yesterday. If you saw it before yesterday.
Mr. Sledge, I just want to ask you a question if I can. I'm not trying to interrupt you. Any of them that you saw put in one pile like you're doing? Any ones you didn't see put in another pile like you're doing? Okay, just keep them separate.
okay, thank you.
Okay, thank you.
And then I know where you might be confused. It's going to be a composite exhibit and he will publish to the extent this witness says he recognizes any of them, a smattering of those, not the entirety of them.
Are you done?
Yes,
Okay, Mr. Sledge, did you make two piles or one pile?
one file.
And do you recognize what has been marked as Jeffrey Williams exhibit number 222A through 220A through 220XX, or do not recognize them?
I recognize.
Your Honor, the question was whether or not he saw them before yesterday, and that was not asked, so I would ask that that be inquired.
Let's clarify, please.
Have you seen those items, all of them in that package, prior to seeing them with your lawyer yesterday?
I didn't see these with my lawyer yesterday, but I have seen these before.
In the past,
Yes,
before yesterday?
before yesterday, yes.
And are they true and accurate? That's just saying, do they look the way that you remember them when you first saw them?
Yes,
Did you see them, those items contemporaneously? That's a bad word. Did you see them at the time that these items were going on?
yes,
Okay. Your Honor, I move for the admission of Mr. Williams, and that would be, Your Honor, 2220A, as in Elisa, through 220, then double X.
All right, that's admitted.
Okay. Mr. Sledge, may I, with the court's permission, may I just
Yeah.
approach you? And I'm just going to show a couple
Yes.
to the jurors as a sample.
yes.
Yes.
Thank you, sir. Now, Mr. Sledge, is it fair to say that these exhibits, and I've numbered them all, but that they're all advertisements or posters for Jeffrey's work, concerts?
Yes,
And is it fair to say that they range from places all over the United States?
yes,
And when I say range from, shows, concerts all over the United States. Is that
yes,
true?
yes,
And the date range goes from, this is just from 2014 into 2015. Fair to
Yes.
say?
yes.
Okay. And if we could just pull up a couple. And this would be with Mr. Kokomo's and the court's permission. Jeffrey Williams exhibit number 220DD. And it should come up on your screen, Mr. Sledge. Could be, or it's maybe to your left, but yes, it's above you too.
Yeah, I think that one might be out of batteries. That's on the.
Yeah, that's indeed.
Mr. Kokomo, can you clear the items on the middle of the screen?
It appears that there's some encryption, Fulton County, on all of the computers, so I'm not sure if it's anything that can be done.
Okay, that's fine. That's fine. May I approach, Your Honor?
You may.
Let me just show you this to you. Mr. Sledge, may I approach you?
Yes,
I'm going to show you what's been admitted, Mr. Williams, or JW Exhibit 220DD. Take a peek at that. And is this a performance in Chicago, Illinois?
yes,
And is it, do you recognize those performers?
yes.
Tell the jurors who they are.
Birdman and Rich Homie Corn.
And anybody else?
Jeffrey Williams.
Okay. And this is the date. Do you see the date?
Yes, December 26th.
And Christmas time,
Yes,
2015?
yes,
To your knowledge and observation, and if you don't have one,
Yes.
Do not see.
I do not see, and so I would ask for clarification. If the testimony is that there is a 2015 on this exhibit that I'm looking at, because there is no year of 2015, as Mr. Steele has suggested, unless I'm missing it. If you could just show me, I'd be okay.
first of all,
Yes.
it comes from the state of Georgia when they subpoenaed Mr. Williams' Twitter account for 2014 and 15, A and B.
Your Honor.
If I go through all of them, you can see the dates in order.
Your Honor, there is no,
I mean, I think that the objection was that the date might not be, the year date might not be on this one, and I don't see it on there either, so.
All right.
But but he's already testified that the entirety of that composite exhibit shows dates from 2014 to 2015. So it's one or the other.
Your Honor, there is a difference that matters. It's a distinction with a difference, because what Mr. Steele is putting up is a picture of Defendant Williams with a young man whom evidence has come out did not associate with Defendant Williams after a particular time.
Okay.
Now I have a motion.
All right, so we'll take up the motion in just a minute. With regard to this particular exhibit, I don't see a date on it either. Is there a date on it of a year? If not, maybe
I'll do
pick a
the-
different exhibit.
Your Honor, my motion be preserved as timely
Yes,
and approach.
yes.
All right, Mr. Slade, may I approach you?
Yes.
Let's just flip a exhibit here. How about the next exhibit? Jeffrey Williams exhibit number 220EE. Okay?
It says December 31st,
Well, let the
2015.
jurors see it first. Oh, there it is. Okay. All right, go ahead. You can look. It's the same.
It say December 31st, 2015.
New Year's
New
Eve
Year Eve.
and MYE. Do you know that stands for New Year's
The
Eve?
E, yes,
2015?
yes.
And did that come, this 220EE come shortly after, immediately after 220DD of Jeffrey Williams exhibit?
Yes.
And this one, again, the date on 220DD is in Chicago, and it is on,
26.
thank you, tell the jurors.
December 26th.
And does this help you orient that December 26th on 220DD is 2014?
No.
Okay. Does it help you with 220EE? Is the date New Year's Eve going into 2015?
Yes.
And who is performing on New Year's Eve, December 31, 2014, going into January 1st, 2015? Who are the performers?
Jeffrey Williams,
Who else?
Birdman, and Rich McCorn.
Okay. Thank you.
So, Your Honor, regarding the objection as to the year of 220DD, I believe that Mr. Steele said the year was December 26, 2015, and that was where the issue was. I'm asking if now it's understood that it's 2014. If we could.
I don't know that we have that understanding because we don't have evidence that, I mean, I realize these are handed to the witness in a particular order, but I don't know that there's any evidence to suggest that the order that they're in is a chronological one. So we still don't have any evidence as to which of the 2 years that other one was. We just know that this one that we're looking at right now, 220EE, is for a concert date, December 31st of 2015 with those performers.
Yes, Your Honor. Thank you.
Did you want to ask him about another?
Yes, Your
picture?
Honor. When you go through these, or you've gone through this, Mrs. Sledge,
Yes.
are they performances, and the jurors will have that exhibit out with them. They'll be able to look at it. Are those performances all over the United States?
Yes.
I'd like to, did your lawyer show you any potential exhibits yesterday or today?
He showed it to me today.
Then I shouldn't have said yes. I apologize. All right. I'm going to approach with a screenshot. If you need to see the actual potential exhibit, just say, I don't recognize the screenshot, okay?
Yes.
Your Honor, I'm showing Mr. Williams number 46, 47, 49.
Right.
These are videos, but I was doing it this way, but if needed, Your Honor, Mr. Kokomo.
All right.
May I approach
You may.
May I approach you, sir?
Yes.
Please take a look at Mr. Williams 49, 47, and 46. And if you need to see the actual item, there's no problem with the court's permission.
It's only with 3.
One more time.
It's only with 3.
Yes, sir.
Yes.
Have you, do you know what their screenshots from? Did you go over that with your lawyer?
I knew they was just professional people.
Okay, and have you seen those items before this week? Do you recognize those images from before this week?
Yeah, I probably seen them on, I think I seen all of them on the internet.
Okay, and when you say the internet, just be clear, that's
Instagram.
before, okay, that's fine, but before this week, is that fair to say?
Yes,
Before yesterday?
before, yes.
Or today, okay. And I know you're not seeing the exact video. Do you need to see those videos? Or are you comfortable, confident, how about that, that you've seen these items before?
Yes, I have seen them before.
All right, Your Honor, I move for the admission marked Jeffrey Williams 46, 47, 49.
Your Honor, with the court, I apologize. Would the court permit an inquiry into foundation? Because I heard the witness say, I think I've seen them. And then when Mr. Steele said, are you confident that you've seen them? He then said, because at first he said, I think I've seen them somewhere on the internet, Instagram. And then Mr. Steele said, are you confident? He said, yeah, I've seen them. So I would ask permission to inquire where it is or in what to further inquire as to his foundation.
No, because
basis for
he's now
knowledge.
said he's confident he's seen them.
Yes, Your Honor, thank you.
They're admitted.
Mr. Sledge, now, there may be something on the screen, sounds like, that's not anyone's doing. So this may not be the best way to play it, but we're going to try, okay?
Yes.
Your Honor, can Mr. Kokomo, well, before he publishes, I know the first one is Jeffrey Williams 46. Let me ask you a couple of questions, Mr. Sledge.
Yes.
Do you remember the prosecutor asked you a lot of questions, or a number of questions, whatever they were, about if you know and if you've done the finger to the nose? You remember that?
Yes.
And she asked you to do it for the jurors, finger to the nose, right?
Yes.
Do you know who started? Do you personally know who started a finger across the nose, if anyone?
No.
God bless you. Is there anything about an individual taking their finger, like I'm doing, and going across my nose, that means that the person is committing crime?
Objection, Your Honor. Objection calls for
A conclusion, a legal conclusion, and objection as to outside the province of this particular witness. It's an improper question to ask whether it suggests that they are committing a crime.
Okay, sustained.
With the court's permission, Mr. Kokomo, would you play Jeffrey Williams exhibit number 46? take a look at it, Mr. Sledge. I'll have a question for you. If it's not going to work because the item over the screen, we'll just do it another time, okay?
Is that
Yes.
box that says something about a hard reset? Just click close.
We don't have access to click close on our computers.
Well, I don't- Okay. Maybe. So what, it's on this screen up here?
It's on all the other screens.
Okay, I mean, because IT. Okay, yeah, I guess it's just somebody, if you don't mind rolling the screen over where the jury and the witness can see it. Hmm?
If you turn that screen that way.
I mean.
There is a camera at the top.
Right.
Oh, okay, stop, don't do that.
Well, you can
Just,
close the camera.
I mean, I don't know the answer to, if y'all are screen sharing from your laptops.
It's on the.
Oh, okay, believe me, I do not know the solution to the IT issue. I don't know. Can you see enough of it around it? How big is it?
Your Honor,
How about-
Your Honor, what if we cover the,
That's fine. I mean,
And the
can you
jurors are seeing.
just come around the back, Mr. Short? It looks like it just kind of sits on top. Just take it off.
Okay.
And stick it on the back there somewhere where all it's gonna see is the back.
No back.
It rolls, right?
So you can't turn it.
Yeah, right here.
what if I just close the windows?
We'll try.
I mean, I can,
There we go. There you go. Look at you.
so that was, yes, okay, good job. So it was that one that was, okay. Thank you. Yeah. Embarrassment, a broken toe, who knows what else. All right, you may take the IT crown away from Miss Percifield since she's not here this week. We can worry about that later. All right, we now have the ability to see on a screen that is not covered by some strange IT notification.
Mr. Sledge. Did you note the two basketball players in that screenshot?
Yes.
And
I'm eating my salad. I'm
you
right
know
here,
them to
though.
Be professional players.
Yes.
And were they doing something similar to what you were asked to show the jurors?
Yes.
I'd like to show you Mr. Williams, number 47. Do you know who that person is?
Rod Wade.
Can you tell the jurors, please, into the microphone?
Rod Wade.
And who is Mr. Wave?
He's a rapper, an entertainer.
And that's WAVE. at the beginning, did you notice that young lady behind Mr. Wave?
No.
Okay. Look at the young lady right behind her, right there.
Oh, yeah, I see it right there now.
And is that similar to what you showed the jurors?
Yes.
And then 49, Mr. Williams, 49? Do you remember discussing with the jurors that you've seen Nickelodeon slime? Do you remember that?
Yes.
Okay. This is going to be Jeffrey Williams, number 49. And do you recognize that person as a professional football player?
Yes.
You know who that person is?
I don't forget his name, but
Okay. And was it similar to the wiping of the nose that you were asked a lot of questions about or some questions about earlier?
yes,
And did you hear him say slime?
yes.
Tell the jurors why is slime significant to YSL?
Could you?
Is it evil?
No,
And the wiping of the nose, is that evil?
no.
I'd like to talk with you about a posting that you were shown, and I forget the state's exhibit number. Give me 1 second. Remember the exhibit that you all played for Mr. Sledge saying why he became the number? You played for me? No, I'll use yours. Your Honor, it's already in evidence. Can I discuss with Mr. Sledge number 435?
Sure.
And that's state's exhibit, Your Honor.
Yes. 435Y, right?
Yes,
Yes.
that's what I'm being told. Could you? Thank you. Do you remember this, Mr. Sledge, being played this? I'm going to ask the court to allow it to be played one more time by Ms. Knight, and then I'd like to ask you some questions, okay?
Yes. Lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
Now, Mr. Sledge, you told the district attorney when questioning that this is not a new statement. Do you remember something like that?
Yes.
And had you heard this before from growing up, from where?
Growing up, I have heard it before though.
Okay. Have you seen it and listened to it or read it on the internet?
I think I have seen it on the internet.
And you related this and you made this statement which is now memorialized as State's Exhibit 435Y. Do you remember what was going on at that moment?
No.
Okay. I'd like to show you what's already in evidence. And it's the State's Exhibit number. Do you have Jeffrey Williams making, what number is that? I'd like to show you 447Y. Your Honor, it's already in evidence.
All right.
May we publish it?
You may.
Thank you.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters didn't get ready in the courtroom and tell God and it's true.
Fuck, nigga.
Don't get it. Y'all nigga need to get fucking killed, bro.
You snitching bitches.
From me and YSL.
Were you able to hear that, Mr. Sledge?
Yes.
And was that, you were asked if that was your voice by the district attorney on direct examination. Do you remember that?
Yes.
And your response was something effective, it sounds like you.
Yes.
Do you remember the date that was made?
No, I don't remember the date.
I'd like to ask you if you remember the other persons who are speaking in that video, okay?
Yes.
And was it Jeffrey Williams speaking?
Yes.
All right. And was he the one seen on the video?
Yes.
And was it Martinez Arnold speaking?
Yes, that's what it sounds like.
All right. And was the other person Mr. McMillan?
Yes, that's
Mr. McMillan.
yes.
All right. Now, I'd like to ask you if you can hear and listen to the very beginning of State's Exhibit number 437Y. Yes. Excuse me, 447Y. I'd like to ask you if you can hear at the very beginning, does it say, I'm a swear to God, it's the truth. I'm gonna tell a lie on God. I want you to listen, okay? If it says that.
Okay.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters.
Did you hear the beginning of that?
Yes.
Okay. And if you want headphones, the judge may allow that. The Honorable Judge Whitaker may allow that. But were you able to hear the person speaking?
Yes.
That beginning part? And did they say, I'm gonna swear to God, it's the truth. I'm gonna tell a lie on God?
Yes.
Who said that?
Hang on. Never mind. Yes, no.
Who said that?
I think that was, it sounded like my voice, but yes.
So at the beginning of this video, audio, is it fair to say that you're talking about going to swear to God, to tell the truth, and then tell a lie on God?
Yes.
Was this video something about people who lie,
Yes.
even though they're under oath?
They don't have to be on the oath to tell a lie.
Now, the next part that I'd ask Ms. Knight, the Honorable Ms. Knight, to play should be Jeffrey speaking. And it's similar to what you said in the video we just saw. Okay. There's Jeffrey saying, listen to this, okay? So, and I'm just saying, and lie to their mama, lie to their kids. lie to their brothers and sisters, and get right in the courtroom to tell the God's honest truth. If you can just listen to that and tell me if that's what you hear Jeffrey say, okay?
Yes.
One more time. You can start beginning, I mean, it's so short, but can you stop it when that part's ends? Jeffrey, yeah. Thank you. You listen for my cue? Okay.
So nigga, a lot of their mama, a lot of their kids, a lot of their brothers and sisters, they didn't get ready in the courtroom and tell the God honest truth. Fuck, nigga.
Was that Jeffrey speaking?
Yes.
And is that similar to what you said on the other exhibit, which is escaping me, the exhibit number? 435Y, State's Exhibit. Is that
Yes.
similar?
Yes.
And are those words that you said are similar words that you've heard before?
Yes.
Did you hear those words before Jeffrey said those words?
Yes.
And then on the next part of it, I'm not going to say it, but it's FN. Ain't going back and forth with you, bro. And then Jeffrey saying, or then another person saying, tell nothing but the truth, so help you God. If you can listen to that, okay?
Yes.
And tell the jurors who's saying that.
Yes.
Don't get it. Y'all niggas get fucking killed, bro.
You snitching bitches.
It's true.
Fuck.
Thank you.
God honest truth.
Fuck, nigga.
Don't get it. Y'all niggas get fucking killed, bro.
You snitching bitches.
From me and YSL.
Okay. Did you hear that? Tell,
Yeah.
tell nothing but the truth, so help you God.
Yes.
Is it accurate to say that in the criminal justice system, from your upbringing and your observation, people come in and lie under oath?
Objection, Your Honor. That's called for speculation about other.
He says from your observation. Of course, I don't know how he can know that.
You can know it
So.
from personal experience.
For speculation until there's a foundation established for his ability to answer that. A basis for knowledge, just speculation about other people lying.
You can try to lay a foundation.
When you said this, when you were part of this, and when I say this, I'm talking about states 447Y, what's up there right now.
Yes.
Tell the jurors what you were talking about.
Talking about people lying.
Okay. Now, I want to show you, Your Honor, may I have one moment?
You may.
Your Honor, can Mr. Kokomo show the prosecutor? This will be Mr. Williams. Thank you. Exhibit number 255.
Okay.
I'm looking at 62 pages. Are we talking about 62 pages? That's what this is.
I'll shorten it, but I just did the dates from the,
That's the same 255 that we looked at before.
no, we cut
No,
out.
it's a different,
Yeah, we stopped in July 2015.
okay, and,
Starts, I think, December or November 2012.
okay. And you were just gonna pick a couple of
Yes,
pages.
I'm not going to go through 6.
Can we, is it possible to have them just specify which two so I can look at those? Or do I need to look at
I was
62
going to
and
show it to
guess?
Mr. Sledge first, Salvis, and then we could do that.
Do you know which ones you're gonna use?
No, because Mr. Sledge has to identify.
Okay. I mean, you know generally what,
Yeah. I'll use the one from November 2012, I believe, and I'll look at it, but there'll be 2 or 3. That'll be it.
I mean, this is the same thing we looked at over lunch.
It appears to be all 62 pages.
Yeah,
So-
no, I know.
Well, it's
I-
not,
I'm-
it's not accurate. It took out after July 15th.
Okay, well.
That's what, but I didn't want to cut it short for the Mr. Sledge to look at, but then I was going to just, once he identifies a few, I was going to stop.
So
Okay, so. Can you come up here for a minute?
It's like every 10 minutes, we got to go and do a bench argument. I don't get it. I mean, this week to me was a waste of a week. Well, on the bench break, guys, I haven't got any members in a while. Let's get some memberships going. Like I said, I'm doing a whole content weekend this weekend. So let me get some members. I just dropped the link. Everybody subscribe, like the live, become a member.
Like anybody else.
Y'all just wipe my nose again, y'all. It's about to be over with for me. Told y'all I don't feel good. Like the live, subscribe. join the members, member. Dang, I can't get no new members. Oh my God. Okay, whatever. Back to Sledge.
Mr. Sledge,
Yes,
we are going to trim down some of those items for you,
yes,
for me. And we're going to get back to that, okay?
Yes.
I promise you I'll come back.
yes.
If the state can show again, Mr. Williams' number and of what number is it, Jeffrey Williams? 447Y. And if you can just look at it with me for a moment, if you don't mind. Now, do you see?
I thought about that, K Bear's
at the
mama.
bottom, if
But I'm not
you're
gonna do
going
y'all
to
like
clear
that.
thank you. You see at the bottom, it says repost, whiz that,
Yes,
and then it says, it's tagging at Thugger1. You see that?
yes.
Do you know what a repost is?
Someone else posted it and it was posted to somebody else posted.
So for an example, if I posted something a week ago and you liked it and you wanted to post it, what would happen?
I hit the repost app and it'll let me repost it on another date.
So the state was saying that this was done and shown and reposted on January 26, 2015.
Yeah.
Do you remember that in the indictment?
Hang on just a second.
Object as to the characterization of that question, the testimony.
Okay, yes, I mean, the state would have asked a question and established that through a witness.
It's in the indictment as well. And if you're not familiar, do you remember this being in the indictment?
Okay, well, that's just an assertion.
Exactly. So I want to show you, are you ready? What number is it? Actually, can you show it to the prosecution first? What number is this going to be? It's going to be Jeffrey Williams, number 256.
Thank you, girl.
Is this something new that's not in what you sent before?
True.
Okay,
I'm trimming down.
that's fine. Oh, I got you. Okay.
All right, can Mr. Kokomo approach Mr. Sledge?
Yes, you may.
Mr. Sledge, is that okay?
Yes,
Just take a look at this, telling me whether you can recognize it and you could hear it as well, just to make sure, but don't make it loud enough for the jurors yet.
So, Your Honor,
Mm-hmm.
prior to that being displayed, what we have not heard is the sound in that video, because this is the first time we've seen it. So
Right.
we'd ask that before anything be done with it, the state be allowed an opportunity to hear what is being said in that particular video, which is a little different.
don't know if it's different or not.
It is, I'm looking at it, it is not the same exact thing that we just
Okay.
put up.
Okay. Then I guess this will be where we break for the evening.
Your Honor, it's 11 seconds. I mean, if that matters.
Well, or we can see if Ms. Love can hear it without.
11 seconds. Let's see.
Do you want to step out into the hall? That would be easier than excusing all of them to the, all right. She'll be right back. We'll sit for just a sec and I'll let y'all go soon.
Go with your computer.
And Mr. Steele, estimate for me how long you think the rest of your cross is going to take.
30 minutes.
Do y'all want to stay for, who else has, if anybody has going to have cross for this witness? Anybody? Okay. Okay. Do y'all want to just, well, do y'all want to stay 30 more minutes? Although we'll have a redirect on Monday, but yes, I have some thumbs up for 30 minutes. Lots of nods for, okay.
The only issue I just want to make the court on the on the
It's always something.
on the 62
Yeah.
item, that's the only thing I have to go over, which is going to take a little more time. So I just want you to, I won't finish is my
All
point.
right, yeah. We'll get 30 more minutes and then we'll see where we are. Okay. All right. Then I guess he's already seen it.
Yes.
So go ahead and ask whatever you need to ask.
Mr. Sledge, have you seen what is now marked as Mr. Williams number 256? Have you seen that before?
Yes,
And is it accurate? And does it depict the way it was when it was first filmed or, filmed and audioed?
yes.
And Your
Any-
Honor, two things. I object on the basis of the vagueness of the question. Have you seen it before? I don't know if that means before he was shown by him.
Well, can you
Lawyer.
clarify that?
Were you present when that was made?
Yes, I was
Or
present.
is your voice on there?
Yes, my voice is on.
Is it the same as, and I always forget, 447?
Oh,
447Y that was shown to the jurors, the repost?
yes, my voice on there.
Okay.
Okay. So on 256, JW 256 is that what you were just asking the questions about he was present for? Okay. All right.
With
Are
that,
there-
I have no
okay.
objection if he's saying he was there.
All right. Go ahead.
Your Honor, with the court's permission, Mr. Kokomo will publish Mr. Williams number 256.
All right.
A lot of they kids, a lot of they brothers and sisters, then get ready in the courtroom and tell the God and his truth.
Fuck, nigga.
Don't get it.
Bro.
Y'all niggas need to get fucking killed, bro.
You snitching bitches.
From me and YSL.
Swear to God.
So nigga, a lot of they mama,
A
a lot of they kids, a lot of they brothers and sisters, then get ready in the courtroom and tell the God and his truth.
Fuck, nigga.
Don't get it.
Bro.
Y'all niggas need to get fucking killed, bro.
You snitching bitches.
From me and YSL.
Mr. Sledge, did you hear your voice?
Yes,
The voice of Mr. Jeffrey Williams and the face of Mr. Jeffrey Williams?
yes,
Did you hear the voice of Mr. McMiller?
yes,
Did you hear the voice of Mr. Martinez, also known as Duke?
yes,
Is it the same exact video that was played earlier as the repost?
yes.
And on Jeffrey Williams number 256, I'd like you to tell the jurors, it's small writing, if you could read it to them, what date at the bottom right was this made?
January 4th, 2015.
And on January 4th, 2015, what was Jeffrey Williams' relationship like with Donovan Thomas from your personal observation?
Objection vague.
Overruled.
They had a great relationship.
And does this video on January 4th, 2015 have anything to do, from your own personal knowledge from being in it, about Donovan Thomas or threatening some witness or anything?
No,
Objection, one is compound, so I don't know which part of that he's asking about. And then the second part, he is speaking to the intent of defendant Williams when he says, does it have anything to do with threatening
Okay,
Ask
well,
me
it's
personally.
his personal knowledge, and while Mr. Steele does ask long questions sometimes, he has a lot of clauses in there. I don't believe it was a compound question, just had a lot of descriptive clauses. So overruled.
So the indictment, and if you don't remember, we'll show it to you. No one's trying to keep anything from you. Says that this was done 16 days after the killing of Mr. Williams, that it was reposted. But this was made 6 days before, God forbid, the killing of Mr. Thomas, right?
Yes.
Now, if you can look at the very top right-hand side, you see where it says watch your post. You see that at the top?
Yes.
And then underneath it, it says watch your post, and then it says best said at MPA Duke, DUKE 1, the number 1, said it first, 3 exclamation points. You see that?
Yes.
Who, to your knowledge, is MPA Duke 1?
Mr. Arnold.
Martinez Arnold?
Yes.
And then it says video by at Thugger1 pound YouTube pound Young Thug pound Thugger1 pound Urban Post. You see all that?
Yes.
Okay. And when it says best said at MPA Duke 1 said it first, that's Mr. Arnold
Yes.
saying it first.
Yes.
Objection, Your Honor, as to that.
Yeah, sustained as to that.
All right. Now, I want to ask you other questions if I can. Before January 4th, 2015, were you familiar with this type of statement?
Yes.
Now, if a witness, when it says at the end, the prosecutor said, y'all should be killed. Let me make sure I got, hold on one second. Y'all should be killed, and that's from me and YSL. Do you remember that?
Yes.
If I didn't quote it perfectly, something to that effect?
Yes.
Okay. From being there and being a participant in this video, which is 256, Jeffrey Williams 256. What do you believe should happen to a witness who lies about someone in trial?
Objection, Judge.
Sustained.
Okay. All right. Let me ask you this. You were released from prison from the drive-by shooting. Remember, the jurors heard a lot about that, April 2015.
Yes.
And is it fair to say you were released in year 2019?
Yes.
And when you were released from prison, you needed a job, didn't you?
Yes.
Okay. You were financially depleted. You didn't have much money?
No.
All right. And is it fair to say that Jeffrey at that time was even more popular than he was in 2015?
Yes.
And did Jeffrey offer you a job?
Yes.
Was it conditional? Did you have to promise something?
No.
How about no more crime?
No.
Are you withdrawing that objection?
Did Jeffrey tell you you can't commit crimes?
That right there is hearsay.
Sustained.
When you were on tour with Jeffrey and from your personal observation, so I'm not asking you what other people said or anything, did you ever observe people who would steal from other people, from stores or anything like that, and Jeffrey would find out about it and repay those people?
Yeah.
Objection, Your Honor, relevance.
Sustained.
Well, I think it's relevant. You're the leader of a supposed
Your
organization.
Honor, I object on the basis of whatever the speaking objection is about to be.
I think it's relevant, more than relevant,
Your Honor,
to the conduct after this trial.
it's character. He's trying
That's
to
not-
get into character.
Sustained.
evidence.
All right. Do you remember seeing in the days before Donovan Thomas was killed, do you ever remember seeing, personally seeing Mr. Kenneth Copeland with an Infinity vehicle?
No,
When you drove Mr. Copeland to the police department on the early morning hours of January 11th, 2015, is that true?
yes,
And your significant other, the mother of your child was with you, as well as your youngest child at that time, right?
it was he ain't my youngest child, he my oldest son.
Apologize. Okay. And Mr. Copeland didn't have a car there, right? That's why you drove him? Am I correct?
He didn't have a car there.
Do you remember at all whether Mr. Copeland asked you to pick him up and drive him to Jeffrey Williams' house with you for safety?
I don't remember that.
Okay. Do you know how, as you sit here today, do you remember how Mr. Copeland, if you know, got to Jeffrey Williams' home on January 10th, 2015?
I don't know.
All right. Has Jeffrey ever paid for your lawyer fees?
No,
Has he ever paid for your bond?
no,
Your Honor? I believe except for the, I have to break down the 62, which I probably can't do in a short period of time. I don't have any other questions.
Okay, well, so is your plan to,
I'll try to do it, with the court's permission, I'll try to do it, Mr. Wright, and figure out if there's a quick way to get it through. I'm not going to speak with Mr. Slade. I don't mean any disrespect, but I'll go through his.
Your Honor, would the court permit outside of the jury's presence for the question to be placed upon the witness so that the court can hear?
sure, yeah,
fine with
that
me.
may be a better way to do it. Okay, all right, so we are going to break for the day and for the weekend, and I am going to remind all of you to not talk about the case with anybody. Don't let anybody talk about it with you. You are only supposed to decide this case based on the evidence admitted inside this courtroom, so don't conduct any research on your own. Don't try to find out anything on the internet or from old school sources or from other people, from social media. Don't do research about the law. Do not read, watch, listen to any accounts of this trial online, in print, television, otherwise, radio, social media, anything like that. And leave your notes in the jury room, and we will see you on Monday at 9. Y'all have a great weekend. You stay here with us for a minute.
Oh, okay.
We're gonna ask you some more questions.
Oh, okay. You better say something. I'm trying to go. They charged it for Monday. It need to be charged.
All right, good. Okay, go ahead and attempt.
Okay, Mr. Kokum, have those. Mr. Sledge.
Yes.
I'm going to ask the court, there's no jury here, but we're still in trial, okay?
Yes.
I'm going to ask with the court's permission to approach you and show you. And I'm just going to pick out a few and just tell me whether you have ever seen these postings online before this week, okay? Is that okay?
Yes.
And I'm going to target a couple, but it's going to take me a moment, but I think I could target a few.
Hey, Your Honor, if Mr. Steele would simply apprise the court and counsel for the state which ones he's targeting and approaching him with, so we could at least write it down.
I'm going to do that. Can Mr. Kokomo and I approach this for a minute, Your Honor?
Yes.
Mr. Sledge, can we come to you?
Yes.
So we have a small screen.
And just be real clear of exactly what you're asking him, not post like this.
We're gonna, Mr. Kokomo is gonna show you. Can you pull up the one that it's, it says it's December. Yeah. If you have not seen it, oh, I'm sorry, Ms. Moore. Okay.
And
If you have not seen this before, you'll just tell us, I haven't read it, I haven't seen it, okay?
Yeah.
If you have seen it and read it, just tell us, I have seen it and read it.
Your Honor, could Mr.
Yeah.
Steele place just on the record the one he just identified for Mr. Kokomo, but I
Yeah,
could
in
barely
some
hear.
way. Or just
Just say
spin
it.
around and show Miss
Yeah,
Love.
if I could
This
see it.
This is DMAC.
Just spin around and show Miss Love. It'll be easier than trying to. Some people's names or tags or whatever are kind of hard to read out.
Thank you.
If you have not seen this, just make it clear. If you have seen it, just make it clear. I'm just going to read it, okay?
Okay.
And it is, I'm just orienting myself. This is Mr. Williams' exhibit number
You can call it 255A.
255A. And it's down here, and it says, DMAC got me to banging at DMAC to banging. And you see the date?
Yes.
December 27, 2014.
Yes.
And this is me, I'm not reading it verbatim, okay? And AN lie to their mama, brother, sister, and kids, but get to the courtroom and tell the God's honest truth, question mark, question mark, question mark. I don't get it. Or ION get it, hyphen at Young Thug. You see that?
Yes.
If you can remember, if you can, it's fine, and just tell us, have you seen that before this week?
Have I seen it
That particular post.
this week?
No.
Oh, anytime.
This week.
I can't even remember exactly what day I seen it, but I don't seen this before.
You have seen it before.
Yes.
Have you seen it
Judge, is he
before?
talking about that?
This
Have you
specific
seen
post.
DMAC got to me too banging on
Yes.
December 27th? That post. You
Yes.
saw that
I
post?
saw this post
All right.
before.
Have you seen it before this week, just to make sure?
Yes, yes.
Okay. We're gonna have to mark that. Can you pull up the one that says, can't remember the exact term. And if you don't know it, I have my notes. I put Can I step back just 1 second? Yeah, no.
Mhm. Yeah. This seems to be a convenient time. I don't know, is this like a schedule? Anybody from the defense team, please? Well, actually, we don't have a jury present. Do you care about this? Okay, so.
Do you want Mr. Sledge in here?
I don't think that matters. Mr. Wright has brought it to my attention that he's now under subpoena, a state subpoena. However, he is serving as Mr. Sledge's lawyer, and he's obviously been sitting in here. And
Told y'all. I told you. I told you. I told y'all.
Remainder of Mr. Sledge's testimony, since he's serving as his lawyer, is the state gonna have any problem with
I
that?
told
Not at all.
y'all.
And then y'all aren't gonna make any kind of, okay, all right, that's fine. Just wanted to clarify that. Okay. And is this like a cautionary potential subpoena, or is he gonna, I mean, are you gonna let him know when you expect him to? He's got other business, obviously, after he finishes as his attorney role. Will you let him know when he needs to be back?
Yes,
Okay.
yes.
All right, that's the only reason I'm asking. Okay. All right, are y'all ready with your next one?
We'll just do the one then, Your Honor.
Okay. Well,
We're
great.
gonna call
then.
it 225.
I should get super
Okay.
chats for
And
that.
it'll just be that
No,
one.
I said
Like
wrong.
y'all need a super chat.
255.
Even.
Just 255.
We'll call it 25 with the court's permission, and then we'll just start with that on whatever you tell us.
All right, and it'll just be that one, and then
And we'll
you
we'll
suspect
rearrange
you'll
it.
be pretty much done at that point.
I actually turned the page. I have more, but yes, it's not much.
I mean,
It'll be
that's
15 minutes,
Okay.
20 minutes.
All right,
But I'm gonna start with that, and we'll make it just one, like exhibit,
Okay.
one thing. So we'll crop it.
that works.
So the only, tweak now that is that 255A consists of is DMAC two-rated.
There's no A though. There's no.
Yeah,
A.
it's not, it's just gonna be 255. But yes, is
And-
that right?
And it's December 27, 2014.
All right, thank you.
That's the one we'll use.
Okay,
I just have one thing to note for the record,
okay. Are we finished with Mr. Sledge for the day?
except Mr. Wright. I'd like to stay just for a minute.
Okay, so are we finished with Mr. Sledge?
I'm finished with him. He could stay out on whatever the court wants, but yes, I'm not asking him
Okay.
any questions.
You may step out and we'll see you at 9 on Monday.
Okay, thank you.
And I'm sure Mr. Wright will be out in a minute if you want to wait for him.
So it's not my desire to say that, a prosecutor or any lawyer or anybody told someone, don't say something in front of the jury. But, I cleared that with Mr. Wright. And I want the court to note that the state never put us on notice. It's not Brady because with due diligence, I found out about it. So I'm not saying it's a violation of Brady, but it's just not the way, if believed, it's not the way that I was understand that lawyers conduct themselves. So I'm sure that I wasn't there. I'm sure that Ms. Love will say whatever she says, or maybe say that didn't happen, but I just
Or
wanted to
maybe it didn't happen in quite that way, but
I
I
just want to
don't know if Ms. Love wants to say anything.
I
or
just
not.
want you to know that I cleared it with Mr. Wright beforehand. And he was on the actual Zoom. So I just want you to know that I didn't speak with Mr. Sledge without Mr. Wright. So,
Okay.
thank you.
Just a small follow-up. And of course, Mr. Wright will have the ability to say what Mr. Wright recalls, but I believe that Mr. Wright informed Mr. Steele before Mr. Steele asked that question that he has no recollection of that ever being stated by me to Mr. Sledge. But I'll let Mr. Wright speak for Mr. Wright. And I inquired, I know that I would not say that. So whatever Mr. Sledge said, Mr. Sledge said. I don't know how the question was posed. I don't, that's all right. It'll happen on redirect. We can flesh it out. But this notion about, I mean, all of that, Mr. Steele can ask whatever questions he wants to ask, and Mr. Sledge can answer however he feels.
You're late.
he
I
needs
told
to.
everyone
I'll
about
handle that on
an
redirect.
hour and a half ago.
Yes, sir.
I'm gonna go ahead and speak. I have indicated to both sides as I'm trying to stay calling this balls and strikes and
Right.
stay neutral, but my client has repeated to me that that's how he heard it. I indicated to both sides that I heard her indicate that she was not going to be asking him, as in she clearly didn't like the subject matter, but I did not hear her affirmatively try to tell him not to disclose or say or secret it. So it's a slightly different interpretation of the non-lawyer and lawyer.
Sure.
And I think everyone knows I'm the fence through and through. I would have no problem being able to say that, oh, that's exactly what she said. But I will not simply say.
The transcript will tell us.
Of course not. I would never expect, of course, our sounds out again, but
It was at least a hot topic that it wasn't something that I thought the state was going to go into, but I can't say I have a memory of her saying the specific instruction to Sledge that he remembers. But my client does, that's how he recalls it. So my client's not being untruthful in terms of.
well, we're not gonna get into whether you think he's truthful or not, because that wouldn't be appropriate. But you can say whatever you need to say when asked. And I appreciate you letting the court know and letting both sides know what it is that your recollection is.
Yes, Your Honor.
All right. So do you think that Mr. Wright will be shortly on the heels of Mr. Sledge?
Right on the heel.
All right. So you should just plan to stick around then, and then hopefully we'll be able to release you after that.
I will not do this right now.
Okay.
Hopefully I'm here for you.
All right. Anything else? Sounds out again. Maybe it's back. Is it back? Allegedly, y'all, they are coming early on Monday morning to replace either the entirety or something in this box. I think they've already tried several things. This is some new thing. We'll see, but
If I buy anything, will they reimburse me?
what you mean?
If I buy some.
Who is we?
I
Court
said
administration?
yeah, they, the people that are responsible for this, will they reimburse me if I buy some?
Miss Love, I cannot guarantee anything like that. I am still trying to get reimbursed for stuff from like 2 years ago. So, I mean, I wouldn't hold your breath. I wouldn't do that. If you plan to buy something, it'll just be for the good of this trial. It won't be, no.
Your
All
Honor,
right.
you
Yes.
allowed me to continue, so I don't have to ask the jurors to leave, but I made a motion,
Oh, yes, yes.
and Mr.
Thank you
Matthews
for
reminded
reminding me of that.
and what happened was, and please check the record, but what I remember happening was Ms. Love makes a speaking objection, comments, puts her own testimony before the jury and states that the testimony, that there's no evidence and it's already been proven. And I know that there's a strained relationship between Jeffrey Williams and Rich Homie Quan. That is wrong. Rich Homie Quan has given interviews shortly after January 10th, 2015, all the way up to 2024, consistently how close he and Jeffrey Williams are. The prosecution said that Rich Homie Quan, his real name is Mr. Lamar, that he was coming to court and he would be testifying. And the prosecution did not call him. He was on a short list. He was under subpoena. They did not call him. I have a good faith belief. They didn't call him because, what? I'm sorry?
Yeah, you need to.
I have a good faith belief that the state did not call him because he gave exculpatory information about his relationship with Jeffrey Williams. So for the prosecutor to then say in front of the jury, and please check the record to make sure that what I'm saying is what was said by Ms. Love, but I immediately would have made this motion if you did not allow me to preserve it. And a lawyer can't tell the testimony. This is what happened. Brian Steele knows this. That is untruthful. In fact, I know the opposite.
Uh-huh. All right. So my recollection is that Miss Love said that the evidence shows that after a certain date, one of the people in this picture no longer hung around Mr. Williams.
Okay, good.
That's a closer.
That is not true.
Account.
What the state was trying, their crazy theory, in my opinion, is that in the fall of 2014, Mr. Williams somehow cared about Rich Homie Quan signing with a third party. His name is Mr. Brian Williams, which is Birdman.
Right.
And somehow that because Donovan Thomas said, no, Mr. Rich Homie Quan, don't sign with Birdman, that Jeffrey Williams has now a motivation to kill Donovan Thomas. None of that comes out. And it's untruthful. As you saw, they are playing together, they being Jeffrey Williams and Rich Homie Quan, on New Year's of
Well, you know what?
2014.
There are plenty of band members who play together and hate each other. So them playing together doesn't establish anything. But yeah, that's all. Yeah. So Miss Love, you maintain that it is in evidence. So can you
That there was.
what part of the evidence and who said it?
Yes, and I would ask if the court has in front of it my exact words, or if there's a way
I
to
don't
grab.
have
Okay.
your exact words in front of me, but I'm sure we can get them by Monday.
Okay.
But it was
So what I was referring to was the testimony that has been given that after a certain date, at least one witness, there may have been two, testified that the relationship between one person in that photograph and defendant Williams changed. I can definitely say that I can definitely say that apart from that testimony that the jury has already heard, personally, I definitely have a great faith basis for saying it, but that is not what I said. I said what I was referring to the second part of what was asserted by counsel.
Do you know which witness or witnesses it would have been? Because I think Miss Weaver's probably transcribed a good bit of this, and she's pretty fast. I'm happy to ask her to.
I believe it would have been Mr. Thomas Sr., who was asked about the relationship between one of the people in the photograph or having seen them after a certain time, or that it was strained. That's why I'm asking. And then I'm not certain whether Detective Dennis talked about it. That I'd have to look back.
Okay. Why don't you look back? I mean, did Mr. Thomas Sr. testify for any real length of time? I mean,
He
would
was
that
there for
be
a
easy?
day.
Okay, that'd be easy enough for Miss Weaver to put together. I'd imagine Mr.
And-
Dennis testified for longer.
Yes,
All
but
right. Maybe you could look at your notes on that and maybe pinpoint that more directly, and then I could ask Miss Weaver, with
I
some
will.
parameters, maybe.
And I'll also just check with the team, because it's not been a topic that has been discussed. So we've discussed those things anyway, and I can clarify, because it was I think that was Miss Hilton's witness, so she'd probably have a better memory than me. But the reason that I asked exactly what I said is because I think I chose my words carefully before I said them.
Okay.
And I want to make certain of exactly what I said, and I want to point back to exactly what I was referring to.
Okay. And Miss Winfrey over the weekend will be kind enough to find us that little portion of Miss Love's statement that resulted in Mr. Steele having a motion and saying, can I just bring it up later, and me saying yes. And then we'll take all that up first thing on Monday.
Okay.
Thank you.
And
Okay.
the point is, a lawyer, I do remember the father attempting to say things like that, but he couldn't explain later photographs, whatever, that goes to weight.
What?
But the issue is, a lawyer to tell a jury what the evidence is testifying. It's inappropriate.
Your Honor, what I think was inappropriate was attempting to mislead the jury by asserting that a photograph that Mr. Steele was aware was taken, or at least that particular concert or whatever, that was not a December 2015 concert, as he stated to Mr. Sledge, and Mr. Sledge said yes. Even after Mr. Steele put up the next flyer or whatever it was, and led Mr. Sledge by saying, this happened December 2014,
That
New
was
Year's
actually
Eve 2015.
that was 2015.
That was it was going into 2015. The second one
So that was 2014.
yes. The
Okay.
first one was 2014.
All of those.
And so when Mr. Steele said, the reason that I said that I objected the way I did is that Mr. Steele said that posting that was defense exhibit
So when people say New Year's Eve 2015, they actually mean December 31st, 2014.
yes, ma'am. Yes, Your Honor.
Yes.
That's what they meant.
So, Your Honor.
But
and
Your
what
Honor, may I
happened-
finish
excuse me
before
just one
he's
second.
allowed? May I finish
This-
before Mr. Steele is
Okay, hang
allowed?
on. Yeah, let's see what Ms. Love was saying. Go ahead.
So at the time that Mr. Steele put up the flyer and suggested before this jury that flyer was for an event in December 2015,
Yeah.
that I objected because, and what I didn't say, what I wanted to say, which was he knows full well that wasn't December 2015, but I said that there has been evidence of something different.
Okay. Well, that probably wasn't the best way to handle it.
And if I'm not saying I did, but I may have misspoke. If I misspoke on a date, I wasn't doing deliberately. And the objection is that shouldn't be 2015. Are you sure, Mr. Steele? Or Your Honor, I don't think that's 2015. And the
I don't think that
evidence
that's a-
shows,
Don't
excuse me.
interrupt. Don't interrupt.
And the evidence shows that there was no relationship. They weren't speaking. That's what I'm complaining about.
Yeah, she said the evidence shows. Okay, I mean, that may
I
not
wanna
have
know
been
what
the
I said.
absolute best way to handle it. And I do wish that both of y'all, I mean, y'all clearly get under each other's skin and try to divorce from the case the fact that each of you is the attorney handling certain evidence or certain witness, because honestly, both of you probably would do your tasks for your clients better if you could focus a little less on the fact that y'all get on each other's nerves, okay? I mean, you do not have to, it does not have to be like a gladiator fight every time anybody says anything when it's the two of you. It doesn't come off well for anybody, honestly. So that's just my 2 cents worth.
Thank you, Your
I'd
Honor.
also like to say that
I
every
appreciate it, Your
evidentiary objection does not need to be made, even if it's a valid one. So think about that too.
Yes,
All
Your
right.
Honor.
Anything else?
Your Honor, just that I'll just await Miss Winfrey's
Okay.
snippet.
Okay. All right. I hate to do this, y'all. I can't stand getting up really early in the morning either, but I think we have enough things to do before the jury joins us that we're going to need to do 8:30 on Monday. And maybe I should just tell the jury from now on 9:30 on Monday, but I haven't. I told them 9. So we're going to see each other at 8:30. Okay.
Yes, Your Honor.
All right. All right. Everybody have a good weekend.
Mr.
God. Oh, God. Well, happy Friday, guys. I just, how many people? Oh, how many people were on earlier when I said, I know who got subpoenaed? How many people were on? And who is that? I told y'all. See, I didn't want to say anything because I never know who's watching and I never know who knows what. So I was a little nervous about saying who it was. But I'm literally talking to him and he told me, and I'm like, huh? So I don't have all the details, but hopefully I will get more information. But I am so I'm gonna have to clip that up because I definitely had the tea today. Thank you, Miss D. Y'all, we made it. This was a long day. This was a long day. I want to know what they could possibly have to ask. It's like every attorney that gets involved in this, it's just unbelievable. The state has subpoenaed the lawyer to testify. He's now a witness. So pretty much, if you are a lawyer and you touch this case any kind of way, You will become a witness. I became a witness with Woody. Melnick became a witness with Woody. Derek Wright is a witness now with Sledge. Jacoby Hudson is a witness with DK. Like, whoa. It means that they will be called to testify. So y'all, I don't think I'm going back in the courtroom. I have to go on live with Nick. If you guys want to come over, feel free to join us. I'm going to drop the link. Let's see. Let's see. Okay, here we go. Everybody head over to Nick's. We are going, we have so much to talk about. Head over to Nick. Head over to Nick. Come on, I'm dropping the link. Everybody head over. I'm about to head over. Thank you for staying on with me all day. Oh, we had a good. You guys got me cracking up. Everybody, we are going over to Nick. Click the link. I'll be back on Monday. I don't have court again on Monday. I have court on Tuesday, but I'll be back again on Monday. On time. Y'all, green hearts for me. I was on time today. Green hearts for me. Go to Nick. Go to Nick. Tell him I sent you. Go to Nick. Tell him I sent you. Everybody head over. Everybody. Love y'all. Thank y'all. Thank you. Head over to Nick. Head over to Nick. See y'all over there.